One matter for admission, my lord, for enhancement of compensation.
Compensation.
Amount, amusement.
We don't have that roster.
Sorry.
No. Today at 11 o'clock we have to observe 2 minutes silence.
Please.
ತಗೊಂಡು ಕಳಿಸ್ಕೊಡಿ.
Criminal appeal connected matters are listed tomorrow.
ಆಯ್ತು.
Subject to complaints.
ತಗೊಂಡು ಕಳಿಸ್ಕೊಡಿ.
Adjournments, page wise.
11 o'clock we have to observe.
Serial number 5, my lords.
Page 1, serial number 1 to 3. Page 2.
Appellant, my lords. Serial number 2, I seek short accommodation.
Serial number 2.
2, my lords. I'm appearing for the appellant.
Office note. What is that office note? We'll see.
I'll do the needful, my lords. 1 week's time may be there.
No, we do not know. We'll see and adjourn it. All right, definitely.
Obliged.
Page 2, serial number 4 to 9.
My lords, serial number 5, my lords. A week time may be granted, my lords.
Why?
Lord, senior is suffering from throat infection, my lords.
Adjourned at the request of the appellant's counsel.
Page 4, serial number 10 to 16. Page 3, serial number 10 to 16.
My lord, serial number 18, my lords.
Serial number
18, my lords.
15. Huh?
18, my lords. 1-8.
Page
Yes,
4,
page-
serial number 17 to
page
20.
18.
Please, my lords.
18 adjourned at the request of appellant's counsel. Yes.
Page 5, serial
Please.
number 21. Page 6, serial number 22 and 23. Page 7, serial number 24. Page 8, serial number 25 to 29.
Serial number 26, lords. 26.1.
26.
Senior mother is admitted hospital.
As requested by counsel for the respondent, list on because 2017 matter you have.
Next
to
week, any rate. Next week, I'll have.
30th. 36. Page 9, serial number 30 to 34.
Serial number 30, my lords.
Hmm.
Want to file second set, my lord, in that.
In the second matter, you have to file the second set.
Please, my lord, that is from High Court Legal Service Committee, my lords.
2017, you are appointed by the office.
So, legal services, my lord, it has been up.
No. Shri Javed as Learned Counsel submits that this matter is, but appeal memo only, other things are common.
Please, my lords.
He is appointed by HCLC. It is there. Can you submit the second set? Only judgment and this thing. No other things. Paper books are ready in the connected matter. What are the grounds of this accused? Official permission the second set.
Next week.
We shall prepare the second set and place it. All right.
Next week, obligations.
List on.
17.
Once.
Oblige, my lords.
Page 10, serial number 35. Fraudus, serial number 1. P. Mahesha. SPP, BV Nidhishri.
Carry out the amendment right away, my lords.
Appearing for the respondent number 2 in this matter.
For application for suspension of sentence is pending since 2023.
Please, my lords.
We'll pass it or do it during the course of the day.
Let's, it's with respect to impleading the respondent.
Correct, you do that amendment. Yes.
Passed over. Serial number 2. Mayur D. Bhanu, SPP.
Appearing for the appellant, my lords.
What is that office note? We'll see. Accused Selvaraj has filed criminal appeal number 244. Accused Arun Kumar has filed 205. Oh, there are other connected appeals.
Kindly, my lords.
He is expected for 3. There are 2 other accused. No, there are many other accused, not only 2 others.
There are totally 7 accused in this case, my lords.
This matter is connected to criminal appeal number 244 of 2025 and 1256 of 2021. List all the counsel for the appellant seeks adjournment. List all the aforesaid matters together on 2025 and 18.
37.
Obliged.
Hearing on IA, cell number 3, Rattihalli Geeta, SPP.
Respond number.
Madam was
So there
pressing.
are 4 accused in this case, please, my lord. A1 is dead, A3 and A4 have been acquitted. I'm appearing for A2, please, my lord. He's been convicted, lord, from the paper book, page number 35.
It may be passed over, my lords. Pass over, my lords.
Passed. One problem is here now, the new problem, Kannada deportations are there. You are relying on that?
My lord, it's a very simple question of law, my lord.
Why you want passer?
Lords, file was, they're searching for file. It may be taken up at 2:30 minutes. I'll go through and I'll make.
205.
Henceforth, wherever there are Kannada deportation, final hearing, now I told the sister that I'll translate wherever, I mean, relevant portions so far as the suspensions. But the main matter, deportations, translations are required.
Required, my lords.
Passed over. Cell number 4, GS Balgangadhar, SPP.
I have been informed by my clients that they are giving some medical facility to my client. My lord, I will ascertain his status. On the earlier occasion, learned
Yes,
SP.
They have submitted the same.
ಹೌದು ಇಲ್ಲ
Last time, court was not provided. In fact, that has also been.
ಪ್ರೊವೈಡ್ ಮಾಡಿದ್ದಾರೆ. ನಾನು ಸ್ವಲ್ಪ ವಿಚಾರಿಸ್ಬಿಟ್ಟು ನಾನು ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. ಹೇಗಿದೆ ಸಿಚುಯೇಷನ್ ಅಂತ ತಾವು ನೆಕ್ಸ್ಟ್ ಮಂತ್ ತಗೋ.
The counsel for the appellant submits that
Bangalore shift again.
he verifies if the jail authorities have implemented the order dated 24/4/2025 and submits as requested by him.
Please, ma'am.
But we have to keep reading the files again and again.
ಇಲ್ಲ ಇಲ್ಲ ಬೇಡ ಸ್ವಾಮಿ. ಇಲ್ಲ ಇದು ಒಂದು ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಆಗ್ಬೋದು.
Speak, ಕೊಡಿ. ಅಷ್ಟು ಹೇಳೋದಕ್ಕೆ ಯಾಕೆ?
ಇಲ್ಲ ಅದು ಅಕಸ್ಮಾತ್ ಸರಿ ಹೋದ್ರೆ ನಾನು ಫೈನಲ್ ಇರಂಗೆ ಫಿಕ್ಸ್ ಮಾಡ್ಕೋಬಹುದು ಅದಕ್ಕೆ.
Correct. See, he can even do it over phone also.
ಇಲ್ಲ ಮೈಲಾಡ್ ಅಲ್ಲಿ
What is given to him? Where is the big issue in that?
ನನ್ ಪ್ರಾರ್ಥನೆ ಏನಂದ್ರೆ ಶಿವಮೊಗ್ಗ ಜೈಲಿಂದ ಇಲ್ಲಿಗೆ ಶಿಫ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದೆ.
To speak in some other language. When
ಸಾರಿ ಮೈಲಾಡ್ ಮೈ ಅಪಾಲಜೀಸ್.
Speak in Telugu.
Sorry, my lord. My lord, what has happened, my lord? He was in Shivamogga jail, my lord. Now I have been informed he has been shifted to here. Because of vacations, I could not contact them. I will get some.
How much? We are granting you 1 week time.
2 weeks.
So far as this application, no, we can't keep the application
Alla,
pending.
my lord, week after next.
Claim is against us only.
No, my lord.
Causing of suspension.
My lord,
We will see the order sheet.
my lord, what has happened? These comments will be there.
And
If justice is delayed, they said denied. Hurried is means buried. These comments we will be hearing. Not, my lord, myself.
To ascertain
Yes.
whether he is
My
provided
lord,
with a court
may I
or
request
not.
for 2 week after next, my lord. Week after
10
next.
days ಆದ್ಮೇಲೆ ಒಂದ್ date ಹೇಳಿ. ಬಾಲಕೃಷ್ಣ ಅವ್ರು ಹಾಗೆ ಹೇಳಿ.
37.
ಹಾಗಾದ್ರೆ ಅವ್ರು ಹೇಳ್ತಾರೆ.
ಆಗ್ಬೋದು.
37.
Please. Sorry, my lord, I did not submit in English.
Cell number 5 adjourned.
Henceforth you have to be little.
Please, ma'am.
Cell number 5 adjourned. Cell number 6, Balasubramania BN, SPP. It is a sweet language.
I follow to some extent.
Balasubramanya. What is this offense? No representation for the.
498,
If they do not turn up, we go on appointing, this is which year? 2024.
delay may have been.
Delay will condone, but see, they file the suspension of sentence application, they don't turn up. He is in custody, will condone the delay, but see, it's a caveat to the bar. If you do not appear, we'll appoint amicus curiae, wherever the accused are in custody. 74 days delays, they will condone. No
I may-
representation for the.
I will take notice, my lord, so delay may be condoned.
No,
1 week time may be
notice was
granted.
not taken. Your
No,
name
madam.
is wrong. Is it coming for the first time? No.
My lords, because an office objection came, I have to take notice, my lords, since delay is there. Delay may be condoned, 1 week time may be granted, my lords, for objections.
I think I have written
After
here.
compliance of office objection, this is the first time, my lords.
This is based on eyewitness evidence. Daughter has supported, husband
That's it,
killed the
madam.
wife in the house. Daughter has supported.
Normally, notice ಆಗಿರಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಒಂದು ವಾರ ಐ ವಿಲ್ ನಾಟ್ ಸೀಕ್ ಮೋರ್ ದೆನ್ ದಟ್
ಅಲ್ಲ,
ಮಿಲಾಟ್ಸ್.
ಇದು ನಿಮ್ಗೆ ನೋಟಿಸ್ ಆಗಿದೆ.
ಅಲ್ಲ ಸರ್ವ್ಡ್ ಅಂತ ಅಷ್ಟೇ ಸರ್, ನೋಟಿಸ್ ಆಗಿಲ್ಲ.
Non compliance of office. Balasubramanya is permitted to attend the office objections. No representation for the appellant. However, Lord SPP to concedes for a condonation of delay. The appellant accused is during trial also he was in custody, it seems. Closing of the evidence. We will find it here. Arrest of the accused 7/2/2020. If he is released.
In one application they say 74 days delay.
Delay will.
In another application they say 45.
Why two applications?
I don't know.
Oh, IA 1/2025 is also for condonation of delay. Whatever maximum will take
okay.
it.
It's okay, yeah, no problem.
They have duplicated even the delay condonation applications. Now, considering the fact that the appellant is in judicial custody, delay of 74 days in filing the appeal is condoned in the interest of justice. IA 2/2025 is the duplication of IA 1/2025. In view of the above order, the same does not survive and disposed of accordingly. As requested by Lord SPP 2. Lord SPP 2 seeks time. You want to file counter to that?
No, no, I will get ready minutes because since delay first time ಬರ್ತಾ ಇರೋ ಸಲುವಾಗಿ ನೋಟಿಸ್ ಆಗದೇ ಇರೋ ಸಲುವಾಗಿ that is the
It's
procedure.
time for his response to I 1 of.
Next week immediately.
List down.
Next week. 25/6. Cell number 7. Rakshita, SPP.
In 74 days.
Rakshit. This is also coming for the first time.
And delay may not okay.
Appellant's counsel is permitted to attend the office objection. That's what last time. Raju Roy. I think generally what I do is I will make a note of or I have wrote.
ನೋಟಿಸ್ ಆಗಿದೆ ಅದರಲ್ಲಿ.
Notice ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
Oh, this is a case based on circumstantial evidence. This case is based on circumstantial evidence. No?
But we passed our minutes, I will argue on IA minutes.
I found that he had the sound of bidding in respect to the deceased. No representation for the appellant. Lord HCP, I'm sorry, Lord SPP 2 concedes for condonation of delay, considering the fact that the appellant accused is in judicial custody. Delay of 374 days in filing the appeal is condoned in the interest of justice. Have you got to say anything on this?
Minutes.
This suspension?
Any day minutes. It may be taken up at 2:30 also minutes, I will get ready.
We'll pass it over.
ಯಾಕಂದ್ರೆ ಬಂದಿಲ್ಲ ಅಂತ ಮೋಸ್ಟ್ಲಿ ಬರೋದು ಡೌಟ್. ನಾಳೆ ಅಥವಾ ನಾಡಿದ್ದು ಒಂದು ಡೇಟ್ ಕೊಟ್ಟರೆ.
Correct. ಏನಾಗುತ್ತೆ? We burn our midnight oil and they do not turn up. Again, next time when it comes, again we have to read the file.
It may be taken up at 2:30 minutes, no problem. I'll get ready.
Okay. ಅವ್ರು ಬರ್ತಾರೆ ನೋಡಿ, ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಅಪಾಯಿಂಟ್ ಅನ್ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಫಾರ್ ಇಟ್.
ಸರಿ.
ರಕ್ಷಿತ್ ಅಂತ ಇಲ್ಲಿ ಬರ್ತಿರ್ತಿದ್ರಲ್ಲ,
ಬರ್ತಾರೆ. ನಾವಲ್ಲಿ ಕಮ್ಸ್ minutes.
Pass on. Cell number 8, Nagaraj Reddy, CGP.
Today, because all Kannada deposition is there. At least we can do this. Yes,
Offense
ma'am.
under section 302, my lords, and there is delay of 655 days. He is in custody, my lords, from the date of arrest.
What is your application? Delay condoned 655.
Delay may be condoned.
In legal service or in
Legal service.
Legal service.
Please, please.
He is appointed by the legal services. Delay condonation. Orders on IA 1 of 2024. Third, the appellant is in judicial custody all along. Considering the said fact, the delay of 655 days in filing the appeal is condoned in the interest of justice. I-1 of 2024 is disposed of accordingly. Is suspension?
Suspension, my lords. Case is based on circumstantial and last seen theory.
My corner below.
The case of the prosecution, my lords, the accused, my lords, was living relationship with one Rama Devi, the deceased. And my lords, the child was also begotten, my lords, and since the deceased Rama Devi and her mother Lakshmi Devamma demanded him to marry her, he has committed another, my lords, the cases.
He was not granted bail during the
No,
trial.
my lords, no, he is
I
not.
think
From 10/1/2021, lords, he is in judicial custody.
last scene, no?
Last seen, the PW1 lords who has seen last, the brother of the deceased, brother and son of the deceased lords, at 8 o'clock when he went, lords, for the job. And thereafter, PW6 lords in the morning informed him, saying that the both were lying dead in the pool of blood.
But the witnesses have spoken. What was his defense before the trial court?
Except denial, lords, no specific
Except denial.
Yes, my lords.
Because the witness have spoken about his relationship.
Yes, my lords, PW1,
and,
PW.
I think DNA was also done, it seems.
Yes, my lords, he was living with them, lords.
No, they were in a live-in relationship.
Live-in relationship, lords, and since they have demanded him for marrying.
And that brother has said that he also started, he came and lived in his house only.
Yes, my lords. PW1 is the brother.
Yes,
Lords, he himself, after committing the offense, approached the police station.
Police station.
He went to police station and
confession reported.
yes,
Yes, my lords.
Confession before the police. And then police officer follows him and comes
yes, my
and
lords.
sees.
And section 106 also, my lords, has been laid on by the trial court.
The only thing is there, they have not taken up that defense before a registration of FIR investigation is commenced.
Yes, please.
But still, look at the gravity of the offense and
Committed the murder of two.
and that too with a person whom he lived for 2 years.
Yes,
2 years, or
there is a
how many
small-
years he had lived with her?
From last
And
2
that
years
old
and
age-
there is a
that
child
old
also,
age
lords.
lady also.
Yes, my lords. There is a child, a small baby.
They should have registered that. Just information they should have registered and then the admission. Effective account. So will reject. Order sign I am, sir. Admit, it's not at admit.
Not at, today today is the first day it is listing, lords, after compliance.
Matter requires consideration, admit, call for TCRs. Paperwork shall be prepared within 6 weeks. So within 4 weeks from the date of receipt of the TCRs. Okay. Orders and I-1 of 2024. By the impugned judgment and order, the appellant is convicted and sentenced for the charges for the charge for the offense under section 302 IPC. The charge against convicted for the charge under section 302 IPC and sentenced to life imprisonment. The charge against the appellant accused was that PW1, He was a migrant labor. He had come from which place?
Bihar, my lords. He was from Bihar.
The appellant. But the other person, a complaint was a local person.
Yes, my lords.
The appellant was a plumber, Allah?
Plumbing ಕೆಲಸ
Plumbing work.
brigade.
Plumber. And for his livelihood, he had migrated Orissa
Orissa. my lords.
from his native place Orissa to Devanhalli, no? Baichapura. Baichapura Devanhalli for there he was working with along with PW1 is the
PW1 is driver. my lords.
PW1 who was working on the same work
Yes, yes,
project.
PW11 is a plumber supervisor, my lords, under whom?
PW1 who was also working on the same work site as a driver. They developed a friendship and the accused started living in the house of PW1. The accused developed a relationship with what is her name?
Ramadevi. my lords. Deceased.
Mahadevi's mother, it seems.
ಮೃತ ರಮಾದೇವಿ ಇಲ್ಲ ಮದರ್ ಹೆಸರು ಲಕ್ಷ್ಮೀ ದೇವಮ್ಮ.
Developed a relationship with Ramadevi, the younger sister of PW1. He lived in their house and they were in a live-in relationship for 2 years. They begot even a child. When Ramadevi and her mother Lakshmi Devamma started insisting the appellant to marry Ramadevi on 10/1/2021, the appellant in their house at Baichapura in Devanhalli Taluk, the appellant picked up quarrel with them. And assaulted them with the chopper and committed murder of both of them. Though the case is based on circumstantial evidence, as per the records, the appellant himself went to Devanhalli police station, reported the matter. And then investigation had started. Any recovery?
Chopper, my lords.
Chopper is recovered. my lords. We took the chopper.
But PW1 he has not even disputed it since because we don't have the records. Relationship.
He has not disputed.
You secured all the records?
Yes, my lords. So,
313 statement, etc.
yes, denial ಅಷ್ಟೇ ಸ್ವಾಮಿ ಇನ್ನೇನಿಲ್ಲ. Yes, it is there. 313 statement.
But ಇದರಲ್ಲಿ DNA ನು ಮಾಡಿದಾರಲ್ವಾ?
Except he says, my lords, he does not know anything about this case. There is nothing on record, my lords. So there are 7 of the judgment. Trial court has observed with regard to 313 statement.
Doctor's opinion. ಇದರಲ್ಲಿ DNA ಮಾಡಿದ್ರಾ? ಯಾವುದೋ ಒಂದು it overlaps today in some other matter. झूठे. The witnesses to the motive circumstance last seen together and the other circumstances corroborated each other. Even during the trial, the appellant was not extended the benefit of bail, having regard to the gravity of the offense, 2 murders and other material on record. It's not a fit case to grant suspension of sentence and bail, hence the application is rejected. Okay. List after the preparation of the paper books.
Seal number 9, Mohammed Mujasim, SPP.
My lord, pray for short accommodation, my lordship. Kindly have it this next week, my lord. Next week will,
Paper ready ಆಗಿದೆ.
for suspension of sentence, my lord.
PW9 son eyewitness has supported. PW15 is the eyewitness. PW16 is.
All those are,
Only PW16 has turned hostile. PW9 and 15 as
My
per
lord,
the
all
judgment.
all are related witnesses, my lord. All eyewitnesses
So
are.
you are ready, that means you argue the matter.
My lord, I'll argue next week, my lord. Just
Correct, why we should keep reading every day the same files?
next week, one short accommodation, my lord.
Make a new file, you should not forget things. No, we will not grant you time. Argument ಮಾಡಿ.
My lord, one day time, short, one day till.
You have read the file now.
ಇಲ್ಲ
We referred to some.
just while drafting I had read.
Pass over ಮಾಡ್ತೀವಿ.
ಇಲ್ಲ,
ಹಾಗಾದ್ರೆ
my lord,
ಅದೇ
kindly
ನಮ್ಮ-
have it,
No, no.
kindly have it tomorrow, my lordship. Lord, kindly, short accommodation, my lordship.
Very shocking.
ಇಲ್ಲ,
Incident is very shocking. When we have to pray for their families now, that's
one short date, my lordship, because we'll take.
why you.
Next week we'll argue the matter.
Yes, you have read the file. Why do you want it?
Only we need to produce some documents, my
What
lordship.
documents at this stage you
Trial
can
court
produce?
records I need to go through, my lordship, because
We'll
of that.
pass it or do it in the
Next
afternoon.
week, my lord, one date, my lord.
We'll impose.
Will
cost,
not take
that is
further
it.
date, my lord. It is legal services authority case, my lordship, because of
Oh,
that.
new legal service or where, na? Then we have to refer it to the legal service
ಇಲ್ಲ,
committee
one
only.
date ಅಲ್ಲಿ just I need to argue effectively, my lord. Otherwise, that's it, my
It's
lord.
what they say. See, when you come from the legal service authority, you should be ready now
My
because
lord, records were not there, my lordship, because he is in prison and the family members are now cooperating, my lord.
in these kinds of matters, nobody will come to inform you.
Please, my lord.
You have to read the file and do the needful.
We'll argue next week, my lord.
Appellant's counsel. At request of appellant's counsel, as a final chance, time granted. List on.
26-6.
Please.
Seal number 10, Ravi Shankar CR, SPP.
The respondent statement.
CR records are awaited. Call for ಆಗಿತ್ತು last time.
Call for awaited. Oh, this time junior Ravi Shankar has come. Ravi Shankar is not getting confidence in this. We'll see.
It's case based on circumstantial evidence, my lords, even. Look into the records.
Just we'll see where is the mic. Another. Oh, this is recovery.
Please.
Accused of PW 25 is a jewelry shop owner.
Yes.
This is a 74 years old lady, it seems that lady. 74 years old lady. Then it is listed in the orders matter.
Yes.
Records are here, no? Why do you want records? You
last-
only have produced charge sheet, FIR.
Last
etc.
time when the matter was listed, IA number 1 of 24 shall be considered only upon securing the records ಅಂತ order ಆಗಿದೆ.
No. When it was ordered? Tell us.
22nd January 2025 appeal was admitted.
Appeal admitted, call for records, list this matter soon after receipt of records on IA1.
Yes.
Orders on IA1 of 2024. Take that. This is from which court? Madikeri.
Madikeri.
The law counsel for the appellant submits that on 22/1/2025.
Please.
22/1/2025. IA1 was ordered to be heard on receipt of the TCRs. ಯಾವಾಗ ಕಾಲ್ಫರ್ ಮಾಡಿದ್ದಾರೆ ರೆಕಾರ್ಡ್ ಸ್ಕೀಮ್ ರಿಕ್ವಿಷನ್ ವಾಸ್ ಸೆಂಟ್ ವೆನ್ 27 since more than 5 months 4 months records are TCRs are not submitted. Seek the explanation of the concern, secure the TCRs expeditiously and list on
36.
Safe.
Cell number 11, T Prakash, SPP.
No confidence.
But convicted for 302, my lord. Convicted for 302.
Delay may be condoned, my lords, next week for objections. IA.
Delay
Notice may be ordered, my lords.
notice to the other second respondent is there? No,
Allah, notice for state, my lords, because coming for the first time.
not ordered. Have any objection even for condonation of delay?
For condonation.
51 days delay.
15 days delay, my lords.
Learned SPP2 accepts notice for the respondent. He concedes for condonation of delay as these are all the accused are preferred or
Pardon, please.
which
No,
accused are preferred?
A1 has filed
Only
this.
one.
Yes.
So he was on bail during the trial.
Yes, please.
Now thereafter he is in custody.
Yes, please.
Since the appellant is in judicial custody after the impugned judgment and order of conviction. Delay of 51 days in filing the appeal is condoned in the interest of justice. Yes, so you want time.
A week's time.
Really, court has observed PW2 is the eyewitness and younger brother of accused number 1. He was not cross-examined immediately. So,
But subsequently, they have turned those till.
right.
1
Yes,
hour.
sir, court infers and refers to a judgment also,
Yes.
judgment of the Supreme Court. ಇಷ್ಟೇ ಇದೆ ಪಾಯಿಂಟ್ ಇವ್ರು ಅದಕ್ಕೆ 3 ದಿವಸ 3 weeks time you want.
Allah, 1 ವಾರ. ನಾಳೆನೇ ಹಾಕೊಂಡ್ರು I will get it.
No, 1 week. 1 week.
Because coming for the first time because of that, my lords.
As requested by both sides, list on
23/6.
24, my lord. 24.
24.
Yes.
24/6. Cell number 12, yes, Balkrishnan, SPP.
I'll take notice, my lords.
TCS is no more.
Delay is there.
Admit call for TCS.
For the appellant in this matter, your lordship,
4 weeks from
the
the date of
delay of 11 days may be condoned, your lordship, since he was imprisoned, he could not find an advocate, your lordship. He could not talk to his family member and find an advocate, your lordship.
Yes, confused.
So we pray that the 11 days of delay may be
Sir, I said
condoned.
today and there is- 1 second. Notice was issued to the second respondent. No,
No, my lords.
notice has to go for condonation. Condonation has to be considered after issue of notice to respond number 2.
Yes, your lordship, we'll,
Yes, it was FOCSO offense, no?
yes, section 6 and 506 of IPC, your lordship.
Matter involves the offense under the FOCSO Act. Respond number 2 is the informant, no? PW2. Is PW2. Correct. PW2, I'm sorry, respond number 2 is the father of the victim. It's issue notice to respond number 2, list on
27.
27.
Much of that. Seal number
In this
13.
matter, DNA test report was there.
Number 13. Hala Shetty Jagdish Sidramappa, SPP.
I appear for the appellant, Lord. The accused number 1 in this, there are 4 accused. Appellant, accused number 1, 2, and 3 are convicted for the offense punishable under section 302 read with 34 and acquitted of the offenses punishable under section 115. Accused number 4 is acquitted of all the offenses charged against her.
It appears
The appeal is filed by accused number 1.
charge against accused number 4 was she abated.
4 ಜನಕ್ಕೂ ಸೇಮ್ ಚಾರ್ಜಸ್.
Correct. Against her.
Against her, all the charges are not proved and she is acquitted. The allegation is that there is illicit relationship between accused number 1 and accused number 4. And as a result, there was a conspiracy between them to eliminate the husband of the accused number 4. And accused number 1, along with accused number 2 and 3, his friends, murdered the husband of accused number 4 is the case of the prosecution. Kindly see para 78, ink page 56.
56.
Ink page 56, internal.
Yes.
However, it is to be noted that the prosecution has not proved its case beyond all reasonable doubts with respect to the allegations of conspiracy among accused number 1 to 4 and abetment by accused number 4 to accused number 1 and other accused to cause the death of Malleshappa. But participation in presence of accused number 4 in any form is not proved by the prosecution beyond all reasonable doubt. Hence, accused number 4 is entitled for acquittal to all charged offenses. Consequently, that's how it proceeded. Conspiracy ne illa ant heli, that is the fine.
With reference to accused number 4.
4 in relation to other
abatement as a
accused.
Conspiracy.
In relation to other accused. When there is no conspiracy proved by the prosecution,
But they are acquitted of that conspiracy.
conspiracy prove agilla. Para 65 nalli the trial court assigned the reasons as to
They are convicted only of 304.
302 read with 34. 34. What is the motive? If the conspiracy is not proved, if the accused number 4 is acquitted of all the charges, then there is no motive proved by the prosecution. The main case of the prosecution is that there is a relationship between accused number 1 and accused number 4. That was the motive set up.
If the motive is not held proved, then how the other?
Let's move with regard to motive. There is evidence for not PW1 and PW5 has deposed about motive. That is the relationship between accused number 1.
On that count, she is acquitted. No?
My lords, that is with regard to conspiracy, my lords. My lords,
Conspiracy,
merely because
abatement, even for abatement and conspiracy, the ground was that her relationship with accused number.
that is right, my lords. Merely because she has entered into conspiracy, my lords, if she has not taken in,
Other circumstances.
my lords, There are 65 minutes of the trial court's judgment. Running page 45, internal page 39 minutes.
Para 65, page 45, the trial court assigns the reasons for why convicting accused number 1 to 3. Page number 45, yes. PW1, who is the brother of the deceased, PW5, who is the mother of the deceased, ಅವ್ರು ಹೇಳ್ತಾರೆ ಆಗಾಗ ಗಂಡ ಹೆಂಡತಿ ಮಧ್ಯೆ ಈ ಕುರಿತು ಜಗಳ ಆಗ್ತಾ ಇತ್ತು ಅಂತ. ಸಾರಿ.
Now you can't speak only in Kannada.
Yes, what PW1 and PW5 say is that there was a quarrel between A4 and the deceased, her husband, with regard to her relationship with accused number 1. And that is what they speak about with respect to the participation of all the accused, A1 and A4. But however, the finding is that the trial court has acquitted A4 of all the offences charged against her.
But why they were not granted bail during trial? During trial they were on jail. They were not granted bail.
It's been 5 years now, my lord, that the accused, this appeal is filed by accused number 1. It's been 5 years now. They are in jail. They were arrested on 30 July 2020.
Now where this vehicle was seized?
Minutes.
Vehicle used in the commission of, that was one of the circumstances.
Yes, minutes.
That was seized from which place? And after how many days?
15
That
days,
is
minutes.
Exhibit P42.
In fact, PW 8 has deposed to that effect, minutes. The vehicle belonged to PW 8.
Local language.
The vehicle belonged to PW 8. He has deposed about minutes, accused number 1 taking the motorcycle from him on the date of incident at about 4 p.m. And minutes that has been recorded at the instance of accused number 1 after 15 days.
Correct. What anything was there to connect that motor vehicle to the any blood stains or anything was there?
That's,
You have preferred any appeal against acquittal of accused number 4?
no, my lords. State has not preferred any appeal.
Because then our doubt is, if the whole basis of the crime was the motive, if she is acquitted, her abatement, her instigation.
Even in the complaint, this allegation of illicit relationship is not mentioned.
Let's merely because my lords.
This is page number 35, 41. That's why we asked after how many days this seizure was effected.
After 15 days, minutes.
Very horrific. Any fingerprints, etc. was done?
Children.
He was also.
Lords, MOs 18 to 20 have been recovered at the instance of accused number 1 under measure, my lords, exhibit P24. They are, my lords, chopper and, my lords, night pant and, my lords, t-shirt. And their FSL report is, lords, accused number 1, my lords. And the FSL report is there to that effect, my lords, that they were stained with blood. That is, my lords, A group of blood.
Was done.
A group of blood, my lords. Deceased, my lords, cloths, my lords, of deceased. Coupled with, my lords.
Exhibit?
Lords, that is, my lords.
That is only against A1.
A1, my lords. Cloths, recovery of weapon used in the commission of crime, MO 18. 19 and 20 are the cloths of accused number 1, the petitioner herein.
18, 19 and 50.
20. With regard to that finding, my lords, trial court's finding at paragraph 57, internal page 30 of the judgment. They contain, my lords, A group of blood.
Page number, which judgment page number?
30, my lords. Paragraph 57. In paragraph, it's paragraph 55 itself, my lords, you will assume kindly one page behind, from page number 29 itself. Page number 29 of the judgment, paragraph 55 itself, with regard to recovery, my lords.
So based on voluntary statement of A1 to 3,
Recovery of amounts 18 to 20 supported by seizure Panchanama drawn as per Exhibit P24 with photos Exhibit P25 to P28 based on the voluntary statement of accused number 1 marked as Exhibit P42.
Of the judgment.
what were MO 6 to 8?
Exhibit based on one exhibit for P40.
6 to
P42.
8. Knife and clothes of A2. Yes.
Hmm? 42.
9 to
Knives,
11 now?
Machete,
No, 9 to
machete
11.
and knives.
Inner weight
Official report eligible.
and iron knife.
Hmm, 50. Exhibit P50. Hmm.
1 to 5.
Blood stain, sodium. Knife. 51.
Internet.
R11.
Yes, how do you explain this? The seizures effected from you, many work clothes and blood stains on the clothes of the deceased and weapons they matched.
My submission is, Lord, mere recovery, Lord, what I understand.
Correct. Mere recovery it connects.
Because PW1, PW5 being
Now how he suffered, I mean, how he got these blood stains on his cloth? You are denied this recovery itself, it seems only. That was at the instance of accused number 1 to 3 all. And the recovery mechanism and that matches with the result. So PW, accused number 4 is acquitted. But she is acquitted for abatement. So there is relation.
Abatement is not proved.
She is acquitted of because actually there was no allegation of actual assault against her. So naturally she is acquitted of 302, 334. 115 that is abatement. Abatement is not proved, that's what.
19 battling there is. 19 battling there is.
Injuries, that photographs
Shows. Yes.
Yes, I think now he has clarified it. And he has clarified because name is before he there close stained with the blood. They have to explain it. So like rejected. So, 283, no?
PW1 and PW5, my lord, interested witnesses.
Relatives, Supreme Court has held in several judgments that merely because they are relatives, they can't be labeled as interested witness. Only thing is that has to be cautiously analyzed.
But the
They are
finding,
the family members. Whatever family affairs go on, they will be knowing. They speak about the quarrels between the couple.
but when there is finding recorded by the trial court with respect to the conspiracy,
That was with regard to abetment.
abetment. So when there is no abetment, not the motive fails.
Even without abetment, they can assault. No
There should be some motive.
motive. They have said for these people also motive is proved, but only that lady's abetment is not proved. That's what he said.
If the motive is proved, then
No,
she is also
not in all cases. If the motive is proved, they should be convicted.
the case.
Unless they have some role in that.
The case put forth by the prosecution is that there is a relationship, and as a result, this happened.
I will consider your submission. What is the number? 282 also. By the European judgment and order, the trial court has convicted appellants / accused number 1 to 3 for the offence under section 3 and 2, read section 34 IPC, and sentenced them to the life imprisonment. The appellants under the above application are seeking suspension of sentence and grant of bail. Shri so and so learned counsel vehemently contends that the whole facts the charge against appellants along with accused number 4 were tried by the trial court in SC number 41 of 2021 for the offences mentioned under section 115, 120B, 302, read section 34 IPC. The case of the prosecution is that accused number 4, the wife of what is his name? Malleshappa, victim Malleshappa, had an illicit relationship with accused number 1. In that regard, there used to be frequent quarrels between Malleshappa and accused number 4. Therefore, to eliminate Malleshappa, all the accused conspired to commit his murder, and accused number 4 awaited accused number 1 to 1. He hires these two, Alva.
Yes.
One to commit murder of Malleshappa. Accused number 1 hired accused number 2 and 3 to accomplish the mission in execution of such conspiracy on on 24/7/2020 at 8 p.m. the accused took Malleshappa accused number 2 and 3. Accused number 2 and 3 induced Malleshappa to consume liquor, and when he was consuming liquor with them, all the accused number 1 to 3 assaulted him with machetes and knives, committed his murder. Next. Shri Hal Shetty, learned and counsel for the appellants, vehemently submits that the whole basis for the relation, the crime was the relationship of accused number 4 with accused number 1 and her abatement to accused number 1, but she is quitted. He further submits that PW, relatives are PW?
1 and 5.
1 and?
One is brother, 5 is mother.
But 9? What about 9? He has also supported. PW 1 and 5 are the brother and mother of the deceased.
Nagaraj K.
Therefore,
Nagaraj K. 9 nodi.
And interested witnesses. And trial court committed error in relying on their evidence.
That he's the owner of the bike.
Correct. Why
Because
he
9 is the
supports?
owner of the bike.
Owner of the bike.
Why he supports? Not only these two have supported, Caesar Mazar witnesses have supported. Caesar, judgment says Caesar Mazar witnesses have supported.
Supported.
Next.
Supported.
For contrast, so and so learned SPP2 submits that the role of accused number 1 was only the abatement. Therefore, her acquittal does not confer any benefit on accused number 1, appellants. He further submits that there was recovery of the weapons of offense and clothes of bloodstained clothes of the accused. Based on their voluntary statement and the bloodstains found on those weapons and clothes matched with the blood group of the deceased. And that was not explained. Therefore, the accused are not entitled to the benefit of suspension of sentence and bail. Next. As rightly pointed out by learned accused number 4 was charged only for commission of abatement of the offence. Neither she was the actual assailant, nor as per the prosecution itself, she was present at the scene of offence. At this stage, the records indicate that there was a recovery of bloodstained clothes and weapons at the instance of the appellants, and the bloodstains found on those articles matched with the blood group of the deceased. That circumstance, the other witnesses have supported, that circumstance was not explained by the accused. Considering the material on record, even during even at pre-trial stage, the appellants were not extended the benefit of bail. Now the said charge circumstances are reaffirmed by judgment of conviction. Having regard to the gravity of the offence and material on record, it's not a fit case to grant suspension of sentence and bail. Hence, the application is rejected. Paper books were not ordered, no, admitted. Matter is already admitted. 4 to 25. 4 to 25.
That is already admitted.
Paper books preparation is ordered. Paper book shall be prepared expeditiously. List of 4 weeks. List of 4 weeks. 4 weeks.
14/7.
14/7.
Cell number 14, Mohan Kumar D, SPP.
Appellant mirrored delay of 120 days accusing judicial custody.
Yes, SPP or in head, sir. Will condone the delay.
Yes.
Appeal is by which accused? Accused number 1.
Yes, madam.
Whether other accused have preferred any appeal?
A brother, other accused brother.
No, whether they have preferred any appeal. Accused number
A-
1 to
another
4
appeal
are
is-
acquitted of 498A.
302 120B. Another appeal also pending yet to be consideration, my lords, for first time.
That's what we asked. Acquitted of 498. Accused number 1 and 4 are convicted for 120B, 302, 201. Two and 3 were on bail. During trial, 2 and 3 were on bail.
Yes, my lord. No, 2 and 3 is acquitted, my lord.
Now acquitted, even during trial, whether these accused were granted bail 1 and 4.
No, my lord. 1 and 2
Now they are in JC and
in judicial custody. The
after they are in custody.
one son and daughter also in the accused number 2, 3 house, my lords. You only look into accused number 1 and 2.
This delay will condone.
Yes, ma'am.
Orders in I number 2 of 2025. The appellants, accused number 1 and 4 are in judicial appellant only. Brother also has preferred an appeal. What is the case number? Office note is there? No. We'll condone the delay and then direct to connect this matter.
Yes, my lord. Lord, call for records.
What about bail?
My lord, bail next date of hearing after records, my lords.
Appellant, during trial also, the appellant accused number 1 was in bail. Considering the same delay of how many days? 58 days.
120 days.
120 days in filing the appeal is condoned in the interest of justice. A2 of 2025 is disposed of accordingly. Law counsel for the appellant submits that accused number 4 has preferred a criminal appeal number.
Adu koduthin.
Criminal appeal number so and so. He further submits that IA number
3 of 25.
IA number 3 of 25 may be considered after the receipt of the TCRs. Hence, admit call for TCRs. Paperwork shall be prepared within 6 weeks. I3 of 25 is deferred for consideration after the receipt of the TCRs. List along with criminal appeal number so and so on 6 weeks on. Yes, admit call for TCRs. I said TCRs. File TCRs.
28/7.
What do you call them? LCRs.
28/7 number kodi sir.
Obligement.
For admission, cell number 15 KVK Swami SPP.
I will take notice, my lords, in this.
I am for appellant in this case, Your Honor.
First
The
time
Honorable Trial Court has convicted the appellant for the offence under section 302 for life, my lord. And notice may be issued to the state, my lord, in this.
State ತಗೊಳ್ತಾ ಇದ್ದಾರೆ. He is taking notice. Lad SPP to accepts notice for the respondent. In this case, PW 2 and 3 are the eyewitnesses for 341 wrongful restraint. It's a very hard. Copy ತಗೊಂಡಿದ್ದೀರಲ್ಲ? You want time for hearing on IA number 1 of 25?
Yes, my lord.
Meantime,
Meantime, note.
6, a girl. He was forcing her to love him and he commits murder. Now takes notice for that. She will admit it and.
Yes, my lords.
Lord counsel for the appellant submits that IA 1 of 2025 may be considered after the receipt of the TCRs. As admit call for TCRs, paperwork shall be prepared within 4 weeks from the date of the receipt of the TCRs. List on 8 weeks or 6 weeks. 6 weeks or
21/7. Cell number 16 P Natraju SPP.
This case, apply for the appellant, my lord. Appellant has convicted the under section 302 and read with section 201 of the
ಇದು ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇದೆ.
first time, my lord. They not filed any suspense of sentence, my lord.
What is the offense? What are the offenses involved?
Offenses are 302 and 201, my lord. Accused is sentenced to life imprisonment till the breath, my lord. Page number.
He was in judicial custody during trial also.
Please, my lord. Now also is in judicial custody. Page number 252, my lord. Sentence, my lord.
2 persons were killed in this.
Case of the prosecution is, my lord, on the basis of the circumstantial evidence, my lord. Only PW 18 has supported the case, my lord. The accused has pledged the God ornaments, my lord. No other witnesses have supported, my lord. PW 1 to 4 are the family members.
They have not filed any application for suspension here.
There's no application. We are not filed.
Application. For admit call for TCS, paperwork shall be prepared within 4 weeks from the date of receipt of the TCRs. List down. 6 weeks or not?
CH-7.
Much of
Cell number 17, RB Deshpande, SCP.
State of Lisa, they have interest for life for a murder, 10 years imprisonment. Yes, Deshpande. Generally, irtaralla Deshpande avaru. Another note in first page of SC number
I'll take
7,
notice,
ordered
please.
it wrongly mentioned as 10-3 instead of 24 instead of 24. Oh, judgment is in.
Coming for the first.
See, what they have mentioned is, date is wrongly mentioned as 10-3-2024 instead of 10-3-2025. Judgment is rendered on 11-25, actually last page. So what? For the mistake committed by the trial court, the appellant is not responsible. Therefore, office note is disposed of, and office note is overruled. Deshpande, where he has gone? Admit call for TCS. Paperwork shall be prepared within 6 weeks from the date of receipt of TCS.
Cell number 18 adjourned for preliminary hearing. Cell number 19.
Session of paperwork.
Akash Kumar Gowda, DM Manjunath, M. Shivaprakash.
Lord, I appear in 19.1 for the complainant. I seek leave, Lord, to withdraw the complaint. Filing a memo. Unconditional withdrawal.
Oh, this is 1960 suit
Yes.
Matter.
Lord, related, my Lord, to certain proceedings instituted.
Subsequently, their allegation is that they went on filing compromise petitions excluding her.
That was the main allegation was that, but I don't want to be part of this litigation, Lord. I have purchased the property and
So one is by purchaser and other one is by.
others
that
have
lady.
also filed, Lord. Others have also filed. There are the connected cases.
Correct. Now, this first matter is filed by the beneficiary of that litigation. One of the plaintiff, Yellamma, is her husband had purchased the property. Yellamma. So you are going to withdraw 19.1 alone.
Yes, my Lord. That is CCC 6 of 24, my Lord.
What about first matter?
I don't appear in that.
This is being derailed. She is not here. Have you issued notice?
ಪಾರ್ಟಿ ನೋಟಿಸ್ ಮಾಡಿದ್ದೀರಾ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಕ್ಲೈಂಟ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ
No, whether purchaser got any relief, why he is with here?
No, my Lord, there are Lord, number of issues that are there in this case. It's in a small part of Chikbalapur. This petitioner's family, my Lord, is a well-known family. They don't want to continue this litigation, my Lord. What has happened is that property is now, my Lord, in our possession. There are other proceedings, my Lord, relating to that. So we don't want to pursue this, my Lord, in the hope that everything will get resolved.
But it is between the court and this thing. No, now cognizance is taken. Preliminary hearing it has come.
It's a preliminary, only notice had been issued.
The file, it is little shocking because 1964 a litigation, 71 decree, 82 final decree proceeding, and they go on filing other cases, how the parties sustain these kinds of litigations?
My lord, I don't want to be part of it is my submission. my
We
lord.
understand if the allegations, because it's at the preliminary hearing, if really to support that judgment and decree, this is being done, this is unexcusable. Who is for the accused here?
I'm for the accused, my lord. Still FDP proceedings are pending before the trial court.
Correct, but they say that to support the earlier decree, you went on filing compromise petitions excluding the beneficiary of the decree.
That,
And matters are pending even till this, none of us were born when this first decree was passed.
senior will come, my lord. Can they pass out the matter?
Even if they want to withdraw, one is going to withdraw, we can permit, but can we permit withdrawal in such case?
My lord, my submission is this, my lord, that if the court had framed a charge, my lord, then it is within the purview of the court, my lord. But now it's at the stage of a complaint by me.
They had filed suit in 1960 and it was decreed on 7/11/1964. We'll say without prejudice to the rights of the
Others,
complainant in the other cases, we'll
Please,
permit you to withdraw.
great.
This is 2024. But we keep seeing, I mean, filing subsequent litigations. In some other cases also we are seeing, more particularly here in Bangalore City Civil Court Center.
Lord, kindly pass over the matter, my lord. In this matter, my lord, there is a allegation against the advocate on record in second matter, my lord. Kindly pass over the matter. Senior will.
Now they want to withdraw this.
My lord, in this matter, my lord.
That was
Before
only
passing-
say, so far as,
Before passing FDP proceedings, my lord,
yes, they have said we have gone through the file in each compromise petition, because they say afterwards when she appeared, those compromise decrees were set aside.
Yes, my lord.
But still he kept on filing further compromise petitions.
My lord, in this matter, they have approached, my lord, accused are the persons are
Who
the
is
illegal-
that counsel? Manjunath, DM Manjunath. huh?
Well, I appear for them.
I'm for the
No,
One
the
of
trial
the
court.
trial
I
court.
think they have made allegations, right? No, now he wants to withdraw one, the other one let it continue. One he wants to withdraw.
second matter. Lord.
We'll permit him to withdraw, you can, whatever submission is there, and the other case you can do it. Do you place a memo?
Accused, yes, Lord, I've just given the memo.
What a memo, no? Yeah, but 19.1 accused to be present before the court ಅಂತ ಆಗಿದೆ. ಅದಕ್ಕೆ whether advocate was also made an accused in that case?
No.
Then
There is a mistake. Last date appearing, my lord, coordinate bench of the Senate court directed to present before the court, my lord, for, complainants, my lord.
not complaint, accused to be present before the court ಅಂತ. ಅದರಲ್ಲಿ first there are 12 it seems I have noted in the first matter. There are 12 accused it seems because somebody died and their LRs are brought on record. Yes, totally now surviving accused are 12. And then if advocate is not made party, what is your problem there now? If he wants to withdraw. Oh. 19.1 ಅಲ್ಲಿ accused is,
In first matter,
whether
my-
accused are there?
yes, my lord. In first matter, my lord.
Huh.
In first matter, my lord, the on-record advocate represented before the trial earlier proceedings on behalf of accused, my lord. That is the, my lord, allegation against the accused.
Correct, now he is seeking withdrawal of the second matter.
Please, my lord.
Shri. Raghunandan ಅವ್ರದ್ದು advocate ಅಂತ. ರಾಜೇಂದ್ರ complaint ಯಾರು ಜಯರಾಮ್.
Jairam.
He is there.
He is not.
In connected matter, one Ellamma is there. I think she is not also not alive it seems now that Ellamma 94 years or 100 years ಅಂತೆಲ್ಲ ಹೇಳಿದ್ದಾರೆ
ಹೌದು.
Shri S.S. Nagananda, Lord Senior Counsel, appearing for Shri Rajendra S., advocate on record for the complaint, submits that complaint seeks permission to withdrawal of the complaint in this matter. A memo to that effect is filed by the advocate on record for the complainant. The other party co-plaintiff, they're not Yellamma was a co-plaintiff. No, her husband was purchaser, no?
Yes, my lord.
Her husband was a
Husband has
purchaser.
purchased.
Anyway, the complaint filed by the other party is pending in criminal CCC number 5 of 2024. Therefore, considering the same and without prejudice to the rights of the complaint in the connected matter, this complaint is disposed of as withdrawn. We can permit that because another complaint is already there, but it is a criminal contempt. That is the problem. Yes, SPP2 ಏನಾದ್ರು ಹೇಳ್ತೀರಾ? They want to withdraw. It is not a civil contempt. It is a criminal contempt. Yes, you only have to guide us in this
No, my lord,
matter.
what I'm submitting is this, my lord. I thought about this situation, my lord. When the criminal, it's like a private complaint. When the honorable court, my lord, considers the matter and finds it fit and suitable to frame a charge, from that stage, my lord, the complainant has no right to withdraw. But now, my lord, it's only a,
Is taken. Now, notice is issued. Contempt rules could act. Our High Court of Karnataka, but after preliminary hearing, this is at preliminary hearing.
notice is issued, but the court, my lord, has not yet passed an order finding prima facie complaint.
Cognizance, no order is passed. Our High Court rules. 18. Rule 8 is preliminary hearing and notice. Every petition or reference shall be posted for preliminary hearing before the appropriate bench. The court, if satisfied that a prima facie case has been made out, may direct issue of notice to the accused. Otherwise, it shall dismiss the petition or reject the reference. B. Notice shall be. So, the court, if satisfied that a prima facie case has been made out, may direct to issue notice to the accused. Now, it is deemed that while issuing the notice, prima facie case was.
Yes, prima facie case is made out. That only the notice will be issued. But my lord, for it to become a criminal case for trial, charge will have to be framed, my lord. Because after notice, they have an answer to give. Honorable court will have to hear and then frame a charge.
Only they are accused. All the accused. This is a criminal contempt. Accused should be present now.
Earlier, my lord,
Exempted.
yes, my lord.
When? All right, you are complaint. You are seeing the rules? High Court of Karnataka rules?
Yes, my lord, I have.
Anyhow, we have said without prejudice to the right.
Please.
Your matter is disposed of as withdrawn.
Please.
Criminal CCC number 6 of 2024, hence disposed of as withdrawn. With the condition that the rights of the complaint in the other
exemption
another connected matter are not affected by such withdrawal. Yes.
Yes.
In which is that first matter, CCC 5. Retirement of memo, we can't take it like that. You have to issue notice and retire. Huh? The notice? There. Where is the retirement memo? The retirement memo. There may be something here which doesn't meet the eyes of the court. See, this is very serious because the case is the case is that they are filing frivolous litigation subsequently collusive litigation. and they are plotting that decree. Now suddenly they come saying that they will withdraw. ಅದು 5 ಇದೇನೋ ರೀನಂಬರ್ ಆಗಿದೆ ಅಂತ ಕಾಣಿಸುತ್ತಲ್ಲ, so that is the problem. 2019 it was filed as civil contempt and then it was converted to criminal contempt. And where are in this accused? Really they are accused. When they were exempted, you say they were exempted, but order sheet says that they shall be present. Idena 5 dina order. It shows when they were exempted. They were not exempted. ಯಾರು ಒಬ್ರು ಇಲ್ವಾ ಅದರಲ್ಲಿ 12 ಜನರಲ್ಲಿ?
Two accused are there.
Who are there? What is our ಹೆಸರೇನು? ಮಂಜುನಾಥ್, accused number B. ಇನ್ನೊಬ್ರು ಯಾರಿದ್ದಾರೆ? Who is the other one?
Jagannath.
Jagannath is
Accused number 3D1, my lord.
3D na?
3D3, my lord.
3D3. D3. B3 or D3? हाँ, B3. Accused number? Accused number?
ನೀವು ಹೇಳ್ಬಿಡಿ.
1B na ಅದು? B, 1B, 3, B, I'm sorry, B ಅಲ್ಲ, B3, 3 ಅಲ್ಲ, B3, ಹೆಸರು ಬರ್ಕೊಳ್ಳಿ. Accused number B, ಮಂಜುನಾಥ್, accused number B3, Jagannath, B into bracket, Roman 3.
Let's accused number 3A1 is also present.
Who is that one?
3A1.
3A1.
3A.
Oh, ನೀವು ಏನೋ ತಪ್ಪು ಮಾಡಿದ್ದೀರಾ. You should have corrected number wise. ABC, why did you give ABC?
Well, amended cast letter.
Where is the original fiction? How did you amend it? See, Nanjappa was accused number 1.
Yes,
you should have done them 1A, 1B like that.
That complainant to
Complainant, ನೀವು ಮಾಡಿದ್ದ ಇದು corrections. You should have shown them as 1A, 2A like that. If somebody is dead, you correct it accordingly. On death of accused number 1, 2, 1, 2. Somebody, what is this? It's very confusing. Their last should have been showed as accused number 1AB, 1A2, F, and 3, A2. ಹಾಗೆ ಮಾಡಿದ್ದಾರೆ, correct. But 1 only they have not done that.
Yes.
1 it was. The complainant's counsel shall correct the same, the cause title of the complaint accordingly. Okay. Now present is accused number 1B. ಯಾರ್ಯಾರಿದ್ದಾರೆ ಪ್ಲೀಸ್ ಸ್ವಲ್ಪ ಸ್ವಿಫ್ಟ್ ಆಗಿ ಹೇಳಿ.
Let's 3AB.
That is Manjunath is there.
DM.
3A is Lakshmi Narsappa.
No, Sri Ramaya. KN Srimara.
No, 3A
death ಆಗಿದೆ. A is dead.
is dead. I'm sorry. B. Sitama. B is Sitama.
Sri Ramaya. KN Sri Ramaya.
No, here they have shown one Sitama as B.
Sitama is D. In
D.
earlier cast.
You know, there is some error it seems. Error present. Please tell the name of the persons who are present.
Ramaya. KN Sri Ramaya. After Lakshmi Narayan. After Lakshmi Narayanappa.
They have shown the name of one Jagannath here. You know, some messing, you have messed up some things here. Original complaint ಎಲ್ಲಿದೆ ತೋರಿಸಿ correction. This seems to be the amended complaint. ಇದು amended ಇರ್ಬೇಕು ನೋಡಿ. ಒಂದು ಕೆಲಸ ಮಾಡಿ ಆ ಕಾಸ್ಟ್ ಅದೇ ಒರಿಜಿನಲ್. But whatever name he is saying, it is not there. You have your copy, see if in your copy they have corrected that accordingly. See, we'll call the name of each one of them.
My lord, the last date of period.
One is Narsimurthy and one A, one B is Manjunath, that is correct. And then one Anasuyamma is shown as D. Anasuyamma, then Nanjundappa. Oh, he is dead. Okay. Lakshmi Narasimhappa.
Dead.
Idara illa.
Illa dead.
Sriramaya.
Yes, my lord. Is there, my lord?
Sriramaya.
KN Sriramaya.
Kursi, he seems to be the aged
Easy.
person. Kursi ಕೆಳಗೆ. Sriramaya. So, ಬರ್ಕೊಳ್ಳಿದ್ದಾರೆ. ನೀವು we have made some mistakes in the complaint while amending that. Accused number 1B Manjunath. Accused number 3A1 KN Sriramaya. ಇನ್ನೊಬ್ರು ಯಾರ್ದ ಹೆಸರು ಹೇಳಿದ್ರಲ್ಲ, ಯಾರಿದ್ದಾರೆ?
Jagannathan.
Jagannathan.
3B3 my lord.
3B3 KL Jagannath. ಮತ್ತೆ ಯಾರಿದ್ದಾರೆ?
Manjunath 1B1 my lord.
ಆಯ್ತಲ್ಲ, ಅದು ಅಷ್ಟೇ ಮೂರೇ ಜನ ಇರೋದಾ?
3 ಜನ ಇದ್ದಾರೆ.
Alone are present. The other accused are not present despite the direction to be present, and then you produce.
Last date of hearing, a small typographical error has happened. The complainant who is a mischief in this matter, where this honorable court has taken cognizance how he has misused and abused the process of law, this honorable court dictated and directed the complainant shall present before the court.
We'll read the order for your benefit.
Now the accused has been ordered. It's purely because both the advocates were present. One Venkatachala was there.
Or the said
Venkatachala was there. He played mischief, and all these things happened at his instance. He is a court bird.
ಒಂದು ನಿಮಿಷ ನೀವು ಹೇಳೋದು ಇದ್ರಲ್ಲಿ ಕಾಣ್ತಾ ಇಲ್ಲ. ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ we are not finding that. Complainant has filed a memo on so and so praying to permit the complainant to engage the advocate in the opinion of such a change. There was engaging the advocate itself. It had taken some time, it seems. There was some controversy.
Complainant accused, the same advocate has appeared in different proceedings. That's why this court has taken very serious cognizance, and the advocate has filed an application, applied it, and has withdrawn. Now, the entire proceedings are initiated at the instance of one Venkatachala. A Venkatachala is a court bird and is a person who created multiplicity of litigations. And now this honorable court directed that Venkatachala to present before the court. Instead of that Venkatachala,
it is not forthcoming in the order.
But I make my statement. Instead of that Venkatachala, by typographical mistake, the accused shall present on Bambiti. That's the point.
Keeping in view submission made by the council is directed to clarify the status. We are not finding that. ನೀವೇ ಆರ್ಡರ್ ಶೀಟ್ ಓದ್ಕೊಂಡು ಬಿಡಿ ಬೇಕಂದ್ರೆ.
Last ನನ್ನ ಹತ್ರ ಆರ್ಡರ್ ಶೀಟ್.
Order dated?
ಇವೆಲ್ಲ 6 ಅಲ್ಲ ಸರ್.
8/4/2025 my lord.
8/4. No, thereafter many orders are passed, no?
25.
After 8/4.
8/4/25 is the last.
8/4. No, thereafter 21/4 another order is passed. 21/4/2025.
8/4 ನಲ್ಲಿ ನಮ್ಮ ಒಂದೇ ಒಂದು ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ತಮ್ಮ ಗಮನಕ್ಕೆ ಅದೇ ಅಂದ್ರೆ this the matter on 21/4 ಅಂತಿದೆ. Complainant namely Shri Yellamma, who has initiated the contempt proceedings, he is said to be aged about 101 years. Shri Venkatachalapati, being her son,
is physically present before the court.
Before this court, to which the proceedings accordingly his status is
correct. Where it says that complaint should be present. Or could see, make him to sit there if the chair is there.
ಯಾಕಂದ್ರೆ ನಾವು ಇಬ್ರು ಅಡ್ವೊಕೇಟ್ಸ್ ಇದ್ರೆ ಇದು.
It's not there, learned counsel. Such order is not there. You keep them present or you have to file an exemption. This is a criminal contempt. Have you read the rules of criminal contempt?
Please, my lord, please. I will file
You have to file
my application.
appear personally. Appearance of the accused. Rule 9(1), in every case of criminal contempt, the accused shall appear in person before the High Court on the first date of hearing and on every subsequent date which the case is posted, unless exempted by an order of the court. Where is the order of exemption?
I can answer now.
Now, whether you are going to file an application for exemption.
Application, I did not file it because.
Correct. Are you now going to file? Please don't take much time. Are you going to file application for exemption?
In the afternoon, I'll file it. Kindly pass over the matter is one aspect. Second aspect is, these are the matters where a civil proceeding before these.
Correct. You can argue the merits of the matter.
The
We do
parties.
not.
Now, by say miserable intent, they may converted this fiction into criminal proceeding. It's not at all maintainable.
Order is already passed. Earlier they were registered as civil contempt. They are converted to criminal contempt. You have not challenged that order. Now it is for the preliminary hearing. If you say that there are no grounds to proceed against the accused, you have to argue that. Now we file application for their exemption.
Kindly pass over, my lord, in the afternoon session.
Law counsel for all right. Law counsel for the complaint seeks permission to retire. However, issuing a notice to the complaint. I'm sorry, issuing survey. No proof of service of retirement notice is produced. Therefore, his prayer is rejected. If you want to retire, you have to issue a notice and retire. Otherwise, we'll appoint somebody then.
Venkatachalapati is present in case in the afternoon. His presence will be secured because.
Mr. Counsel, there is no such order.
No, I'm making this because last occasion also.
You first seek.
Last occasion, in presence of both the councils, that order was passed.
It is noted.
However, it is inadvertent mistake. It has happened. Now I am making submission so that he is present because he.
But first, you file exemption and argue your application. He says he wants to retire. We'll grant him some time if he wants to retire.
I file exemption in the afternoon. I'll argue the matter on that point.
Next, passed over. Still number 20. Jairaj DS. Dinesh Kamkar.
Seems to be something. Have you seen the previous order sheets? Engaging advocate also there was also issue. The complaints advocate had appeared to his for his adversary in some other proceedings, etc. But anyway, once it becomes a criminal contempt, it is between the court and the.
Lordship, I prefer petitioner. Lordship is the.
One submission. That's a rich time to file my objection. Senior is out of session.
Allah Lordship, kindly see, because the court order has been taken and due to this one, they have taken up to Supreme Court. Supreme Court has confirmed the order and he has acting upon the agent to agent, he has not handing over the key. Instead of that one also, police protection, everything filed before the trial court. The trial court is keep pending and entertaining other persons to enter this one. We are having the fruitful of 83 suit. Till today, I am not getting the. Lordship.
Previous case previous case also filing multiple litigations.
Out multiple ಇದು ನೋಡಿ ಇದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗಿ ಆರ್ಡರ್ ಆಗಿದೆ. In spite of that, we have filed the execution.
In execution petition.
Execution petition ಅಲ್ಲಿ ಮತ್ತೆ ಇನ್ನೊಂದು ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಪಸ್ ಅವರಿಬ್ಬರೇ ಮಾಡ್ಕೊಂತಾರೆ. ಅವ್ರು ಶೂಟಿಂಗ್ ಪಿಜೆ ಇಲ್ಲ ಅವರೇ ಮಾಡ್ಕೊಂಡು ಡಿಗ್ರಿ ತಗೊಂತಾರೆ. How can subsequent suit is ಏನು ಅಂತ ಗೊತ್ತಾಗ ಮತ್ತೆ he has not handing over the key. So come before the court and saying that I want time. And your Lordship, judgment debtor is also present before the court. He has every time, like in the last attempt also court ಅಲ್ಲಿ war ಮಾಡ್ಬಿಟ್ರು. Then this court again it will time ನಮಗೆ 83 ಇಂದ ಪೊಸಿಷನ್ ತಾಳಿಲ್ಲ ಅಂದ್ರೆ ಸೂಟ್ ಹಾಕೋದು ಯಾಕೆ ಯಾತಕ್ಕೆ ಏನ್ ಮಾಡೋದು ಗೊತ್ತಾಗ್ತದೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ತನಕ ಹೋಗಿ ಬಂದಿದೆ.
Where is the Supreme Court judgment?
Judgment, your Lordship, page number 133. Dismiss ಆಗಿದೆ.
Objectors applications, writ petitions,
ಅದು ಪ್ರೊಟೆಕ್ಟಿಂಗ್ ಮಾಡಿ ಅದು ಪ್ರಾಪರ್ಟಿ ಇದ್ರಲ್ಲಿದೆ.
Judgment
133, your Lordship. Page number 133.
Had sought some mandamus to pass orders in
Yes, correct, your Lordship. That's why 133.
Annexure D. Annexure D.
Compromise.
Then order copy can't. Heard no merit, special petition is dismissed.
Oh.
This is RFA number 990 of 2000.
I mean RFA preferred. ಹೌದೌದು. ಆಮೇಲೆ ಇದಾದ್ಮೇಲೆ ಲಾರ್ಡ್ಶಿಪ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆದ್ಮೇಲೆ ಅವರಿಬ್ರು ಒಂದು ಸೂಟ್ ಹಾಕೊಂಡು ಡಿಗ್ರಿ ಮಾಡ್ಕೊಂತಾರೆ, ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿ ಮಾಡ್ಕೊಂತಾರೆ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್.
We are seeing so many.
ಅಲ್ಲ ನಮಗೆ ಪೊಸಿಷನ್ನೇ ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲೆಲ್ಲ ಇದಾಗಿ ಎವ್ರಿಥಿಂಗ್ ಎಕ್ಸಾಸ್ಟೆಡ್.
One second.
ಅಲ್ಲ ತಮ್ಗೆ ಹೇಳಿದ ಗಮನಕ್ಕೆ
Sorry, madam.
ನೀವು ನಮಗೆ ರಿಫ್ರೆಶ್ ಮಾಡೋದು ಓದ್ಕೊಂಡು ಬಂದಿರ್ತೀವಿ.
ಅಲ್ಲ ಕರೆಕ್ಟ್ ನೀವು
Apologies, madam.
ನೋಡಿ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ ನೀವು, ನನಗೇನಾದ್ರು ತಪ್ಪಿದ್ರೆ ಹೇಳ್ಬಿಡಿ.
We heard you will hear him also. Why do you want adjournment and whether accused
Madam,
is present?
Present, madam.
Why do you want adjournment?
I'm a proxy counsel, madam.
Then don't worry about that.
No, like he's went to ಧಾರವಾಡಕ್ಕೆ ಹೋಗಿದ್ದಾರೆ.
The party is present. Why when criminal contempt was listed, they
Okay.
should make some other arrangement. If it's not possible.
Short
for them to
accommodation, madam. I will.
case.
Sorry, madam. Short accommodation, madam. We'll file with my objections, madam. That.
Last time.
ಅಲ್ಲಿ
before that-
ಯಾರನ್ನಾರು ಏಜೆಂಟ್ ನ ಫಿಕ್ಸ್ ಮಾಡಿ ಅಲ್ಲಿ ನಡೆಸ್ತಾರೆ.
Any
ಇಲ್ಲಿ
date, madam.
ಬಂದು
Short date.
ಇಲ್ಲೊಬ್ರು
Next
ಫಿಕ್ಸ್
week.
ಮಾಡಿ ಇಲ್ಲೊಂದು ನಡೆಸ್ತಾರೆ.
However, keeping
ಲಾಸ್ಟ್ ಟೈಮ್ ಕೈಂಡ್ಲಿ ಸಿದಿ ಲಾಸ್ಟ್
the learner counsel for the complainant
ಹೌದು.
ಅಂತ ಮಾಡಿದ್ದಾರೆ list on.
ಹೌದು ಲಾಸ್ಟ್ ಕೇಸ್ ನೋಡಿ ಸ್ವಾಮಿ.
Respondent along with
ಹಾ.
submission shall be present before the court.
ಹೌದು
Kindly one short accommodation. That's all, madam. One short accommodation. Madam.
Accused
Any date, madam.
Nagaraj is present before the C. Nagraja present
Yes.
before the court. What is your name?
Raghavendra M.
Raghavendra M.
Proxy counsel.
One Raghavendra M. On behalf of Mr. Gavkar Dinesh Nilkant, advocate on record for the accused, seeks adjournment on the ground that the said advocate is not in town. Learner counsel for the complainant seriously opposes the adjournment. It is the grievance of the complaint that though they succeeded, their original complaint was the party in the suit.
Yes, sir.
Though the original, Hanumantappa.
Father-in-law of the complainant.
She was also party. Ambujakshi was also. Unsent application.
Execution she was.
Okay. Though the complaint's predecessor succeeded in the suit, in which year?
Verse number 51 of 1983.
83 suits, your lordship.
That was in 2000 judgment was pronounced.
Yes, your lordship. 1983 suit.
In the year
Confirmed
2000,
RFA.
fighting
Then
the
Supreme Court.
OS were 51 of 83. That is again around 20 years. Because of the conduct of the accused.
Yes.
They are not able to reap the benefit of
One or the another, they
the decree is
implead the agent.
up to the Supreme Court. Considering such submission, however, to grant a last chance will impose heavy cost. Time granted on payment of cost of rupees 10,000 payable to the complainant. List on
ಈ ವೀಕಲ್ಲೇ ಮಾಡಿ ಸ್ವಾಮಿ.
the next week.
ಯಾಕೆಂದ್ರೆ ನಮ್ಗೆ ಅಟ್ ಲೀಸ್ಟ್ ಇದೆಲ್ಲಾರು ಕೀನಾರು ತಗೋಣ ಅಟ್ ಲೀಸ್ಟ್.
25/6. Time granted should be proportionate to the.
ಲಾಸ್ಟ್ ಅಲ್ಲ ಲಾಸ್ಟಿಪ್ ಕೈಂಡ್ಲಿ ಸಿ ದಿ ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಆರ್ಡರ್ ಇವ್ ಲಾಸ್ಟಿಪ್. ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡ್ಬಿಡಿ. ಐ ಓನ್ಲಿ ರೆಪ್ರೆಸೆಂಟೆಡ್
16.
Next,
ಒಂದು ವಾರ ಬಿಟ್ಟು
23, 24.
21, 23 will she?
Sit on 23. Monday.
23.
23.
I'm sorry, my cost.
Either you have
short
to
form.
argue the matter or you have to
He's a
pay the
proxy
cost.
counsel, how can they
Elder
fix
illandu will proceed against him. What is this?
No.
They're showing us, the records show that the suit was of the year
83.
83. How the litigants will sustain
50 years
these kinds
ಆಯ್ತು.
of litigations?
No, you went to Dharwad. That's
Who asked him to go to Dharwad? It is if you find it inconvenient, you evade it in this way.
sorry.
Ask him to pay 10,000 rupees cost.
23/6.
Hearing on
Much
A,
obliged.
seal number 21, Omkaresha, government advocate for A1 to A3.
Was in heavy cost. They were to the money.
The complainant, my lord.
That's right. Yes. Yeah.
In spite of
CD in filing, recalling application. filing.
directions, my lord, none of the directions has been followed. And
Applications, recalling application.
yeah, recalling, my lord, I am the applicant.
7. You have filed objection 17/12/2015. After so many years, yes.
No, it is
in the Supreme Court, this is set aside, no? Imposition of caste.
Yes,
Is it
yes.
the same case?
Yes, same case, my lord.
That's why you are
See,
seeking
yeah, yeah.
recalling. That's why you are
Cost
seeking-
was imposed and before the apex court, the imposition of cost has been expunged. Rest of the orders that has been intact. The order passed by this honorable court is intact. Until now, the possession is not been handed over to the complainant, Your Honor.
Rejected on page
Your,
of
my lord.
law saying that complaint is abusing the process of it. Once after an inquiry truth has emerged, institution wants to withdraw the contempt petition. It is about till only he wants to withdraw the complaint. So there was some manipulation of administrator's order. Is that?
Yes,
the
sir,
same case?
that even C report has been filed, my lord. That's the COD has been filed a C report with
Supreme
respect
Court's
to no
order
documents.
Along with your application, no?
Yeah, along with the application I have filed. That report is also there. C report or that what the,
No, that order, Supreme Court order.
a Supreme Court order, your lordship will get it at ink page number 15. Ink page number 15, my lord.
15 of your application. Got it. Here. Annexure N.
There it is. Therefore, the special leave petition is disposed of expunging the adverse.
Dated
My lord?
17/12/2015.
Yes, nothing. The observation is kept out. The observation of this honorable court is remained intact with respect to passing of the B orders, my lord.
The only permission sought by the petitioner was to withdraw the application, which the High Court permitted on payment of cost. However, in view of the admitted portion that there was a delay of around 6 years in complying with the orders, we find that there is no justification for imposition of cost. Therefore, a special leave petition is disposed of, expunging the adverse observation made by the High Court and also vacating the order of cost. Now, what is your opposition? Who is your colleague? ಎಲ್ಲಿದ್ದಾರೆ? Correct. Now, this order of how many times we have to read the same files? Is she coming in the afternoon? Now this court dismissed the complaint with some adverse observation and imposing cost. Right. Now Supreme Court has set aside that judgment. So these have to be restored, no? What objection you have filed? And subsequently, this court, a single judge of this court has passed another order.
Please, my lord.
She will come in the afternoon. Then we take it up in the afternoon.
Please, my lord, please.
Passed over. Hearing on for framing of charges. Still number 22, P.N. Rajeshwara.
Maybe Supreme Court will stay there. Some Supreme Court.
This is a contempt petition.
Audition.
There was an order earlier, my lord, where this honorable court, my lord, held, my lord, that they are framing the charges. But then they went to the Supreme Court. They said, we'll get a stay. It's already, my lord, more than 4 months.
Last time also the same thing.
Oh,
was
the same.
submitted.
And they have not got a stay.
Is likely to be listed on 18th, madam. Day after tomorrow. That's what the diary, the website
The
shows.
order sheet. We are not able to lift it.
Not only that, what is also happening is, in respect of one other survey number, they are required to give us, my lord, back the land, my lord, that belongs to this trust. This is a charitable trust. There is, my lord, what is known as survey number 52/1. They are permitting, my lord, even now, my lord, permitting encroachment. There is an order passed by your lordship's court. In fact, my lord, we are showing the photographs. Just point out.
No, that's there.
I have the copy of the application today, madam.
No. See, you have to, if this matter is pending since 2021. If you want to opt in any interim order, you should do it
They have also appeared, they were caveat, my lord.
That is,
And
that they have
then
produced.
they have
it.
filed their reply, my lord. We were supposed to file rejoinder. That is also, I'll verify, my lord, instructions. Whether rejoinder has been filed, it will be taken up at the
Correct.
earliest
When
itself.
these matters, we give the date. It's not that they are abruptly
No, my lord.
listed. Then
Court
you should
has
take
given
all
me
those.
time. Just that Supreme Court is closed for vacation, my lord.
Correct. You should take all those instructions in
We are
advance.
following
See,
diligently.
last order was on 29/4.
We are
When the
following up
Supreme Court
diligently.
vacation started? When the Supreme Court vacation started? In June,
25th of May.
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 Right. 1
June.
month, what were you doing?
By then they had filed their reply, my lord. We were supposed
No,
to
they
file
had
rejoinder.
produced,
All-
There are vacation sittings also. In fact, they are sitting, my lord, for final disposals also.
It is not called in the Supreme Court now vacation, partial working.
Correct, correct.
It's getting listed on 18. That is what the website also shows, my lord.
Where is that?
Day after tomorrow.
Show us from.
Says, sorry, I'll just
Last
pass.
time
I
they
have
have
one copy, my
submitted
lord. I'll
in
just say
special petition number
tentatively
so-and-so.
to be listed on 18.
Interim order has not been granted in the, therefore. Both councils are directed to secure specific report in respect of special leave to appeal.
9th of April 2025, my lord, notice, and they were on caveat. They have appeared, my lord. They were given 2 weeks' time to file counter affidavit, and we were supposed to file rejoinder to that counter affidavit. My lord. Now it shows that it's likely to be listed on 18th. All efforts are being made, my lord, in this case.
Where are your accused? At least they should be
The
present before the court.
Exemption, ಆಗ್ತಾ ಇದೀವಿ. There was no.
They stay comfortably with exemptions and see,
No,
look
my
at
lord,
our difficulty.
I understand. One more opportunity may be given, my lord. We will move the matter, and then this is a case where, my lord, we have handed over nearly 262 acres of land, my lord.
There are
That's
impleading.
no solace. 92
I'll
acres,
just
my lord,
explain
still
to
in
the
the.
court, my lord.
Impleading
Okay.
applications are also pending. At least shall we pass orders on that?
Yes.
PW.
IA number 5, impleading accused number 9.
Primarily that you will never parties before any of the proceedings, underlying proceedings, appeal or institute. There was, of course, there was a brief period where some work had been undertaken. If I an affidavit, that we will not undertake that work. And some compensation will be, but that is sorted out last year. That applicant has been kept pending for a while. And so I'm here to assist the court in any requirement.
My lord, what has happened is, during the pendency of this, there were certain orders
Let
passed.
us recollect it because file has become so bulky.
So
What
big.
is that complaint? And order sheet bulkier than the complaint. Hold up, sir. Complaint. This is not. This is counter affidavit.
18/7 ಅಂತ ತೋರಿಸ್ತಾ ಇದ್ದೀನಿ.
ಅದು ಇಷ್ಟು ದಪ್ಪ ಇದೆ.
18/6 ಅಲ್ಲ. ನೋಡಿ.
Sorry. Is it a complaint? Memo for amended cost title. Amended cost title, DBMP copy.
18/6.
Amended petition.
18/7.
ಮತ್ತೆ
18/7.
ಹಿಂದೆ
Oh, this is Justice Dinesh Kumar our judgment alva idralli. Yes. Reportable anta. Include order in petition number 5000.
No, this matter pertains to the orders passed by the land tribunal with regard to the ceiling limit. Ultimately, the court came to conclusion that the lands held by the trust is not required to be subjected to the ceiling limit. By then, the state government had already taken possession by drawing 3 mazar, and we were directed to hand over the lands
As
back
per
to
the hazards.
Yes, 3 mazars were drawn, my lord, and we were directed to hand over the lands back to the trust.
Yes.
Now, my lord, in the present contempt petition, my lord, a court commissioner was appointed. the court commissioner has handed over nearly 262 acres and odd, my lord, to the trust. Insofar as the balance 92 acres is concerned, my lord, the principal secretary has filed a detailed affidavit saying how we are not in possession of those 92 acres. Out of 92 acres, 65 acres has been acquired and handed over to the APMC. Now nearly 300 acres of the trust has been acquired for APMC yard, my lord. The acquisition was also challenged by the trust. Writ petition has been dismissed and they are in the writ appeal. So as on today, my lord, acquisition notification is also upheld. Insofar as 92 acres is concerned, my lord, we had taken a defense saying it is impossible to perform simply because we were not in possession of the lands. It is the APMC which is in possession, which fact has also been made note of in the order of the Honorable Supreme Court. So several.
When this order was passed in 2021, you were in
21,
possession or not?
No, my lord, we were not in possession. I'll just
Why
answer.
did you
my lord.
not bring that to the?
No, we had brought all these aspects.
That contention was rejected.
That was rejected and court felt that there is material to proceed despite taking a stand that we are not in possession of 92 acres.
No, your contention is rejected. That means
That's why, my lord, we are in appeal. We have taken that order of 7th of March passed by this honorable court, my lord, holding that there is an ample material, despite we having taken a defense that we are not in possession of 92 acres. Nonetheless, my lord, my apologies, that order sheet shows 18-7, my lord, before the Supreme Court. It's not 18-6. I mistook it for 18-6. Now all efforts will be made moment the court reopens, my lord.
the matters they mention and move it. Why don't you do
Allah
that?
mention madi move marti. Now it is not our case that we are not willing to hand over the lands to them. my lord.
Diary number, it is still in diary stage.
And in the meanwhile,
2025, registered on 29/3/2025.
My lord,
This judgment
may I
was
just
passed
pass
in-
on this on 29th of April, my lord,
This
by
judgment
court
was
office.
passed in 2021. You have challenged it in
Illa,
2025.
not 7th of March order, my lord, passed by this honorable court. Your lordship may kindly take 7th of March 2025, my lord.
was upheld by the division.
No, what we are asking is whether you have challenged this order, this writ petition order.
7th of March 25 order has been challenged.
Please answer our question.
Yes.
Now they are in this contempt saying that you have violated this judgment dated 30th/6/2021. Whether you have challenged this order.
Order we have lost also, my lord. Challenged and
The
lost, my lord.
scope for all this, you have to say that you are not in possession.
No, my
To the
lord.
Supreme Court, and they filed an application for clarification
My lord.
for single judge. That was also dismissed.
My lord, insofar as that
Same
order
content.
in respect of which contempt petition has been filed,
That has attained finality.
finality, my lord, has attained finality. Now in the present contempt petition, my lord, in the present contempt petition,
7/3/2025.
7/3/2025 order, my lord, passed by this honorable court, is pursuant to the affidavit that the principal secretary had filed, my lord. This honorable court takes note of all the contention, my lord, and says that there is an ample material to proceed for framing of charges.
7/3/2025.
Lordship may kindly take the,
Oh, it runs in so many pages. This.
all our contentions are recorded, my lord.
So this is regarding framing of charges.
Framing of charges, a detailed affidavit was filed, my lord, saying how we are not in a position to hand over 92 acres. We have handed over 265 acres back to the trust. We are not in possession of 92 acres. All that has been recorded by this honorable court. And by virtue of this order, my lord, court has said that there is ample material to frame charges. As against this order, my lord, now the SLP has been filed. Lord, that is going to be listed, and I would only request for.
You try to justify this now in the contempt.
No, my lord.
You admit that this order is not complied, but you are seeking some justification. Then that
Not
comes only by
justification,
way of defense, now after
No, my
framing
lord.
the charges.
There are three valid defenses available in a
Correct,
contempt
Mr.
proceedings.
Counsel. See,
The-
whether there is willful disobedience of the order. That way, at what stage that comes, that justification you have to substantiate in the evidence. Charge has to be framed for that.
No, my lord, but APMC has acquired land and they are in possession.
Correct.
How can I give
See,
possession of that land of which I am not in?
it may become a justification for you and you have to substantiate that contention. Now that is also
I understand.
rejected. Now we are not at the trial stage. You are at the stage of framing the charges.
My lord, in any event,
Then why are you dodging this framing of charges?
Lord, because of the pending SLP as against that order. My lord. 7th of March 2025 order now, my lord, we have filed the SLP. I have given the order sheet, my lord.
Probably you know what happens in
No,
all
one
probability.
more, the moment the court reopens, my lord,
Knowing little bit of the criminal law, at the stage of framing of the charges, this all justification comes in the defense. Why the charge should not be framed? Now you admit that this order is not complied. You are only trying to say that you had some valid ground for non-compliance. At what stage, whether it can be accepted
before,
only at the
before
stage of
framing
hearing.
of charges, we were heard, my lord. Before framing
So
of
now,
charges.
on hearing before charge, court has held that there are grounds to proceed to frame the charge.
Yes.
Then we'll frame the charge. You can take up all this defense and justify it during the course of evidence.
We have challenged that order, my lord. So therefore, my only request is
Right,
that some
after
time may
challenge-
be given to move the Honorable Supreme
Challenging,
Court.
what have you done?
We have moved, my lord. We have filed the SLP on 29th of
Here,
April.
date, 2 weeks time is
2 weeks time was granted to them
After
to file
filing the counter.
reply, my lord. They have appeared before the Honorable Supreme
when did you file the counter? When did you file? No, this order dated 9/4/2025 says that counter affidavit to be filed
Within 2
2
weeks.
Rejoinder that if any be filed in 2 weeks after filing of the counter affidavits. Totally 4 weeks.
That's also.
From
By then,
9/4 from 9/4, Supreme Court had granted 4 weeks time to both of you.
yes,
They should file the counter within 2 weeks.
should have filed that
Thereafter, you should
rejoinder by
file.
then.
Now that 4 weeks has elapsed. Now we are in June. That was on 9/4.
my lord,
Where is your
subsequently this Honorable Court, my lord.
Where is your accused?
Lord, I have kept the exemption ready, my lord, because there's no,
He can
because of, no, your lordship may kindly see the
we'll
other
impose
two orders
cost
which have been
payable by
passed,
him.
my lord.
All right, we'll record all this.
Note, I just my one submission. Your lordship may also take the order dated 25th of March, 9th of April and 29th of April. All these facts I have placed it before the court with regard to the pending SLP. Court has taken the pending
Now also you are
SLP.
submitting, we take note
That's all.
of that and we'll
My
pass
only
further
humble
orders.
request is that one more opportunity may be given. Moment the court reopens, we'll press for early hearing with regard, already there's a matter
Please to
pending.
say this, your accused should be present before the court.
I'll,
And that too, only we asking you where is the accused, you are saying that you are passing on the application.
I'm sorry, my lord, I'll
This
keep them
matter is
present, my
listed
lord, if
today
your lordship kindly
for,
directs them.
Framing of the charges. The accused
And
is
my
absent.
exemption application may be
Learned
taken
counsel
on.
for, AAC, learned AAC. The records have become so bulky now. Yellow itadu, ಮತ್ತೆ contempt, fiction. Who is They admit that they have not complied the order, but they try to justify. That may come in evidence.
No, my lord, before justification, in terms of
No, so many accused are there.
the accused are
At
principal
present,
secretary and
all those accused. That application order has to be passed on his application. I'm sorry, on your application to implead them. Sorry. That's what. Either we have to reject it. If not necessary party, we may have to reject that. But pending, keeping that application pending charge cannot be framed. That's it. Are we asking why they are impleaded, PBM?
Because 2/2/23 if your lordship will look at.
IA 2 of 2023.
2/2/2023 order sheet.
Order sheet dated. This has become more than a commercial appeal.
Lord, they've been filing after filing, Lord, applications. What do we do?
2/2/23.
Yes, Lord, 2/2/2023.
Because sheet dated 2/2/23. 2/2/23, we got it also. ಇದರಲ್ಲೇನು so and transmitted the order dated also passed by the court, PBMP is still proceeding for formation of the road or any construction in the land in question. Oh, they have formed the road according to you.
Therefore, my lord, your lordship, my lord, in the last paragraph.
What was the order dated 27/1/2023? Because we have to go back again. 27/1/23. Where submission is placed on Deputy Commissioner who is present in the court shall take necessary steps to intimate Shri Tushar Girinath, Chief Commissioner, so and so, to stop further formation of the road or any further construction in the lands in question, which is the subject of this contempt petition. In spite of this order, if anything further formation of road or any further construction takes place, BBMP is taking its own risk in contempt petition.
Then it's, there was no further down the road. There was some other submitting of the land pointing back. There was some overlap with this APLC land. But all that has been sorted out was, and there was also a direction in all fairness for us to, because some portion of the land is utilized, or this disputed land will utilize that. To give a background, the litigation between the state and the petitioner or the complainant side. Now, in the meantime, the GBMP, I'm not sure how much, but they utilize some portion of the land admittedly. And even given undertaking that even commence the process of issuance of TDRs if they are to utilize that. Now, the procedure under the KTCP Act was followed. And when we issued what is called Form 1, the APLC came forward and objected saying, this is actually our land, which is what Mr. Rohn was talking about when the litigation was going to be application. You cannot issue TDRs when the land belongs to the APLC. So that has to be worked out. So we are ready to give TDRs if your lordship of the direct, but the APLC have an objection.
But why did you proceed further when there was a preventive order?
The work stopped. That's why.
They formed the, he says part of the road was formed, contrary to the order passed by your lordship. Thereafter, my lord, again, my lord.
No, after this order you formed the road.
No work is up. Absolutely no work is going on.
What is that you are to, what is the material? What is the material you have placed to show that after this 27/1 order they have formed the road?
Photographs are there.
Photographs, whether they would be sufficient, their photographs with date or with the dates, huh? Vivo, May 8, 2025. This is
At times, some blue color sheets were placed, but road formation, I'm submitting nothing.
No, why are they working on the site? No, they have produced these photographs 8/5/2025 at 12:35 p.m. It shows.
That's not detailed. Very clearly, it's not detailed.
Those photographs are at page number 104 onwards.
ಇವತ್ತು ಹಾಕಿರೋದು ಬೇರೆ ಸ್ವಾಮಿ.
ಇವತ್ತಲ್ಲ, ನೀವು ಹೇಳ್ತಿರೋದು.
What we have filed today is, my lord, the government has permitting, my lord, encroachment. But if your lords look at, my lord,
You want to implead them as a party saying that.
But my lords may look at, my lord, the application filed on 1st of February 2023, my lord.
1st of February 2023. What is that IA
numbers?
You leave alone IA. What is that IA for?
Additional affidavit for the counter affidavit.
ಎಷ್ಟು ಡೇಟ್ 20?
1st of February 2023 ನಲ್ಲಿ ಒಂದು we had filed, my lord, one additional affidavit.
Additional affidavit.
1st of February 2023 na? ಹೌದು.
Page 14, if your lords come to, my lord, in this.
That is 1/2/2023.
Yes.
Page 14.
14, photographs, my lord, as on 28/1. Night, my lord, they come and carry out the work.
See, once it is said that don't carry out the work, why they should put this sheets?
During that period, yes, possibly some sheets were put up, what are you something?
Correct. That also they should, at least they should ask you. They
I don't even want to stand on the technicality as of now. This between the parties, we will never involved, but even see that as if any work was done contrary to any orders passed by this honorable court, it was stopped. And 25 years, he will write faster for and say, whatever land you are in possession of, some smaller estate, we are ready to give TDRs. So, but as I
Yeah.
submitting,
Giving TDRs, we are seeing so many litigations now.
both directions with TDR product, so we started the process. Now, the process came to an abrupt end once the AAPMC stated.
Correct. If you go on like wheels in wheels, there's he came, so she came, they came, so we are not able to execute the order. That's all your own making.
None of the orders where the contempt is alleged have the BBMP as a party.
So now they want to implead you on the ground that they have violated this order.
They wanted to implead us first because a portion of that land which they are now claiming from the government.
Where is that?
Now in the possession of the BBMP.
IA number ಎಷ್ಟದು? ಆಯ್ತು ಇಂಪ್ಲೀಡ್ ಮಾಡಿ ಬಂದಾಗ ನೋಡ್ಕೊಂಡ್ರೆ ಆಯ್ತು ಬಿಡಿ IA 5 of 2020. Where is that IA 5? Because keeping that pending, we can't pass, I mean, proceed to frame the charge. That's what. IA 1 of, there is one more impleading applicant, IA 1 of 2024, that is disposed of. This seems. Or substituting the part. This is exemption.
No, current is not needed. Whoever was.
IA 1 of 2023, sorry, IA number. ಇದು ಏನಿದು? You also could have done that if there was that contempt, that constitutes another cause of action, you could have proceeded. Otherwise, this complaint will be delayed.
Can I submit this one? Permit us to withdraw with liberty to file my lord afresh.
That's why, otherwise this case also gets delayed.
Please do that. I'm grateful to you.
Orders
Please
and-
stand on technicalities, but I'll agree.
Right.
Straight away.
This matter will be delayed because of that.
Permit me to.
ಶ್ರೀ ಉದಯಹೊಳ ಆಯ್ತು ಬಿಡಿ ಅದನ್ನು ಸಫಾಯ ಉದಯಹೊಳ senior counsel appearing for ಶ್ರೀ ಯಾರು ಇನ್ನೊಬ್ರು ಇದ್ದಾರೆ so and so advocate for the complainant submits that IA 5 of 2023 is filed to implead the you want to implead BBMP not as a person. You are.
No, but then thereafter we said Tushar Girinath specifically we made.
ಈ ಅಪ್ಲಿಕೇಶನ್ ಈಗ ನಾವು ವಾಟ್ ಇಸ್ ಪೆಂಡಿಂಗ್ ಇಸ್ IA 5 of 2023 ಅಂತ ತೋರಿಸ್ತಾರೆ 5 of 23 ಅಲ್ಲಿ ಇಲ್ಲಿ ಬಾಡಿಯಲ್ಲಿ ಹೇಳಿದೆ ತುಷಾರ್ ಗಿರ್ ಎಸ್ ಓ ನೌ ದಿಸ್ ಆಫೀಸರ್ ಇಸ್ ಆಲ್ಸೋ ಚೇಂಜ್ಡ್
No, madam.
ಬಟ್ he can be impleaded even otherwise. So submits that since the Commissioner of BBMP violated the interim order of this court dated 27/1/2023. IA 5 of 2023 was filed to implead him in this case. It is further submitted that since that constitutes a different cause of action and due to the said application, the main matter itself gets delayed, permission may be granted to withdraw the said application with liberty to take necessary remedy. Recording the submission, IA 5 of 2023 is disposed of as withdrawn with liberty to take up appropriate remedy. Okay. Sumne ee applications all now you are relieved.
Insofar as the accused are concerned, look, today there's a meeting with the deputy commissioner.
You write it first. You were writing this.
And subject to section 14 of the limitation. Section 14.
That will be excluded
Oh, then
and subject to 4 section.
Please.
That you can even otherwise you can urge, no?
ಬಿಟ್ರೆ ನಾಳೆ ಆಮೇಲೆ ಅದೆಲ್ಲ ಪ್ಲೀಸ್ ಮೇಡಮ್ ಗೇಟ್ ಕೊಟ್ಟಿಯಲ್ಲ
ಇದರಲ್ಲಿ ಫಸ್ಟ್ you were taking dictation first. This you record this first, then you take when ಹೇಳಿದ್ನಲ್ಲ accused is absent ಅಂತ.
My lord, there's a meeting today by the.
Two submissions. ನಾವು ಕೇಳಿದಾಗ
Allah, I kept it ready, my lord. I just because there's a meeting with the with regard to tomorrow's stampede, my lord. No, stampede which had taken place. Sorry, no. Tomorrow's PIL is being listed. Sorry, I didn't make the right submission. Tomorrow PIL is being listed. My lord. I have stated so in my. I have too many things, my lord. I just. I'm sorry. I made a mistake. I stand corrected. I filed, my lord, there's a meeting being held with regard to taking stock on the, that matter is also being listed tomorrow, my lord. That's why I've,
No, what is that meeting being held regarding tomorrow's? What is tomorrow's? You are not completely.
Adu Deputy
The
Chief
quarterly
Minister
meeting.
has taken
No,
adu
quarterly
meeting
meeting
today,
ಅಂತ ಹೇಳಿ.
16th of June 2025. There's a meeting at 10 AM. I produced it as document number 1. Therefore, I'm seeking for exemption.
Document number 1 is quarterly meeting, KDP meeting.
Allah, this document,
Document
page
number
3,
1,
my
meeting
lord.
notice dated
Page
5.
3, my lord.
You could have deputed somebody there. He could have deputed somebody there.
Allah, meeting irodrinda we.
Correct, ಅವ್ರಿಗೆ every day meeting ಇರುತ್ತೆ executives.
Out.
Then
Next
whether
date,
they can
my lord,
evade-
may make one submission. my lord. Today they have filed anyway, IA. My lord,
ಬರ್ಕೊಳ್ಳೋಣ.
may-
ಹೋಗ್ಲಿ, ಅದು ಎಷ್ಟೊತ್ತು ಹೇಳಿದ್ರು ಸುಮ್ಮನೆ we keep spending our time. Law counsel for Mr.
Document
Leonard
2
ASC
pertains to.
submits application for exemption of the accused. Your addition. Which accused? Now there are many accused. ಅದನ್ನ ನೋಡಕ್ ಹೋಗ್ಲ. This case. ಇದಲ್ವಾ contempt. ಎಷ್ಟು ವಾಲ್ಯೂಮ್ಸ್ ಇದೆ ನೋಡಿ ಇದರಲ್ಲಿ. 9 volumes. Domestic violence for us. This is. On whose behalf you are filing this exemption application?
On behalf of the.
Because there are in
My
all.
lord, Principal Secretary, Deputy Commissioner and Assistant Commissioner and Tahsildar. I have stated in my para 2. my lord.
Accused number.
They have
Accused
been
number
assigned
evidence. Accused
as
number
inquiry
ಎಷ್ಟು?
officer in connection with
No, which of the accused you are filing? Just you
all
say
the
addition-
accused, my lord. All the accused I am filing the,
Whether all the accused have this meeting?
that's what I am
There are in
instructed. my
all
lord.
8 accused.
No, my lord. Insofar as 4 are concerned, my lord, that is the
You do not
accused
even-
number 1.
Mr. Counsel, in your application, you do not say for which of the accused you have filed exemption application. See, we are not going to get anything by keeping them here, but there should be some proper representation.
There's
Whom of the accused you are seeking exemption here?
1 to 4, my lord. That's. I'm sorry, ma'am.
Lila.
That should have been stated. I'm sorry, it's not stated
Is
so,
it?
but I have named, sorry.
And the Learned Counsel for Learned ASC submits application for exemption for the accused. The application is as bold as possible. It doesn't indicate for which of the accused. Another Rajendra Kataria, accused number 8 ಅದು, and Jagdish G. ಮತ್ತೆ ಯಾರು? Pramod Patil, Assistant Commissioner, and Madhuraj.
Tahsildar.
ಅವರೆಲ್ಲ ಇಲ್ಲಿ ಚೇಂಜ್ ಅದಾರ? They are not here now. On
Now
record.
they are not there.
No.
They are all changed.
ಅದು ಬೇಡ, at least 4 members ಆಗ್ಬೇಡ. Does not, the said application is only with reference to 4 accused. Further adjournment is sought on the ground that the SLP is pending. The copy of the order dated 9/4/2025 furnished by learned AAC himself. Copy of the order dated 9/4/2025 in special leave petition into bracket C number 88/32/2025 produced by learned AAC himself shows that on 9/4/2025 the Honorable Supreme Court granted 2 weeks time to the present complainant to file the counter affidavit and further 2 weeks time to the accused herein to file the rejoinder to the same. That 4 weeks, now 8 weeks have elapsed. Now it is
8
more
weeks.
than 8 weeks.
After that also.
However, to whom we shall impose the cost now?
Lord, I'll pursue that SLP, my lord, in terms moment the court reopens. The Supreme Court, my lord,
This court,
all that I'm saying, my lord, we
it
have,
is clear that the accused are adopting dilatory tactics
Lord,
to grant a final chance. Time granted on payment of cost of rupees Why they should litigate for all these years? You say that order has attained finality.
My lord, we are not in possession, my lord. If APMC is in possession, how am
do you
I?
take?
My lord, that's exactly the ground
But
that we
that
had raised.
contention has failed now.
No, that was never considered
And
in the
even
earlier order.
assuming that that is the justification, okay, that also will record. The AG submits that the land is in question is not in possession of the accused, therefore they are not in a position to hand over the possession. That may constitute a defense for the accused in the trial, but that is not a ground to for the accused to absent themselves. To postpone the stage of framing of the charges. As a last chance, time granted on payment of cost of fees, how much should we impose according to your status and standards? Payment of cost of fees 5,000 payable by each of the accused to High Court Legal Services Committee. Okay. Accused should be present on next hearing date without fail. List on. ಎಷ್ಟು time consume ಮಾಡಿದ್ವಿ ನಾವು ಇದರಲ್ಲಿ?
ಇಲ್ಲ.
Right? They should come to the
ನಾವು
box.
ಕೋಆಪರೇಟ್ ಮಾಡ್ತೀವಿ ಇದು.
Plead the evidence. If there is justification, there is no willful disobedience, then court may accept that. But they can't go on postponing or delaying the framing of the charge itself. Yeah. What is that you have given now?
That they are encroaching, my lord, and permitting encroachment despite, my lord, orders passed in this honorable court itself, in this contempt.
You want us to take this again? Mr. Rajeshwar. First you were. Now it is in 9 volumes we are told. In the trial you can produce.
July 13th.
And you can also move that.
But the Honorable Supreme Court reopens on 13th July. My lord. Till then, I may not be able to really.
Partially working. No, you can
Partially
produce
working
this
with
order
you,
that-
there'll be some matters which,
No,
keeping
you can-
that in mind, my lord, keeping that in
You
mind.
cast, at least you pay cost. Are you
I'll
going
pay
to pay the
the-
cost today?
The cost may be called out in the third week of
This
July.
is
my
too
lord.
much to say for 88 officers that there is some meeting and therefore we are not coming.
No, my lord,
They
this is
should
with regard to
depute
this.
somebody there and come here.
ನಾಳೆದು ಅದು
ಇವಾಗ ಕಾಸ್ಟ್ ಹಾಕಿದೀವಲ್ಲ ನೋಡಿ, ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಯಾವ ಮೀಟಿಂಗ್ ಇದ್ರು ಬರ್ತಾರೆ. ಇಲ್ಲಾಂದ್ರೆ ಒಂದು ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ಬರ್ತಾರೆ.
may I request
They
at
think
least after
that,
13th, my lord. May I request after 13th at least, my lord. Because till 13th I may not be able.
They are sovereign above everybody. Yes. 1/7.
Still number 23.
Court reopens only on 13th.
You can move there, Mr. Counsel. How many times you have to do?
No.
We are aware partial working is going on there.
I will make efforts.
Still number 23, Sanat Kumar Shetty.
Next time, they should be positively
They'll be present. They'll be present.
The accused shall be present. The hearing for framing of the charges on the next date of hearing without fail.
Yes.
Yes, it is. Oh, Sanat Kumar Shetty or
Filing
condition
complaints,
withdraw.
conditions removed, your lordship.
ಏನು ಇವ್ರೆ ಕ್ಲೋಸ್
I
ಮಾಡಬಹುದಾ
sincere
ಈಗ?
apologies, your lordship.
Close ಮಾಡಬಹುದಾ? See, they were entitled in 1991. So 25 days from that period, that date, it is already
Retrospective
over.
doesn't apply.
Mechanically, why they do it? Madam is also present today.
Please,
Again.
she has to sign the affidavit complaints.
Leonard, see, you will be ultimately held responsible. Whatever the others may say, you have to exercise it independently and you have to do it. Whether we are right or not, because they were entitled in 1991. If 25 years applies from that date. Leonard, you are AGA. Srimati so and so, learned AGA. Submits the affidavit of which accused is
First year, Deputy
the
Commissioner.
first accused.
Deputy Commissioner would be.
Will record her present.
Please.
ಓ ಹೆಸರು ಬೇರೆ ತೋರಿಸಿದಲ್ಲ. ಫಸ್ಟ್ ಅಕ್ಯೂಸ್ ಅಂತ ಬರ್ಕೊಳ್ಳೋದಕ್ಕೆ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ because his name is different.
Name is
Affidavit of
Dr. Vidya Kumar.
Dr. Vidya Kumari, the present Deputy Commissioner of Udupi District.
Please,
Udupi District, along with
documents, Hakkupatra ಮತ್ತೆ RTC.
Sagwadi chit issued chit dated 11/6/2025 and RTC. Okay. ನೀವು ನೋಡಿದಿರಲ್ಲ? Learner Council for the complaint. Where is that clause now?
7 ಅಲ್ಲಿತ್ತು earlier ಇದರಲ್ಲಿ. We have removed that clause.
ಅಲ್ಲ, ಪರಂತು ಮಂಜೂರಾತಿಯು ಸಾಮಾನ್ಯವಾಗಿ ಭೂ ಕಂದಾಯ ಅಧಿನಿಯಮದ ಮತ್ತು ಅದರ ಮೇಲೆ ರಚಿಸಿದ ನಿಯಮಗಳ ಉಪಬಂಧಗಳಿಗೆ ಅಥವಾ ತಾತ್ಕಾಲಿಕದಲ್ಲಿ
ವಸೂಲು ಮಾಡತಕ್ಕದ್ದು.
ಅಲ್ಲ, ಇತರ ಯಾವುದೇ ಅಗೇನ್ ದಿಸ್ ಇಸ್ indefinite alva. Why you include this class? Why you include this class?
As it's a format, your lordship.
You should tell us what are those rules, because you are the revenue department. Why this vague class?
This is a format as prescribed, your lordship. It is not nothing we have created.
Show us where is that prescription. ಮತ್ತೆ ಇದ್ರ ಮೇಲೆ ಇನ್ನೊಂದು litigation ಶುರು ಮಾಡ್ತಾರೆ. What are those rules? ಮತ್ತು ಪರಂತು ಮಂಜೂರಾತಿಯು ಸಾಮಾನ್ಯವಾಗಿ ಭೂಕಂದಾಯ, you can't read it. See, this litigation they are fighting since 1991. Okay, they have succeeded. The government was directed to issue them, land was granted to them, and they had to issue this certificate, land grant certificate. So they did not do all that. After so many years now, after this contempt, they issued one this grant certificate. In that they had imposed a condition that they should not alienate for 25 years. But they were entitled in 1991. In now 2025 they say that they should not again further alienate for 25 years. So they objected it. Now they undertook that they will remove that clause and come back. Now they have come up with this clause was there in the earlier grant order. Where is that previous? Another copy is previously on the affidavit kotidralla. Now they come up saying they have included this clause saying that this grant shall be subject to the general rules of Land Revenue Act and the rules made thereunder and any other interim rules made by them. So if again this may give rise to another round of litigation, they should tell what are those rules, if the rules are there. This last time it was there earlier.
As it is, please wait. As it is prescribed under the rules, your lordship. Your lordship may kind. It could.
Where is that?
It could.
That was clause number 8. ಮತ್ತು ಪರಂತು ಮಂಜೂರಾತಿಯು ಸಾಮಾನ್ಯವಾಗಿ ಭೂ ಕಂದಾಯ ಅಧಿನಿಯಮ ಅದರ ಮೇರೆಗೆ ರಚಿಸಿದ ನಿಯಮಗಳ ಉಪಬಂಧಗಳಿಗೆ ಅಥವಾ ತಾತ್ಕಾಲಿಕದಲ್ಲಿ ಜಾರಿ ಇತರೆ that was there earlier also. It was clause 8. Now it has become
only clause
7.
number 7 has been removed, your lordship. That 25 years not to alienate the property adu removed. That has been removed.
Rule 29 rule Kannada book you are giving.
English is
ನಮ್ಮ ಹತ್ರ ಇದೆಯಾ? No, madam cannot read. Madam cannot read Kannada. Rule 29
format prescribed.
This format is prescribed under rule 29.
Please.
What rule 20? Rule 29 only states form number so and so. 29.
Page number.
ಅನುಮತಿ ಪತ್ರದ ನಮೂನೆ ಅಧಿನಿಯಮ 93 ಪ್ರಕರಣ ಮೇಲೆ ಕೊಡಲಾದ ಅನುಮತಿ ರೂಲ್ ನಂಬರ್ ಸರಿ
ಇದು
ಫಾರ್ಮ್ ನಂಬರ್ 7
345
ಇರತಕ್ಕದ್ದು
ಇಂಗ್ಲಿಷ್
ಏನ್ ಹೇಳ್ತೀರಾ ಅವ್ರ ಆ ಕ್ಲಾಸ್ ದಿಸ್ ವಾಸ್ ದೇರ್ ಅರ್ಲಿಯರ್ ಆಲ್ಸೋ
only clause number 7 was removed not to alienate it.
ಏನಂತ what is that record? What is and RTC okay.
English.
Now there is one clause that should be subject to these rules anta learner counsel for the complainant sorry Beginning, Srimati so and so Padmavati, no? What is her name? No, Deputy Commissioner. She is present before the court, that you have to record. Her Vidya Kumari, Dr. Vidya Kumari, Deputy Commissioner of the district is present before the court. Thereafter, you take that. Okay. Law counsel for the complainant. What do you say? What is your say in the matter? Not your admission. What was the order there? And this order.
Directing them to comply with the order that is passed by the KT in the year 1993.
1990. Yeah, set aside. The Deputy Commissioner is hereby directed to implement the order dated 23/2015 passed by the Karnataka Appellate Tribunal.
That order, my lord, directs them to comply with.
No, that is at page number?
Page number, my lord.
Land Revenue Appellate Tribunal.
140.
Page 140.
140. 8.
17th September, was it?
Improved order passed by the respondent.
Implement the order dated 23/2015 ಅಂತ ಹೇಳ್ತಾರೆ.
Oh, 15 ನಲ್ಲಿ.
We have mentioned in our complaints affidavit.
No.
Please.
What was that KAT order? 130. Okay, we got it. 3/28/2021. Ultimately, impugned order by the respondent in so and so is hereby set aside with a direction to comply the order of this tribunal in appeal number 241 and 314 of 92.
1993.
8393. Where is that 8393?
That order is. See.
So many rounds of litigations. It is waste of government time also. Page number 70. Final operative portion. Both appeals are allowed. Impugned order is set aside. Appellants are hereby liberty to purchase the land at the rate fixed under the agreement. The original of this statement is ordered to be kept in file number so and so. Now they have fixed the rate, you have paid it.
That is fixed, my lord, as per annexure.
Now you have paid that. Now there is.
I will pay, my lord.
They have not paid, your lordship. 75 rupees per acre.
That we will pay.
75 per acre.
Per acre.
Per acre. That is already fixed in 73.
Accepting the compliance affidavit by the Deputy Commissioner Udupi, the proceedings against the accused are dropped. It will be waste of even your government officials' time also. No, rounds, many litigations.
There are a lot of litigation, court cases. That we are not implementing.
No. Once one litigation comes to the end, all that should be complied, and otherwise your time is the greatest resource. That will be wasted, and again you have to come here.
Today she was supposed to be there, heavy rain, Papa, to take care of her.
But last time we had directed her to be present. I don't think.
Adu affidavit now, fresh affidavit we have filed, no? Obliged.
For arguments, seal number 24, PB Appaya, Vasant Kumar.
Anything you wanted further? No. You are relieved. Who is for the other side? You are not. Somebody is making submission there. Avarena Vasant Kumar andre.
Yes, my lord.
Vasant Kumar.
Yes.
The order complaint of my lord, your lordship will find the main order in this matter, evidence was recorded. So I think your lordship may straight away take the exhibits.
So they have said that we have gone through some of these records. One, she has sought apology saying that it was not willful or in an anxiety, etc. The other one is that the child cooperate.
No, but the question of the child not cooperating doesn't arise because I'll show to your lordship a particular order of this honorable court.
Order of this court dated? You are referring to which order? Mr. Appa, you are referring to which order?
I'll show to your lordship. Your lordship may take my rejoinder to their apology affidavit.
On which date?
It was filed on 24.
One rejoinder or?
Your lordship may take CCC 710. CCC, the first matter.
You have taken that matter.
Yes, on 24/5/2022.
24/5/22.
I filed a rejoinder to her apology affidavit, to the apology affidavit of the accused.
24/5. What is the reason? Yes, got it.
Your lordship finds a rejoinder?
You got it? 24/5. 24/5. Rejoinder.
Yes. Page 7, para 15.
Yes.
This was in the context of the respondent saying that, the accused saying that it is subject to wishes of the child, etc. Para 15. Secondly, this honorable court was pleased to pass an order dated 6/10/2017 in WP number 5295/2017 filed by me as proposed. However, prima facie, since it is seen that the order dated 11/11/2015 does not impose any condition such as the wishes of the child to be ascertained, as the visitation order is after detailed consideration and presently by the improved order, such condition has been imposed by the executing court for the present. I find it appropriate that the father and child to establish a order of 11/11/2015. In the contempt petition itself, the lordship will find it at page.
So, executive court had imposed a condition subject to the wish of the child. Prima facie it is seen that order dated 11/11/2025 does not impose. This 11/11/2025 was in G&W proceedings.
Yes, and the lordship will find that order in the contempt petition itself, 11/11/2000, page 42.
Page 42. Contempt petitions.
Page 42, the relevant page, my lord, is page 55.
For G&W, this is.
The lordship got page 55.
This was the interim application, no?
Yes, in the interim application.
Page, relevant pages?
Page 55, the starting page of annexure D.
Starting pages, right, 42.
Page 42, relevant page is page 55.
Yes.
Order. The lordship has it?
Yes.
Internal page 14, page 55 of the main
yes.
Order. I filed by the petitioner under section 12 of the Guardians and Wards Act 1890 is hereby partly allowed. The respondent is directed to hand over custody of the child so-and-so, age so-and-so, to the petitioner husband on 40% the first half of all the vacations like Christmas, Dussehra, summer holidays of the child for mediation center Bengaluru to exercise his visitation rights during the above said period. And after exercising his visitation rights, petitioner is directed to return the child to the custody of the respondent for mediation center Bengaluru without pay. Further remaining period would be given to the custody of the respondent. The prayer sought for custody of the child during Diwali vacation from so-and-so.
So in the main order.
No condition imposed the child should be.
Right, but in execution proceedings that court imposed such condition. Whether in the execution petition, any
Yes,
such,
that was the whole problem.
where is that execution order?
That is the order complained of.
Is 160, page 64.
That your lordship will find that exhibit E10
No, page number
in the documents marked during the trial,
during the trial.
page 64.
ವಾಲ್ಯೂಮ್ ಬಂದಿದ್ದಿಲ್ಲ ಯಾವುದೋ ಏನೋ ಮಿಸ್ಸಿಂಗ್ ನಾವು ಮನೆಗೆ ಹಾಕಿದ್ರೊಳಗಡೆ ಎಲ್ಲ ಬಂದಿತ್ತ ನಾನು 1 to 5 ತನಕ ಹಾಕಿದ್ದೆ 1 to 5 6.
Exhibit P10, starting page 64.
1 second.
Relevant page, my lord, is
Madam,
page 66.
yes, only one set exhibit. P10, yes, page, relevant page?
Page 66.
Ah, yes. Read set it in there. Okay, you can see here now. Yes. Directed to deposit so and so.
CH-4 counsel filed memo.
Stated that yes. That to hand over the custody of the child and access to the not mentioned wishes of the child. His prayer is rejected.
Yeah, DHR counsel filed memo stating that the deposited an amount of 3,000 as a commissioner's fee. It also stated in a filed memo that to hand over the custody of the child, and also stated that not mentioned as with the wishes of the child. Same as hereby rejected. If PF paid, issue delivery warrant against the JDR to court commissioner with regard to hand over the child to so and so, as sought for in the petition to the DHR with wishes of the child. That was never the condition at all imposed in the order by IA number 40, the order passed by the family court. Suddenly, the family court judge started.
Correct, but you have not challenged this order.
We did not challenge this particular order because there was no necessity to. The condition was never there.
Yes. Yes.
So that is the order complained of, my lord. That your lordship will find in the prayer. At page 15 of my petition. Initiate contempt proceedings against the accused, Commissioner of Security for violating the order dated 9/12/2016. EP number 2404 in pursuance of.
Where are you reading? Just a minute. Page, where are you reading?
Prayer column of my contempt petition, page 15.
Oh.
This is exactly what the whole contempt petition is all about.
9/12/2000.
That's the prayer, page 15.
This order is dated 9/12/2016. Yes. 9/12/2016 and 11/11/2016. And
9/12/2016 order, my lord, is what.
And 11/11/2015 is the main order.
Yes.
Out of which this execution arose.
Yes.
Yes.
Yes. They have actually filed their apology affidavit. Not with any great remorse, because if your lordship sees the sequence of events, contempt petition filed on 17/4/2017, objection statement filed on 10/7/2019, charges framed on 38/2019, complainant's evidence by way of affidavit recorded on 23/10/2019, exhibit P1 to P22 marked. Then, almost 1.5 years later, when they realize that there is no escaping, the first apology affidavit is filed on 14/2/2020.
Yes.
And then the second apology affidavit filed on 21/4/2022.
Yes.
And not even just a plain and simple apology affidavit, unconditional. I submit while petitioner has violated orders passed in so and so with respect to educational expenses. Then further, he has agreed not to interfere in my life. He is misusing my two-wheeler car. Then she says, I'm ready to send my daughter to the father, keeping her wish and welfare as priority. And then she makes a series of demands in her apology affidavit. Direct the petitioner to issue NOC to HDFC Bank, direct him to pay 3,19,000, direct him to return my vehicle bearing number so and so. Is that an unconditional apology? All we want is, I have unconditionally apologized for my past actions. I undertake to comply with all orders passed by this honorable court in future.
Yes.
Not all these various conditions for compliance of the order.
Yes.
Exhibit P12 is the report of the court commissioner, which clearly shows even in response to the delivery warrant, relevant portion is page 12, exhibit P12, page 70.
Yes. Yes.
Commissioner says, para 1, on the first occasion of 24/12/2016, we went to the mediation center to execute the warrant. DHR was present, but JDR did not appear nor did she produce the child. Then they went to the JDR's house. The apartment security did not allow the court commissioner to go in. Then last sentence of the commissioner's report at page 70, JDR informed the court commissioner over intercom that the child had she had some inconvenience to hand over to the child on that day. Nothing about the child not wanting to come. She had some inconvenience not to hand over the child, would hand over to the particular holder on Monday. Then she says, further told the court commissioner that she would hand over to DHR even without the presence of court commissioner on 26/12/2016 without fail. Next paragraph. They go on 26/12/2016. JDR does not hand over the child as promised and asked him to come again on 27/12/2016. Then they went on 27/12/2016. Apartment security says, so that is the accused did not give permission. NC cannot allow anyone without the permission. Then court commissioner asked security to take the apartment manager to get permission. The manager was available and NC asked to come on next day, 28/12. On 28/12, that's the third occasion, court commissioner went to the apartment of JDR and the DHR to execute the warrant. Apartment representative was shown the warrant. The apartment security informed the court commissioner that Srimati Soji, that is the accused, was not at her house and had already left. Later, security allowed the court commissioner to enter inside the apartment. The JDR's house was locked. Security persons also come to accompany the court commissioner and declare the relevant inside department. The JDR was willfully disconnecting all the communications made to the court commissioner. The court commissioner could not meet the JDR and child on all the occasions when attempts were made to meet the JDR and the child to execute the warrant. Accordingly, the delinquent warrant is so issued by this honorable court in execution of so could not be executed on all the three occasions due to willful default of the JDR in executing the warrant issued by this honorable court. Hence, returning the delinquent warrant herewith unexecuted. Then after that, we sent a demand notice, that's at page 73, saying please comply the order. At page 75, we said if you don't comply the order, on your failure to comply with the demands made, the client will be constrained to file a petition against you for committing an act of contempt of court or at a risk and costs to consequences. All the acknowledgements are there. Further communications, total silence. This is as far as 710 of 2017. Open and shut case, that is gross contempt committed by her. Then the next one, my lord, is 826. Sorry, 710, I may point out that the charge was also framed, as I mentioned, by this honorable court on 30th of August 2019.
See this, first one is regarding violation of order dated 9/12 and this CCC 710 of 2017 is regarding violation of orders dated 9/12/2016 and 11/11/2015.
Yes.
This
That as I mentioned in
826.
the prayer column of the petition itself, violating the order dated 9/12/2016.
710 of 2017.
Pursuance of the order dated 11/11/2015.
CCC 826 is regarding the Kodi.
In the petition itself, the lordship will find order dated 11/11/2015.
Is main order. 11/11/2015 is main.
It's the main order. It's the main order.
Right. Why three petitions, three
What
complaints?
has been violated is the order dated 9/12/2016.
That is in CCC 710. What
CCC
is
710.
this CCC 826?
CCC 826, my lord.
Proceeding request. Order dated 29/10/2010 in execution number 100 of.
Again, because of these repeated refusals, there is repeated execution petitions. Order dated 29/10/2020. EX of so and so, violating the judgment dated 16/1/2020.
2020.
Now, what had happened, my lord, is the main judgment, that was all that interrupt the
29/10.
that is the main
2020.
29/10/2020. What just pause for a minute, my lord.
That order is at page
The
number.
2017 CCC was against the interim order. What I tried
Okay.
to lordship passed to go by then. But by 2020, the main GWC case had been disposed of. That order, your lordship, that final judgment, what your lordship will find, starts at, in your lordship has a CCC 826.
826.
Your lordship will find the final judgment is annexure C. It starts
Page
at
number 59.
It starts at page 59.
Yes.
Relevant portion, my lord, is at page 110.
One.
Page 110 is the final order in the GWC proceedings.
It's the final order.
Page 110.
Second one. 110. Yes, what is the final order?
Final order.
Visitation, right? Partly, petition is partly.
Para 26, point number
It was
3.
his petition for appointment of guardian. It was his petition for appointment of himself as a guardian.
This is the visitation, because father is always.
No, this GNWC was under section 7 and 25.
Yes,
So
sir.
7 is for appointment, permanent appointment.
Strictly speaking, my lord, that is the mistake we find in a lot of pleadings in the family court, invoking section 7.
No, court does not invoke. You file the petition. Your party has filed the petition.
Not necessary. That's what we can't help it.
No,
Everyone just
no,
strictly
you,
invokes section 7.
no, you should tell about your counterpart, not the trial court.
No, we should tell them not to invoke section 7. Father need not invoke section 7.
What was the prayer of the father in the petition?
The mother wants to be appointed the legal guardian.
No, ideyalla, to appoint him. No, see,
Then section 7.
read the page 2 in that. To appoint him as permanent guardian of the child.
Yes.
It was not for mere visitation, right? He sought his appointment as a permanent guardian. Yes. Yes, what is the petition is partly allowed. Petitioner is entitled to visitation, right?
Yes,
Yes.
Para 20, point number
That
3.
is
in view of the
first and third Sunday of every month between 2 to 5 p.m.
Yes.
Right to have civil vacation.
Of the minor child during first half of 40% of school vacations, like Christmas, Dasra, summer holidays, etc.
Yes.
Conditions. During the course of visitation, right, or interim custody, petitioner father shall not poison the mind of the child against a respondent. Petitioner father shall not cause any harm to the health of the minor child, and he shall take care of the child in the minor during interim custody. Petitioner father shall hand over the child without causing any obstruction to the respondent mother after completion of interim custody. Respondent mother is bound to allow the petitioner to exercise his visitation right and the interim custody as ordered above. The respondent mother shall not poison the mind of the minor child against the petitioner father. All the expenses of the taking child to the custody of the petitioner's father and returning to the respondent mother shall be borne by the petitioner father. Petitioner father shall bear 75% of the education expenses of the minor child till she attains the age of majority. This order will continue till the minor child attains the age of majority. Thereafter, it is left to the choice of the minor child. Where is the question of thereafter? Once after child attains the age of majority, there is no question of choice of the minor child. The court permitting the choice of the minor child. Minor child can exercise a choice irrespective of any order of any honorable court with great respect. Nowhere is this condition mentioned, even in the final judgment. That is also violated.
What was the order dated 29/10/2020 and execution 100 of 2020?
It is a motion.
What was the order dated this
That is in the
29/10/2020 and execution number 100 of 2020?
Execution again is filed.
Now that is at page number?
Yes, that is at page number about
100 of 2020. Is it marked there? About it 2010-2000?
page 142, madam.
142. Right. Yes.
The only condition your lordship will find at the end of page 144 is the order. Order starts at page 142.
There is second.
Portion is
it 826?
826.
Yeah, page number 144.
826, page 142.
This is the order said to have been violated. JDR is directed to hand over the child to DHR. Huh? Only one page is there.
120 is 144 is.
It's not there. It is being said in the second set, this order is not. Order ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅದರಲ್ಲಿ. Execution case.
The main petition, page 140.
ಇಲ್ಲ here. This is 120. Here it is. This is 140. That is objection itself.
Relevant portion is at page 144. Next page.
JD is directed to hand over the child to 1/11/2020.
To hand over the child to the DHR today is 1/11/2020. Comply the order passed in GWC number so dated 16/1. That's a main judgment. Both parties shall follow the conditions imposed in the above said order. As I mentioned, nowhere about wishes of the child. Before taking over the custody of the child, DHR shall produce the COVID report. If the COVID report is negative, then only JDR is directed to hand over the child. If the COVID report is positive, the JDR shall not hand over the child, which is paramount welfare of the child. The DHR shall send a copy of the COVID report to the court through mail. Next page, my lord, is the COVID report.
So, this was an ex parte order. This was an ex parte order. This was an ex parte order. No, even before issuing notice, it seems, because issue emergent notice to notice of IA3 and main petition to the JDR. I think this was on the first hearing ex parte order, it seems.
So I think so. Maybe it is expired. But there was no issues because after all, the petitioner father was entitled to it. A main judgment is passed giving him these rights. So there is no harm in passing an ex parte order. The only thing the family court judge said, send the COVID report. COVID report is sent. Still no custody handed over. Then next paragraph, next annexure, page 147 is the demand notice. That is also sent. No response. So that is CCC 826 number.
We'll continue in the afternoon. We'll continue in the afternoon. I have invited the sister to our association in the afternoon at 1:45. ಇವಾಗ್ಲೇ ತಾನೇ ಇರೋದು. It's at 1:45, no? You have invited the sister at 1:45 to your association.
Oh, I'm not aware.
You are not aware. You are not the member of the association.
I'm not an office bearer and I'm
No.
not privileged to give the invitation.
Member. Yes. At 2:30, we'll take up at 2:30.
ಇದು ನಾನು ಬರ್ಕೊಂಡಿಲ್ಲ ಆ ಥರ ಬಟ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ರಿಲೀಸ್ ಅಂತಾನೆ ಬರ್ಕೊಂಡಿದ್ದೀನಿ. ಯೂಶುವಲಿ 50% ಆಫ್ ದಿ ಅಮೌಂಟ್ ಡೆಪಾಸಿಟೆಡ್ ಅಂತ ಹೇಳ್ತಾರೆ, ಆ ಥರ ಹೇಳಿಲ್ವಾ? ಯಾಕಂದ್ರೆ
ಏನಂತ ಹೇಳಿದ್ದಾರೆ ಹೇಳಿ? Registration ಇದ್ರೊಳಗಡೆ 25 ಅಲ್ಲಿ ನೋಡಪ್ಪ 12(6) ಅಲ್ಲಿ ನಾನು ಇದ್ರೊಳಗೆ ಬರ್ಕೊಂಡಿಲ್ಲ. ಯಾವುದೋ ಒಂದು ಕೇಸಲ್ಲಿ ಹೇಳಿದ್ರು ಬಟ್ ಅವತ್ತು ಅದೇ ಕೇಸ್ ಅಂತ ಗೊತ್ತಾಗ್ತದೆ. ಅದು ಫಾಸ್ಟ್ ಆಗಿ ಹೋಗ್ತಿರುತ್ತಲ್ಲ ಅದನ್ನ ಬರ್ದ ಹಾನಿ ಹೊಳ್ಳದೇನೆ ಇದೇನೆ ಅಂದ್ರೆ ಅವ್ರು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ ಆಯ್ತಾ 25 ಫುಲ್ ಅಂತ ಹೇಳಿದ್ರ ಅಂತ ಅಮೌಂಟ್ ಇನ್ ಡೆಪಾಸಿಟ್ ಅಂತ ಹೇಳಿದ್ರ
ಫೈಲ್ಸ್ ಇಲ್ಲಿ ಇರೋದು ಇದು
ಅದು ಬೇಕಾ ಅದ್ರ ಜೊತೆ
ಮೇಡಮ್ ಫಸ್ಟ್ 710
ಇವಳ್ದು KSR ಫೈಲ್ ಇಲ್ಲೇ ಇದೆಯಪ್ಪ KSR ಫೈಲು ಇದೊಂದು ಫೈಲು KSR ತಗೊಂಡು ಕೊಡ್ಬಿಡಪ್ಪ ಇದೊಂದು ಕೊಡಪ್ಪ ಇದು KSR ತಗೊಂಡು ಕೊಡು ಮಧ್ಯಾಹ್ನ 2:30 ಅಷ್ಟೊತ್ತಿಗೆ ತಿರ್ಗಾ ಬೇಕು ಫಾಸ್ಟ್ ಓವರ್ ಮ್ಯಾಟರ್ ಇದು ಕೊಡಪ್ಪ
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 36 ಲಾಸ್ಟ್ ಮ್ಯಾಟ್ರು ಏನಾದ್ರು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಆಗಿದೆಯಾ
ಇಲ್ಲ
ಇಲ್ಲ
230 ಮ್ಯಾಟರ್
230 ಇವರು ನಮ್ಮ ಚೆಂಬರ್ ಮೇಡಮ್ ನಾಳೆ ಕೊಡ್ತೀನಿ ನಾಳೆ 3 ಮ್ಯಾಟ್ರ್ ಬರ್ತಾ
ಇಲ್ವೇನಾಗ್ಲಿ
ನಮ್ಮ ಬುಕ್ಸ್ ಇಲ್ಲೇ ಇರಲ್ಲ ಹೆಂಗೆ
ಇವರು ಸ್ಕೂಟ್ನಿ ಅವ್ರು ಹೇಳಿದ್ದು ಅವ್ರಿಗೊಂಚೂರು ಕೇಳಪ್ಪ ತೊಗೊಂಬಿಡಿ ಕಂಟೆಂಟ್ ಅಲ್ಲೇ ಇಡಿ ಅಂದ್ರೆ ಅದು ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಹಾಕ್ಬೇಕಾಗುತ್ತೆ ಹಾಕಿ ಇಲ್ಲ ಇವ್ರನ್ನ ಚೇಂಜ್ ಮಾಡಿ ಸೆಟ್ಟಿಂಗ್ಸ್ ಇನ್ನಿರ್ತಾರ ಏನ್ ನೋಡ್ ಕೇಳ್ತೀನಿ ಅವ್ನಿಗೆ ಹೇಳಿರ್ತೀನಿ ಒಂದು ಇದೇ ತರ ಒಂದು ಹಾಕೊಂಡಿರೋ ಬೇಡ ಅಂದ್ರೆ ತೆಗಿಸ್ತೀನಿ ಅಂದ್ರೆ ಇದನ್ನ ರೆಡಿ ಕಳ್ಸಪ್ಪ ಒಂದು 10 ಅಂತೂ ಕಳ್ಸಿರೋ ಅವ್ರ ಹತ್ರ ಇರ್ಲಿ ಆಮೇಲೆ ಇದೊಂದು ಇದೆ ಗೊತ್ತಿಲ್ಲ ಸರ್ ನೋಡೋಣ ಏನ್ ಹೇಳ್ತಾರೆ ನಾವ್ ಹೆಂಗೆ ಎಲ್ಲ ಇದು ಇವಾಗ ನಮ್ಗೆ ಇದು ಹೊಸದಲ್ವಾ ಇದು ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಅಂದ್ರ ಇವ್ರು ಬಂದಿರೋದು ಇವಾಗ ಮೊದ್ಲೆಲ್ಲ ಏನ್ ಆತರ ಇರ್ಲಿಲ್ಲ ಯಾವ ಮೆಂಬರ್ಸ್ ನೋಡ್ತಾ ಇದಾರೆ ಅವರು ಈಗ ಹಾಕೊಳ್ತದ್ದು ಈಗ MFA ರೋಸ್ಟ್ರ ಇಲ್ಲ ಇಲ್ಲಿ ಹೌದಾ ಅಂದ್ರೆ ಸಿಟ್ಟಿಂಗ್ ಲಿಸ್ಟ್ ನೋಡಲ್ವಾ ಅಂತ ಸರ್ ಸಿಟ್ಟಿಂಗ್ ಲಿಸ್ಟ್ ರೋಸ್ಟರ್ ಚೇಂಜ್ ಆಗಿದೆ ತಿರ್ಗಾ ಹೆಂಗ್ ಬರುತ್ತೆ ನೋಡಲ್ವಾ ಅದನ್ನೆಲ್ಲ ನೀವು ಅಂತ KSRದು ಆ ಟೈಪ್ ಆದ್ಮೇಲೆ ಅವ್ಳು ಕೊಟ್ಟು ಕಳಿಸ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೀನ್ ಒಂಚೂರು ತಂದ್ಬಿಡಪ್ಪ ಅಷ್ಟೇ
ಸ್ಟೇಟ್ಮೆಂಟ್. ನನಗೆ ಕಳಿಸಿದ್ದಾರೆ, ಇಲ್ಲೇನು ಬೇಕಾ ಕಳಿಸ್ಕೊಡಿ. ತಿರುಗ್ಸ್ ಅಯ್ಯೋ ಸುಮ್ಮನೆ ಯಾಕೆ ರಾಮಾಯಣ ಹೋಗಿ ಫಸ್ಟ್ ಡೇಟ್ಸ್ ಎಲ್ಲ ಈಗ ಬಂದಿದ್ದಾವೆ ಯಾರಿಗೆ ಗೊತ್ತಿಲ್ಲ. ಈ ಟೈಮ್ಗೆ ಕರೆಕ್ಟಾಗಿ ರಜಾ ಅದು ಹಾಕಿದಾನೋ ಬಿಟ್ಟು ಗೊತ್ತಿಲ್ಲ ಬರುತ್ತೆ 3 ದಿನ ಸುಮ್ಮನೆ ಕೂತಿದ್ದು. ಸಾಕು ಬಿಡು ಸಾಕು. ಪಾಸ್ ಓವರ್ ಅಂದರೆ ಫಸ್ಟ್ ಕೇಸೇ ಪಾಸ್ ಓವರ್.
21 ಪಾಸ್ ಔಟ್ ಹೋಗ್ತೀನಿ.
ಹಾಂ
19 ಅಲ್ವಾ
20. ನಾನು ನೋಡ್ಲಿಲ್ಲ ಏನಂದ್ರೆ ಹೇಳಿರ್ತದೆ ಹೇಳ್ಬೇಕು ತಾನೆ ತಕ್ಷಣ. ನನ್ಗಿದು ಇದೇ ಅಡ್ಡಾರ ಹಿಂಗ್ ತಿರುಗಿದ್ರೆ ಹಿಂಗ್ ಕಾಣಿಸುತ್ತೆ. ನೋಡಿದಾರೆ ತಾನೆ ಅವ್ನು ಹಾಫ್ ಡೇ ಅಂದ್ಮೇಲೆ ಕೊಡ್ಬೇಕು ತಾನೆ ಯಾರನ್ನ.
ಅದೇ link display. Yeah.
ಬೆಳಗಿನ Past over matters. Seal number 1, P. Mahesha, BV Nidhishri, SPP.
Hearing for the respondent number 2 in this matter.
No, there's an amendment carried out. Amended appeal memo they have not given. Non-amendment of appeal memo. Appeal.
Was amended on 4/11/2024. Mistake committed by the registry.
Okay. Records show that the appeal memo was amended on 4/11/2024 itself. Therefore, office objection overruled. Yes. Suspension. Notice had gone to somebody's Nidhishri.
PV
Who is
Nidhishri.
I'm appearing for respondent number 2. I'm on her
Respond number 2.
2.
Oh.
Sole accused was convicted for life. The offense is punishable under sections 363, 376, and 5 and 6 of the Pox Act. Thus, the Governor Session Judge convicts me solely on the ground that there is a statement made by the victim girl herself. Now, there is nothing apart from that. There is no medical evidence tying me down. There is not even a single medical record which shows that I was involved in a sexual assault.
But why is the victim's witness statement should
Victim
be?
statement, yes, Malala.
Supreme Court says that she is in the like injured witness.
Please, Malala, but she doesn't say that I am the person when I am
PW?
PW2, Malala.
Kannada. PW2 is the victim.
Please, Malala. Malala, in this matter, there is no eyewitness, Malala.
She says Viresh.
Viresh,
What is the name of this accused?
Please, Malala.
In fact, your lordship, PW2, who is the victim, has identified specifically that the accused, that's the complainant. Oblige.
The one who has cut my finger is Viresh. He hit me with stone, crushed my head. And
She gets scared, Malala, when he is brought
then
to the-
he hit on my head. And he brought her, took her from her house when she was sleeping and took her near a bush, bowed her mouth and committed the She showed her stomach portion showing that had caused her pain and urinating place she showed her face. She said when doctor was taken to hospital, etc. What is the cross examination? No. He suggested her. She is tutored, she denied that.
And asked about the case, she started crying.
So she was not even willing to look at his face. She had an aversion. They asked her to identify the that is child aged
5 years.
5 years at that time, at the time of evidence.
In the 6 years. 2018 was the
No, here her age is shown as 5 years in her deposition.
That incident took place in the year
Who
2017.
is the doctor? Date of incident was?
3/6/2017, madam.
3/6/2017.
Interestingly here, the doctor who prescribed the
One
issued
second.
the wound certificate.
When she was examined?
That's at around 3:45.
No, on the same day. 3/6.
On the same day, madam.
Where is
They
that
say
day?
incident took place at 1:30 to 2 o'clock. Wound certificate is issued at 3:45. Another doctor, OBGYN doctor, examines her at around
3/6?
2017. madam.
Where is that? Search. 3/6/2017 at between 2 and 2:45 a.m.
Please, madam.
When she was examined by the doctor?
The wound certificate was issued at 3:45.
Exhibit?
P4, my lords, doctor is PW9.
P4 is at page number?
No.
P3 it's in.
P3 is the
Department of-
accused.
P3 is also medical examination report. What is it?
It's the medical examination of the accused.
Accused medical examination.
Accused.
Please, madam. Exhibit P4.
P4.
Is the examination by the OBGYN.
P6.
Took place at 6:30. That is the second medical examination.
Second means what was the first medical
The
examination?
wound certificate was issued by another doctor, Dr.
The
Shiv
primary
Kumar.
health center.
Please, madam.
That is, where is that?
That's exhibit.
Is there a
It has not been marked. It is in the charge, a part of charge sheet, madam, because the doctor wasn't examined. The wound
Maybe.
certificate is issued at
maybe male doctor?
3:45.
Maybe
Please,
he
madam, male doctor.
So he sent to
Please, madam.
Bowring Hospital.
Please, Bowring Hospital.
What is the, it is 3/6, time of examination at 5:30.
Time of examination
At 5:30 a.m.
Plus, that was the accused time of examination. Plus,
No, just a minute. We'll see what is
victim girl's time of
Should
examination was 6:30.
KZ Hari, so and so. Where is the name of the victim? Name of the individual, Lakshmi. Where is
Lakshmi is the mother, madam.
name of the individual?
Victim's name has not been disclosed. ma'am.
In this. They have mentioned, examine the victim. Examine the victim, that's all they have mentioned. No, then your statement is incorrect. Exhibit P4 is the victim's age 5 years. It is victim's examination report.
I stand corrected,
She was
madam.
examined at
Exhibit P3 is the
5:30 a.m.
Exhibit P3 is the examination of the accused.
Page number 104 is report. Lying on the road with the dogs around. So initially the culprit was not known.
Please, my lord.
So, but I meant they are present.
Now, I was apprehended at 5:30 in the morning itself, my lord.
Yes.
My argument is that, my lord, there is not even a single iota when the victim has been examined at within 3 hours, within 6 hours of the incident. There's not even an iota of medical evidence indicating that I have committed the assault.
Within 6 hours you were not connected to the crime.
I mean,
Right.
there should be, plus I do agree there is a statement of the victim girl, but along with that, there should be something clinching evidence that I have committed that assault. There's not even a medical report which says that the assault took place because of me or the semen which was found.
Was he a person known to the child earlier?
No, my lord.
They are from the same locality. It's the neighbor.
Yes. You were granted bail during trial?
Sorry, my lord?
Were you granted bail during the trial?
No, my lord. I have been in custody since 2017, my lord. This is a successive application as well.
This is successive application.
Please, my lord.
Then what is the changed circumstance?
It's been more than 8 years, my lord.
So delay.
I have a wife and 3 children, my lord, who are minors.
At the age of 24, you had a wife and 3 children.
Yes, my lord.
Your age is shown as 24 in the charge sheet.
My wife has filed the affidavit.
Correct. We were asking you because you represent him. He was not on bail, you say. As per the charge sheet, he was aged 24 years. So by that time, he had wife and 3 children. Aggravating circumstance. Yes.
My wife has filed an affidavit stating that she is unable
Why?
to handle.
Why I did not? Matter was not heard.
That's on 2019 order.
2019.
14/1/2019.
14/1/2019. Yes. Now we are only on the ground that now there is delay in hearing the appeal.
My only submission would be this, my lord.
Correct. Now why are you arguing on the merits of the case? You should have told us that this is a successive bail application. Right. Yes, sir. Changed circumstance. Where is the proof of your marriage and you living with 3 children before the crime? Mr. Counsel, stating on oath is not sufficient. You have to show us that before this incident, he has wife and 3 children and they were living. At least ration card will be there. 2024. It's a little strange, no? He is from which place?
Chitradurga district, my lord.
Chitradurga. Nagavara Arabic College, Chitradurga. I'm sir, Bangalore.
Page 3 of my application, my lord.
This is IA number 1 of 2025.
I have one of 18, my lord. 23, I'm sorry. I have 1 of 23.
Oh, we only asked to list it because why this application is pending. Contempt action directly 99 that list mark
Page 3, my lord.
She says Tippamma. She's 28 years. Page 3.
3 children, my lord. I'm working as a maid servant. With my meager revenue, I'm not able to look after the welfare of my children and eking out livelihood. Appellant has lost his father and mother during the pendency of the criminal proceeding. That is the reason why, my lord.
Yes. Is what I was about to say. Whether you have
If
any
you're-
information about his family?
Your lordship, if your lordship may see page number 100
100 of paper?
on the paper book, page number 100, that is the medical
Appeal
examination
paper?
report of the accused
Appeal paper or paper?
in the appeal, the paper books.
Paper.
Your- My learned friend was in fact
Page
saying that
100, 100 and
there is no proof that the accused has committed anything, and the medical examination report is also not there. That was his submission. Page number 100 talks about the injuries of the accused. It says there are 2 scratches in his neck,
Yeah, the scratch mark in his neck
3 on his collarbone.
and
There is a bite mark,
yeah, collar, neck again, that's another injury.
and this all has happened between 6 to 12 hours.
Screw, and three scratch injuries. And there was a bite mark.
And above that, page number 101, your lordship, it's the iodine test at the end, at the bottom, wherein the medical examination report clearly says that he has engaged in a sexual intercourse between 6 to 12 hours.
Yeah,
And this report was prepared
at the time of examination.
subsequent to the examination of the
Found to have
victim.
involved in sexual.
This clearly shows that the accused has engaged in this offense.
How did he explain these injuries? He had his injury and his private part also.
Yes.
Yes. It's not for me to do so.
This is a, Mr. Counsel, it is under the, 1 second. You are very much audible to you need not raise your voice. You are arguing in a POCSO Act. There is a presumption under section 29 and 30 of the Act. You are saying, I need not explain. Prosecution has to prove. There is a duty on you to explain these things.
That's unfortunately in the trial court, the counterpart couldn't explain it because there's nothing on record.
Accused has to explain at least under 313 statement how he got that injury. Records here.
Statement and the statement and the
This evidence of who is the doctor who conducted examination. Who conducted his examination? PW?
PW8.
PW. I wanted to take down PW8's evidence. Who is the doctor who examined him?
Dr. Minors.
PW9 is the victim's.
Doctor. Yes, Pratima, that is, she has examined the victim. PW8, Dr. Nagaraj. Yes, truly said false. Here, that is elicited in his cross-examination that there were injuries on his body, but he has only said false. In the evidence of this doctor, his examination was disputed.
No, your lordship. In this matter, it's a clear cut that the victim has identified the accused during the examination. And even this same honorable court has, in fact, in 2018 has said there is sufficient evidence on behalf of the complainant. And they find no reason to suspend the bail.
Her examination, this is same thing. I mean, victim's examination report. They have put it in the paper. Oh. Being presented saying that he has not shown any material to show. That lady has not produced any material to show that he was married by that time and he has etc. And say like that. So, order sign number 1 of 2023.
Even on paper, it seems he has not stated anything.
What injury has not
Not considered injury.
taken up this ground of wife and children? application now. Sentence, internal page number 27.
They haven't taken this contention to my knowledge.
He was married.
His counsel submission is there, it's not forthcoming.
At the time of commission of offense, he was married, my lords. Accused was married. The reason is PW3, my lords.
Statement, his voluntary 167.
No, my lords. The reason is PW3, who happens to be mother-in-law of my lords, this accused. She is a neighbor of my lords, victim's family.
Oh, he had come to his.
That is what my lords, page number 60, you will ask me kindly peruse page number 60 of the paper book.
16 of the paper book.
60.
60. But it should be a child marriage if he was married by that time, not for him.
With regard to
But for
children,
his wife,
I was not knowing, my lords, but
3.
PW3, my lords. And victim knew the accused because.
He is not the mother-in-law. She
Yes,
says,
madam.
ನನ್ನ ಮೈದನನ ಮಗಳನ್ನು ಆರೋಪಿ.
Sister.
PW3 sister.
Sister-in-law, my lords. Relative.
The relative
Relative of
sister-in-law.
sister-in-law.
PW3.
But all these grounds, why do they live with him with all this history? Impleading application. This is a successive bail application of the appellant about case by the impugned judgment and order, life imprisonment. The appellant is convicted for the offences punishable under section 376 IPC. Read with section 5 into bracket M and 6 of POCSO Act. He is sentenced to for the major offence. Imprisonment for life. Imprisonment for life. He is earlier. This court, by considering the merits on 14/1/2019, dismissed his earlier application for bail. The changed circumstance urged in the above application is that he has, they should have been by that time also. Whether this was urged in earlier application IA1 of 2019?
No, they haven't taken this contention, your lordship,
2018?
regarding the family members and children. In the previous application, they have just mentioned about this thing, but not related to the family.
Mentioned about the marriage.
No, your lordship.
His 24 statement is there in the paper book. Any recovery?
Lords,
27 or
no voluntary statement, my lords.
No voluntary statement.
It might be in LCRs, my lord. It might be in LCRs, my lords. I have to go through.
Yes. No.
Not in the paper book.
If at all it is there.
Normally it will be recorded, my lords.
No, I'm sorry. The changed circumstance, now it's being urged. The charge ಹೇಳಿಲ್ಲಲ್ಲ, I'm sorry.
Madam.
The charge against the appellant was that he on 3/6/2017 between 2 and 2:45 AM, he dragged the victim girl aged 5 years from her parental house, assaulted her and committed aggravated sexual assault on her. Further, he attempted to commit her murder by dropping cement block on her head, fingers, and other parts of the body. 307 307 is acquitted. Why can we sentence only one? Huh? Correct. 307 charge is framed.
That he has assaulted with my lord stone on the head of the victim girl.
So she wife was pregnant. She had gone to her parents' house. She couldn't control his, and he was an alcoholic. These people were also migrants.
was sleeping in her house.
No, that girl had come out for his injury, come out for urination. At that time, he brought her. Yeah. That is case. Yes.
But then he attempted to commit murder by dropping cement block on her head, pieces and other parts was not.
Okay. The changed circumstance are in this application is that he has wife and 3 minor children. ಮತ್ತೆ ಆ ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಫಸ್ಟ್ ಚೈಲ್ಡ್ ಡೆಲಿವರಿ ಹೋಗಿದ್ದಾರೆ ಅಂತ ಇದೆ. It is said in that voluntary statement she had gone to her first delivery. How he can get other 2 children? In this 164 statement, sorry, this confession statement, it is said that his wife had gone for delivery about 10 days back.
Yeah, third child. First child.
No, there is no.
First child.
First child. ನನ್ನ ಹೆಂಡತಿ ಹಾಗೂ ಮಕ್ಕಳಾದ ಕರೆಕ್ಟ್ in the top it is said he had 2 children by that time.
And went for delivery for third child.
Third child.
Sorry, the changed circumstances in this application is that he has wife and 3 minors.
This appeal is not heard, and they have become, because of his detention, they are suffering. The records show that while arguing on sentence or in his application under in his earlier application for bail, such contentions were not taken. Further, no material is produced to show that at the time of the incident he was living with the said wife and children. Considering the gravity of the offense and the material on record and the above circumstance, the alleged changed circumstance is unacceptable and it's not a fit case to grant bail. Hence, application is rejected. All right, paper books are ready. You argue the matter. We'll list it for. Why 2 weeks? Next week only we'll list it. You are Legal Service Authority Council? As requested by the Appellant's Council, list for final hearing on 2 weeks ಆದ್ಮೇಲೆ. ಅಲ್ಲ ಅವ್ರಿಗೇನು 10 days ಆದ್ಮೇಲೆ ಹಾಕೊಳ್ಳಿ. ಇಷ್ಟೇ ಇದೆ ಪೇಪರ್. It's not a big paper.
36. Past door matter. Seal number 3. Rattihalli Geeta Veerna. SPP for R1 H. Shankar.
Respond number 2.
Yes.
A1 is there, A3, A4 have been acquitted, A2 is appealed before the Council Court. The order of execution of 25 people, A2 has been convicted for offences under section 6 of the COPS.
Madam cannot read order. Kannada.
It's very simple,
But
Telugu, otherwise I was told it.
huh?
I don't know Telugu, otherwise I would have told it.
You would have argued in that. English. No, she will argue in English, but she is referring to the judgment. Judgment is in Kannada.
Just it's only offences he's been convicted and and what is the sentence? That's all, my lord.
One paper book. Yeah, last time also he submitted, now he has served this sentence for POCSO Act. And only what survives is SC/ST/PA Act.
Exactly, my lord. That's the only thing, my lord. So whether the section under subsection, section 3, subsection 2, clause 5 of the CH Act is applicable to this particular case is the only question.
Why he also, whether you have disputed that the victim belonged to scheduled caste?
That's not there here.
No, have you disputed that?
My lord,
That victim belonged to the scheduled caste?
Please,
that is not
please,
They have disputed.
please, not disputed.
That's,
They
we
belong
are
to,
asking whether they have disputed.
no.
In evidence, who is the Tahsildar is examined, caste certificate, etc. is produced.
Exhibit P8.
Exhibit? No, we'll go one by one. You said that SC/ST/PA Act is not applicable, in other words. So, well, two things. One, whether the victim being to the scheduled caste was disputed. And second one, that this offense was committed with the, this caste discrimination intention.
Very important point is that this particular section gets attracted only if an offense under the IPC has a punishment more than 10 years. The law can just see that.
What is the offense punishable under section 6?
The 6, 10 years, he has completed the law. Have you been given?
No. If he has completed, whether that operation goes, that operation of section.
Because this operates only for the IPC offense, not for the POCSO. The law can just read that section.
Correct. Here it's no. 506 is also there. Here conviction is he is acquitted of 323, 324, 504. Convicted for section 6 of the POCSO Act, 506 of the Act. So it overlaps, no, section 6 and 376. And it's a special enactment itself for SC/ST/PA Act. Yeah. Shall we go on, or you want? We'll ask them to produce this thing.
Only 1 point.
They should not say that they won't be challenged. They should not say that how did they pass the order. Tomorrow you yourself should not challenge the order if it goes against you, saying that one of the judge was not knowing Kannada. Then how did they pass the order? Suppose it goes against us. Yes. Shows section 3
Yes, section 5. Section
3 to 5.
Yes, 3 to 5. Section 3, subsection
2, 5.
2,
5.
Can I read the law?
Yes.
ಯಾವ್ದ್ರಲ್ಲಿ ಕೊಡ್ಬೋದು 375
Punishment for a term of 10 years or more against a person or property, knowing that such person is a member of the scheduled caste or scheduled tribe or such property belongs to such member, shall be punishable with imprisonment for life and with fine. So it is a very, very strong section which has fixed that only when the offense for which the punishment is 10 years under the IPC, only when this section gets attracted. But in the case on hand, the IPC section for which the case has been found guilty is section 506. IPC gives only 2 years. But here in the order, the judge has given only 1 year.
Charge sheet was filed for section 376 also. Whether if charge was framed for 376 CD section 6 or only because one of the provisions of IPC POCSO Act says that if the offences overlap, they can sentence them for one of them.
Please.
Which carries the highest sentence, punishment. Not 2018. POCSO Act earlier it was there. POCSO Act. Our judges makes this kind of mistake. He should commit for while sentencing. He should sentence for
Not required. Not in that one.
Kind of charge is there. Just they read copy only charge sheet. They have framed the charge also for section 6 only.
6 only. However, the charge sheet is for 376 only.
TP or they should have sought amendment of the charge or even while see they have to convict for both of them. And sentencing is
That is right, that is
whichever
right.
carries highest
Highest,
punishment.
that is right, madam.
Yeah. But can we close our eyes for that? Show us if there is any other judgment on the point.
Yes.
No. Carrying equal punishment.
I'm not very sure on that, Manoj, but there is one judgment which speaks about the intention. Manoj, even the complaint-
Right here, the offense, the act constituted the offense under section 376 as well as section POCSO Act. Charge sheet was filed for section section 376 as well as section 6. But learned judge frames charge only for section 6.
Plus, why? For a very simple reason, Manoj. A1, FSL report happened at DNA ಒಳಗೆ, the A1 is found to be the
Father,
child.
biological father.
Yes, Manoj. So A2 has got no role to play at all in this. Yes,
We'll
unless he
see.
undergone 10 years of imprisonment. Even the complaint, even the definitions of the mother and the victim, no way they claim that we were
Yes, that we have seen. DNA test did not match with him. That accused number 1 had died, it seems.
Accused number 1, madam.
only for A1.
It was positive for A1.
Yes, madam.
Because PW4, one of the neighbors claims that A2 was never in the village at this time. He was always working with his family in Bangalore. So there's no fixing evidence.
We are trying to see that which is the provisions of the POCSO Act. It says if two offences, it overlaps. Punishment. Application of code of CRPC to the proceedings for special court. Alter section 42. Section 42. It says, was it by amendment? This was 2013 only, this amendment.
No, Manoj, yes, yes.
2013 only. This offense is in 2017.
14 minutes.
14. So after amendment, when an act or omission constitutes an offense punishable under this act, and also under section so and so, in that 376 they are all included, and IT Act, notwithstanding anything contained in any law for the time being enforced, the offender found guilty of such offense shall be liable to punishment under this act or under IPC as provides for punishment which is greater in degree.
So I think this 676, he is not even convicted for any of these offenses, Manoj, as mentioned in section 42.
He is not convicted for section 6.
Convicted for section 6.
Section 6 is convicted, no?
Manoj is completed 10 years, and even Manoj has to go through the entire evidence, the deposition. Nowhere, Manoj, there is any kind of clinching evidence that A2 has committed this offense to Manoj. Or Yaro through. A1 mentioned the name of A2, hence he has committed the breach.
A1 mentioned the name of A2.
That is what is coming in the deposition and even in the deposition of the victim, Manoj.
Victims.
PW2.
PW?
PW2, Lord.
PW2.
And there's also this discrepancy in her age, my lord. If my lord can see her date of birth.
Now, which document was produced to prove the age? You have disputed the age also?
Not disputed, Lordship.
Not disputed. Huh.
In page number.
There is no document as per the statute.
What is the name of this accused number 2?
Malad.
Mallappa.
Mallappa.
If my lord comes to page number 52 of the paper, my lord, you will see.
We are
that
seeing.
the birth certificate is given 2-3 different ages, my lord.
Madam, when you have not taken that defense before the trial court, now you leave it there. Again, we have to see whether documents were produced, etc. Now we are saying she has not spoken. She has spoken, no?
This one. She has stated.
In this paragraph, the name of A2, she has taken the name.
First, this accused number 1 took her to his house, committed rape on her. When she was coming out of his house, this accused number 2 saw her and told her that if she does not cooperate, he will reveal that incident to her parents. And Then on one day, blackmailing that he will inform her parents, he took her to his house and committed sexual assault. In the similar fashion, he committed 5-6 times.
Page number 54, fourth line from top, my lord.
When this A2's name was included in the FIR, first only she had, because there was delay, it seems.
Lord, they have 8 months. The mother doesn't know that the
In the
daughter.
complaint itself, it is there, members.
Complaint, his name is there.
It is there, members. Page number 107, relevant portion, members.
My lord, page 54 on military, my lord.
We are reading, we read that, 54.
ಅತ್ಯಾಚಾರ ಮಾಡಿಲ್ಲ ಮಲ್ಲಪ್ಪನು ಸಹ ಅತ್ಯಾಚಾರ ಮಾಡಿದ್ದಾನೆ ಎಂದು ಹೇಳಿರುತ್ತಾನೆ.
Where is 54 only?
Page number 54, my lord. Print page number 3. The third line onwards, my lord. ಅತ್ಯಾಚಾರ ಮಾಡಿಲ್ಲ ನಾನೊಬ್ಬನೇ ಅತ್ಯಾಚಾರ ಮಾಡಿಲ್ಲ ಮಲ್ಲಪ್ಪ
ಹೇಳಿದನಂತೆ ನಾನು ನಂತರ ನಮ್ಮ ಅಮ್ಮ ಮನೆಗೆ ಹೋಗೋಣ ಬಂದು ಕರೆದುಕೊಂಡು ಹೋಗಿ ಕೇಳಿದ್ರು. ನಾನು ಅವರ ಬಳಿ ಎಲ್ಲ ವಿಷಯ ಹೇಳಿದೆ. ನಂತರ ನನ್ನ ಅಮ್ಮ ಹಾಗೂ ಅಪ್ಪ ತಿಪ್ಪೇಸ್ವಾಮಿ ಹಾಗೂ ಮಲ್ಲಪ್ಪನನ್ನು ಕೇಳಲು ಹೋದಾಗ when they went, accused number 1 said that not only me but accused number 2 has also committed it. No, you were saying that victim has not involved him. Victim has also implicated him.
Implicated again that he said he has done it.
No, madam, you are misreading that. She says her parents went to ask accused number 1 about his act. Then he said, not only me, accused number 2 also has committed the same act. Why are you asking me alone?
But my lord, there's also a lot of difference in the versions at page number 69 and page number 46, my lord, of the same.
Is it the first application? This is 2018 matter. Is it the first suspension application?
Yes, my lord.
Yes, madam.
It is pending since 2018 only.
Yes, ma'am.
Serial number
I2 of
2.
18. Serial number 3, I2 of.
All right. Yes.
And the remission also, my lord.
If you would have argued the matter is itself is of 2018.
I for the NOC, my lord. As for now on record.
Right, you can see, we'll list it in the next week. We'll pass orders on this. See, if you feel that there is a very good case for you, because this act involves a presumption clause. She has supported. Then you can argue in the main matter.
That is what the order says, my lord, on 31/10/2019.
31/10?
31/10/2019. Order passed on this I2 of 2018, my lords.
It was
Right
order.
along with the main matter, that is the order.
No, we said, see, now they file application and keep them pending.
So that is an order.
Then they go, start blaming the courts. Application is pending, court has not taken up. So we ask the office to list all these matters.
There is an order passed by the Senate court, my lords, to take up this.
We can consider that. We can recall that order and pass order.
That is right, my lords. So
Probably-
any of my lords, paper book is ready.
Date?
31/10/2019, my lords.
31/10/2019.
19.
Probably somebody might have submitted. Oh, it's not our order. History. 31?
10/2019.
10 now. Twenty-three 8 ಆದ್ಮೇಲೆ 31/10 RVMs ಅವರದೇನೆ. But it should
Yeah,
be considered.
I am
if
not-
he
I am
says
not-
so, it should be considered.
No, I
within
am
a
not coming in the way.
reasonable time.
No, I am not coming in the way of my lords considering.
We'll
Our
order-
paper book is
we'll
ready.
pass orders on this application and we order to list it. And your ground is that, your main ground is that this section 325, it applies only to the IPC offences, no? That's all? And imprisonment, he has already served 10 years.
Actually, it's got a remission of 1 year, 7 months and 3 days. It's there in the custody.
You have produced.
Yes, sir. On 1/4/2025.
See, if at all somebody is, suppose falsely implicated, they should not suffer
Yes,
unnecessarily.
it may be heard finally, my lords. I don't know. Paper book is also ready.
Because now you had seen previously how, what kind of roster we had. And so many cases, 10,000 cases were there earlier on our roster. In a way, it is correct, because not because of non-application. There may not be strong evidence Unless to read the evidence. Sometimes yes, there is chance of taking. No, why the trial court sentenced him in two different 3 to 5 life imprisonment and this because he had already delivered a child also. If at all trial court was convinced, had convinced that he has committed this aggravated sexual assault, then it could have granted the same punishment for both of them. This was in 2000. It was not punishable with 10 years maximum. It was up to life, no?
3 to 5 up to
Even
life.
in 2013, it was up to life.
Please.
Or 2018, that amendment was
2018 में amendment आ गई. Before that
3 to 5.
only 10 years. Maximum punishment was 10 years.
Section 6.
We'll see. It shall not be less than 20 years, but which may extend to imprisonment for life.
Imprisonment for life.
Before that, what was this? Shall be punishable with rigorous imprisonment for a term which shall not be less than 10 years.
Less than 10 years. Yes,
No,
madam.
no, it was life imprisonment.
That time also it was
Only that minimum sentence was less.
Yes.
Now it has become 20.
Yes.
So judge was very kind enough to
Award
impose
minutes.
sentence for sexual.
ಅದಕ್ಕೆ ನೋಡ್ತಾ ಇರೋದು.
See, he should have, that is the case. Two of them, they would have reduced that. And he should
Does
have
that.
rather give us a lifetime sentence. Orders on a number. Two of them. No, some emotional. He should not do that. The judgment also is then if we have to take it up, we have to furnish the translation, judgment and other things. Now we start facing this problem because the portions invariably in sessions cases then one application is no, it translates immediately, but you have to correct that because that will be incorrect. You have to orders on number 1 of 2 of 2018. We'll record that also. It was ordered to be. Orders. Orders. I 2018. I'm sorry. By order dated. What is the date of that order? You said it's very 2019. Got it. 31/10/2019. By order 31/10/2019. I 2 of 2018 was ordered to be heard along with the main matter. Considering the fact that appellant, learned counsel for the appellant contends that for the offence under the Pox Act, the appellant accused number 2 was sentenced for 10 imprisonment of 10 years and has already served that. And wherever IPC offenses are not IPC offense carrying a sentence more than 10 years is not involved. Section 3 to 5 of the SC/STPA Act is not applicable. Therefore, the matter is taken up for consideration of IA. And the accused is in custody since 10 years, since more than 10 years. Having regard to such submission, I 2 of 2018 is taken up for consideration. Heard both sides. The trial court, by the improved judgment and order, has convicted the appellant. Only there are 2 more. They are acquitted, no? 3 and 4 were acquitted. Has convicted the appellant for the offense under section 6 and 5 and 6. Wide 6 read section 34 IPC and section 3 to 5 of the ACSTPA Act. Accused number 1 died. Accused 1 who was alleged co-abuser of the child died even during the trial, no? Pending trial. Accused number 3 and 4 are acquitted. The charge against the accused was that the victim, she is PW? PW to the victim, a minor victim belonged to scheduled caste. The accused, they harbored him. 3 and 4, no, they threatened, intimidated. Accused number 1 and 2, abused her subjected her to aggravated sexual assault multiple times. Consequently, she conceived and delivered a male child. Delivered a male child on which date?
Date of birth.
Date of the child is there in the charge sheet. She was taken to the hospital on 26/6/2015 and she was found 7 months pregnant. Conceived and delivered. Is it there in the charge? But it has come somewhere. No, about her delivering the child. (98) 2015. She delivered a child on 19/8/2015. Expert. It is true that the DNA profiling of the child did not match with deceased accused number 1 and did not match the paternity of the accused number 2. However, PW2, the victim, in her orders for the trial court has supported the prosecution version about aggravated sexual assault on her by the accused. So far as the records show that the charge sheet was filed for the offence under section 376 as well as section of IPC as well as section 6 of the POCSO Act. Even charge was also framed for 376. ಮಾಡಿಲ್ಲ ಈಗ ನೋಡಿದ್ವಲ್ಲ ಕರೆಕ್ಟ್. However, the learned judge has convicted, though held that the aggravated sexual assault was proved, has convicted the accused for section 6 of the POCSO Act alone. Probably in view of section 42 of the POCSO Act. Considering the aforesaid material, it's not a fit case to grant suspension of sentence and hence the application is rejected. List for final hearing on
25/6.
25/6. Can you give this translations by that time? We'll take up the matter, of course. By that time. 25/6, is it possible? The appellant's counsel shall furnish the translations of at least material Kannada. You have to furnish the portions and.
I had given a synopsis, the report had asked me. I had given a very brief synopsis of all the depositions in English. And last time, the honorable court
Some reports are in English. Really, because that.
I have given everything on one form.
ಏನ್ ಮಾಡೋದೀಗ ಟ್ರಾನ್ಸ್ಲೇಷನ್ಸ್ here they record in Kannada because they have to multiple time now. We have to, if we record in English again, we have to explain to them. That's why they record it is their language, they record in Kannada only. Only where official witnesses others come, they will record. The appellant's counsel shall furnish the translated copies of the Kannada depositions and documents. He can furnish here only. I can't be allowed at this stage because victim has supported. Madam, you are disputing here. That's
Here
why we
only.
asked you whether I had taken that contention. You argue the main matter itself. We can close this. Either way, if you succeed, you will succeed. Anyhow, no. For all these years, you have not pressed this application. Next on. See, tomorrow there should not become a ground if any of you go to the Supreme Court, right? So to avoid that, you furnish the copies. Now, at least I can say I have translated those documents are in English. Medical documents are in English. She had given the history. So we understand your difficulty, but ಮಾಡ್ಕೊಡಿ ಏನಾಗುತ್ತೆ ನೀವೇ ಕುತ್ಕೊಂಡು ಮಾಡಿಸಿ. How many colleagues you have? For her? We told you the easiest method. You go to that translation app and correct that subsequently wherever there are errors. No, you can work on that. This translation app. This
Pastor matter, serial number 7, Rakshita, SPP.
Serial number 7. They had not come. Morning. ಏನಾರ ಬರಲೇ ಇಲ್ವಾ? Morning. This person had not come. Rakshitar. We condone the delay. We'll appoint some person as amicus curiae because if they appear and they do not do justice to them, learned counsel. The matter was passed over. The appellant's counsel did not appear till 3:40 p.m. The appellant is in judicial custody. Therefore, ಯಾರನ್ನು ಮಾಡೋಣ? ನಾಗರಾಜ್ ಹೆಗ್ಡೆಯವರ ಇವರು ಇದ್ದಾರೆ. ಆದ್ರೆ ಮಾಡ್ಬೇಕು ಅಷ್ಟೇ. ಯಾರೋ ಪ್ರೋಬೋನ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರೆ ನಮಗ್ ಜಾಸ್ತಿ ತೊಂದರೆ ಕೊಡಬಾರ್ದಾದ್ರೆ ಸರಿ ಅಷ್ಟೇ. Some of his was telling she does pro bono for the criminal cases. They should be brief. ಸಂಪಂಗಿರಾಮಯ್ಯ ಇವ್ರು ಕುತ್ಕೊಂಡಿದಾರಲ್ಲ ಅಲ್ಲಿ ಅವ್ರು ಶಂಕರ್ ಅವ್ರು ಮಾಡ್ತಾರ.
HS ಶಂಕರ್.
This is a matter of 2024. Therefore, she in Shankar HS Shankar counsel is appointed as amicus curiae to assist the court on behalf of the appellant. Now paperbooks are all with him. No, they have to prepare the paperbooks. Registry that I think morning we had dictated all of that part. No? Admit call for TCRs. Suspension of sentence. Do you argue that? TCRs. Admit call for TCRs. Paperwork shall be prepared within 4 weeks from the date of the receipt of the TCRs. Copy shall be furnished to the amicus. Registry shall furnish the copies to the amicus curiae. List on the list of the receipt of TCRs.
Pastor matter, serial number 19. Akash Kumar Gowda, DM Manjunath, M Shivaprakash.
That I'm filing application for exemption.
Oh, that argument matter. ಅದೇ ಇವಾಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಡೀತಾ ಇತ್ತಲ್ಲ. That the caste title has shown them correctly. Complainant. ಸರಿ ಮಾಡಿದ್ದೀರಾ? One accused number 1. You should have shown them as accused number 1A and B, etc. Madidara? See, dictation, not now. It was being shown to us that 2A, similar to case. 3A. Okay. Correct and give the corrected copy of the amended copy of the complaint.
I'm filing application for exemption, madam. in this.
The exemption.
An exemption for
Accused are not present despite direction to no constitutional complaint seeks permission. Oh, idರಲ್ಲಿ you sought permission to retire in the morning. Who knows he is his son? No, who knows who he is his son? He was there on record, no. She is not alive. She is alive. And then you have to issue notice and retire. Is there any? ನೀವು ಅವ್ರ ಮಗನ ನೀವು ಯಲ್ಲಮ್ಮನವ್ರ ಮಗನ ಏನ್ ನಿಮ್ಮ ಹೆಸರು ಏನು ಏನಿಯ ಏನು ಅವ್ರೇನು ರಿಟೈರ್ ಆಗ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ ಯಾವ ಬಟ್ ಶಿ is not here. He is not the complainant. That we understand. What is you have a ration card that to show that you Aadhaar card alla. He is her son and she is at least ration card would have shown that. You issue notice and retire. We'll give you and some other. What is application? Now consider the accused. Submit application for exemption of which accused? Application seeking
accused number 1A, madam.
appearance of
Accused number 1A.
accused. Simply accused. Exemption granted for the day.
Please, madam.
We'll grant for the day because he is also not ready. List on. This was for preliminary. No, one is withdrawn in this.
One minute.
List on 2 weeks. Put up. If you want to retire, you have to issue notice and retire.
2/7.
Obliged, madam.
2024 matter.
Pastor matter, seal number 21, Omkaresha.
My lords, I appear for the respondent state in this matter, my lord. My lord, firstly, I apologize for appearing on VC, my lord, because of some medical emergency in the morning. I had to rush back home, my lord.
Allah, the matter ಆಯ್ತು ಏನು some they recalling ordered correct this educational institution. Now in view of the Supreme Court judgment, this may have to be recalled. The order dated 1712.
My lord, this matter was disposed of in 2015, my lord. Thereafter, we do not have any files in
On
our office.
1712, this complaint was dismissed. Now
Yes.
you have come up with reopening that on the ground that Supreme Court has set aside that order. We are asking her, those applications are pending still. This, have you seen that judgment? Supreme Court judgment?
No, my lord, we do not have a
Mr.
copy of
Counsel,
it.
not for you. Please try to understand. The counsel is appearing there. You are. Do you know that which applications are pending?
I'm aware, my
On
lord.
on which matter you are arguing today? You are arguing on which matter? Recalling applications. We have heard you. She is not here. That's why we are asking her. Have you seen that Supreme Court judgment?
I'm sorry, my lord, I have not seen that judgment because the office file is not traceable in the office, my lord. I shall obtain a copy and make my submissions next week, my lord, so that I can make my submission. We have filed our objections. The cause list reflects that we have filed our objections to the
Supreme
IA.
Court has set aside that order. How can you file? Take up any objection for that?
My lord, then the application may be allowed, my lord. Matter restored back to file. I shall take instructions, my lord.
What is the objection you have stated in your counter?
Lord, I do not
Actually,
have
there
the
is
file.
not delay. When that Supreme Court order is passed, along with IA, you have produced, no? No, I think it is saying that this judgment is passed on 12/8/2016. Correct. When have you filed these applications?
23, my lord.
23. Why such a big, long delay? Was it a civil contempt?
Civil contempt.
Civil contempt. Then beyond 1 year, how can we take notice?
Process.
Mr.
Continuous option was there. And in spite of that, they are not given as a result of quite another petition. There is asking seeking direction. That was also allowed and directed. And nothing has been considered. As a result, also other.
No, our apprehension is because there is 1 year limitation is there. It should not amount to some irregularity. See, Contempt of Courts Act, see the Contempt of Courts Act. They have filed it after so many years.
Judgment, that judgment is covered by full court judgment may not.
The Contempt of Courts Act. Limitation, what is that? Limitation is 1 year, no? Which is that provision?
20, Section
Limitation,
20.
Section 20.
20, my lord. 20.
Sure. ಆಯ್ತು ಕೊಡಿ ಹೇಗಿದ್ರೆ ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತ see all right it is there of course before Supreme Court has succeeded but now you have moved it after a long time you could have then only you could have come and go.
That is the reason I have taken this judgment.
Right, but
Categorically absurd. Article 213
right, but try to listen to us. You were the advocate who were conducting all along. Whether you were the advocate who was conducting the case all along. Listen, see, instead of filing another writ petition after the Supreme Court judgment, they could have got this only reopened.
Is the reason. Para 87, it was seen absurd.
Even without contempt of court, sir.
4361 number.
Only to the contempt of subordinate courts.
Yeah, it is applicable only to subordinate. And thus the ruling has been given. Yes, we are satisfied with that. It is Article 215 of Constitution is applicable to this.
Right. Now here, first contempt was filed. I mean, alleging non-compliance of writ petition number 7284. Writ petition number 4808 of 2012. Right.
It was filed in 2014, ma'am.
Correct. We had a doubt whether after so many years we can condone this. Now he is showing the Supreme Court judgment. And there is, if the contempt is not of the subordinate court, then Article 215, court can recall that order. I mean, delay will not come in the way. Is applicable only in respect of contempt of subordinate court. No application in cases where contempt of High Court. Para 50. We respectfully agree accept that. We are not called upon to decide the wires of section 15 and 20. In the question we express in our opinion. Therefore, our conclusion is that period of 1 year in section 20 of the Act is applicable only in respect of contempt of subordinate courts. It has no application in all. What objection they had raised for this? What objection they had
Objections
raised?
are filed for the delay application.
Delay?
Delay application. Delay objections ಹಾಕಿತ್ತು.
Where is that counter filed by you? And I 2023 for condonation of delay. Statement of objection. Same cannot be a ground to condone delay. 270. Dealing. But even in our counter also you have not stated that Section 20 bars condonation of delay. You are not said in your counter. We are asking them only why it is, why you become so anxious. But orders and I number. This complaint was filed. First time evidence was recorded? No, it was only an inquiry. First time evidence was not recorded. Charge was also not framed. This petition was filed alleging contempt of this court by disobedience of judgment in the order passed by this court in writ petition number 48,008 of 2012, CMREs, and writ petition number 48, that's enough. Okay. On 8/2/2013, by the said order, the learned single judge of this court had directed the respondent accused to abide by the order passed in writ petition number 8649 of 2005 and connected matters within 2 months from the receipt of the said order. In WP number 8649 of 2005 and connected matters, the learned single judge had directed to consider directed the respondent is to consider the report of administrator and pass orders within 1 month from the date of the receipt of a copy of the said order. Pending the above petition on the allegation that some documents submitted by petitioner institution in the inquiry was a forged one. Forged one. Here also inquiry was directed, no? First it was dismissed for non-compliance.
Please, madam. And thereafter it was, an application was filed, my lord, for not pressing the contempt petition.
So
my lord.
not pressed, they said not pressed. And that's why an inquiry was directed, no?
My lord, inquiry was directed so far as production of a government there were 2 sets of orders which was passed by the administrator, my lord, out of which one was a tampered document against which inquiry was initiated, my lord.
And consideration of this court by order dated 11/12/2015 observed that application pending the above petition contempt for complaint, pending the above complaint, the response said to have accused said to have conducted some inquiry, and it was reported that the letter submitted by the administrator was forged one. This court holding that there is some foul play on the part of the complainant, dismissed the complaint with cost of rupees 25,000 payable by the complainant. There is no dispute that the complaint challenged the said order before the Honorable Supreme Court in special leave to appeal into bracket C number 8363 of 2016. The Honorable Supreme Court by order dated 12/8/2016 set aside the. Where is the question of recalling that order now that a judgment is set aside? That order is set aside by the Supreme Court.
No, it is not set aside. There are A and B orders are there. Only,
see, it is said first. Despite repeated orders by the court, management is being continued by the administrator. That is not the issue arising in the order of in contempt petition. The only permission sought by the petitioner was to withdraw application, which the High Court permitted on payment of cost. Okay. However, in view of the admitted position that there was delay around 6 years in complying with the orders, we find there is no justification for imposition of cost. Therefore, special leave petition is disposed of expunging the adverse observation made by the High Court and also vacating the order of cost. For any other grievance, it is for the petitioner to work out before the appropriate court. Right? So, the order happened. Supreme Court by order dated 12/8/2016 while setting aside the order with regard to cost, held as follows. Since the Honorable Supreme Court took exception for continuation of the administrator, the complainant filed another writ petition. The Justice Sanjay Gowda's judgment you have produced, no? There is filed writ petition number 21,514 of 2016 into bracket GMKSR seeking directions. What was that prayer there? Direct order to restore the possession of the management. Seeking cautioning of the appointment of administrator. That order dated 9/12/2025 is appointing an administrator. Yes, sir. This was research is dissolved antana. It is said ಮೇಲಿನ ಎಲ್ಲ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸಾರ್ವಜನಿಕ ಹಿತದೃಷ್ಟಿಯಿಂದ ರವೀಂದ್ರ ವಿದ್ಯಾಸಂಸ್ಥೆ ಚಳ್ಳಕೆರೆ ಈ ಸಂಸ್ಥೆಯನ್ನು ವಿಸರ್ಜಿಸಿ ಎಲ್ಲ ಚರಸ್ಥಿರ ಆಸ್ತಿಗಳ ಹೊಣೆಗಾರಿಕೆಯನ್ನು ಸರ್ಕಾರವು ವಹಿಸಿಕೊಳ್ಳುವುದು ಸೂಕ್ತ ಎಂದು ಆದೇಶಿಸಲಾಗಿದೆ ಅಂದ್ರು. ಅದೇ ದೇ ಡಿಸಾಲ್ವ್ ದಿಸ್. Questioning the order of the response dissolving the institution and taking over the management by the government, and for direction to respond to the response to restore the position of the said educational institution, complaint educational institution to them, the management of the institution. That petition came to be allowed on 5/4/2023. Under the aforesaid circumstances, the above applications are filed seeking recalling of the order dated seeking condonation of delay of 1998 days in filing IA number 1 of 2023 and for recalling the order dated 17/12/2015 The records show that an CID conducted investigation about the forgery of the order of the administrator, and ultimately C report was filed. The complaint or any of its office bearers were not indicted in that matter. Considering the the only objection of the respondent accused for recalling the order dated 17/12/2025, 2015 is that there is delay. Sorry, inordinate delay. There is inordinate delay in filing those above applications cannot be condoned in view of section 20 of the Contempt of Courts Act. The full bench of this court in Messrs. A.V. Kaudi and Company versus R.V. Lakshmi Devamma. While holding that section 20 applies only in case of contempt of subordinate courts, and so far as the contempt of order of this court, Article 215 does not get affected by section 20 of the Contempt of Courts Act. Paragraph 15 of the judgment, which is relevant for the purpose of this case, reads as follows. Yeah. In the present case also, the alleged contempt is with regard to the order of this court. Therefore, there is no merit in contention regarding application of section 20 of the Contempt of Courts Act. Hence, the applications are allowed. Then when there is no delay, where is the question of recalling that? According to this judgment, the section 20 is not applicable. Then the delay of so and so days in filing I number 1 of 15/12. This is the statement says that section 20 is not applicable. 17/12/2015. So rejecting the complaint is hereby recalled. The complaint is restored to the file. Okay. It was to be heard on a preliminary hearing.
Lord, I pray for 2 weeks' time, Lord, to seek instructions in this matter.
And I had CP6, 2 weeks' time for preliminary hearing. List on
30th.
3/7. But it is 2014. It becomes 2014 matter on our file.
Yes, ma'am. I shall take instructions immediately.
Take instruction. There is another subsequent order of a single judge also. Ask them to comply if it is.
I
If
shall.
that has attained finality. It seems that is also 2023 order.
I shall take instructions and make my submission. On 6th of July, madam.
Oh, you do.
Pleasure.
Last ಅಪ್ಪನವ್ರದ್ದು ಇನ್ನೊಂದು ದಿವಸ ಅಪ್ಪಯ್ಯ ಅವ್ರದ್ದು ಇನ್ನೊಂದು ದಿವಸ ಕಂಟಿನ್ಯೂ ಮಾಡೋಣ ಹಾಗಿದ್ರೆ. There are two matters. We are in the midst of one parted matter. ಎಲ್ಲಿದ್ರು ಅವರು? He is not there here. PB Appaya, cell number 24. You are there in that matter. ನೀವಿದ್ದೀರಾ? You are there in that matter. No, there is one 230 matter where Mr. Rajgopal is appearing, and we have heard Mr. Appaya in part. Yes, choice is yours. Whomsoever. Your matter is 2023. Which is your matter, Mr. Appaya? 17. Then we'll take up that matter. We'll adjourn your matter.
Very good.
No, your matter is 2017. Their matter is 2023.
Oh. I'll finish in 5 minutes.
Would it possible to accommodate any date this week? Witness Thursday or Friday?
We have to recollect what was the rectification of office objection raised on additional compliance report. rectification of office subsection, modify the order dated 15/12/2024. Advocate, complainant's advocate also has filed. You represent a complainant. No, you represent the he represents complainant. Who represents the accused here?
Lord, I represent Lord.
We have to recollect what is this.
Oh, dear.
What are these office subsections compliance?
Lord, copy serve.
Compliance of it.
Service of copy have served already, my lord.
Just that is there. We'll overrule that. Rectification of office subsection. These files always get office subsection compliance affidavit. ಏನ್ ಹಾಕಿರ್ತಾರೆ ಇವ್ರು ಏನ್ ಬರೀ ಹಾಗೆ ಬರೀತಾರೆ
ನಾವು ಸರ್
what is that objection
complaints affidavit of
ಎರಡು
accused.
affidavit ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ but
ನಾವು
they
sir
don't even
serve ಆಗಿದೆ
mention
sir.
what is the date of it.
There are two complaints lord affidavits. One is lord.
On additional compliance affidavit.
It was filed on 19 February 2025.
19 February.
Various orders are passed time to time and
Yes.
directions are issued. Installment basis.
These matters become like company matters. Keep it pending all along. Yes. Morning there was one matter where there are 9 volumes.
Copy serve ಆಗಿದೆ.
ಏನದು ಅವರ ಆಫೀಸ್ ಸಬ್ಸೆಕ್ಷನ್ ಯಾವುದ್ರ ಮೇಲೆ? No. Rectification of office subsection raised on additional compliance affidavit. They don't even mention advocate for the accused. Filed by advocate for the accused.
ಅಲ್ಲ ಅದನ್ನ ರಿಜಿಸ್ಟರ್ ನಾನು ಆಫೀಸಲ್ಲಿ ಚೆಕ್ ಮಾಡಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತೀನಿ ಸರ್. ಏನೋ ಇದ್ದರೆ we have served the copy on other side.
They should write no what is that office
ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ನೋಡ್ಕೊಂಡು ನಾವು ಮಾಡ್ತೀವಿ.
Additional affidavit. When did you file the additional
Lord,
affidavit?
19 February 2025, my lords.
19 February 2025.
Additional is 19 February.
Huh.
The complaints affidavit was filed, my lord. That
And
is
rectification of objection raised on additional compliance report.
additional compliance report.
That is. One is affidavit, another one is report, compliance report. When did you file that?
Lord, additional compliance
On
was
the
filed.
19 to 2000. Why do they raise these kinds of objection? But, even outer sheet is also like that. Correct. They should say what is that objection. English translation copy of Kannada annexures to be filed. Correct. Here they have mentioned in the list regarding rectification of office objection raised on additional compliance affidavit filed by advocate for accused. English translation copy of Kannada annexures to be filed. Then rectification of office objection raised on additional compliance report. That is annexures to be attested by the competent authority. English translation copies of Kannada annexures to be filed.
I'll do the needful, my lord.
Learned counsel for the accused seeks time to comply the office objections. You do it. Yes, then we'll have after 10 days.
Yes, my lord.
After 10 days.
That I think could be heard during this week, possible.
Come.
See, now there are
Our end we can commence the.
Kannada translation. That is the problem. English translation.
We have filed.
You have filed those translations.
Document already translated. That is translated version is already part of this.
Where is that?
Memo of calculation I have filed.
Memo of calculation. When did you file? He do not know. Let him comply. Memo of calculation is here.
Memo of calculation dated 10/1/2024.
Here. No, they are also in Kannada. 10 days before. List on
26.
26. You did file positively by that time.
26.
26. At 2:30 p.m. You complied by that time.
For arguments, seal number 24, PDFIR.
So other matters may not reach. Yes. We'll repeat these matters, no? No, there is one matter, 25 is 2015. We can have it tomorrow.
Repeat matter.
25. ಅಷ್ಟಾಗೆ ಬಿಡುತ್ತೆ ಇಲ್ಲ ನೋಡ್ಕೊಂಡು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ.
Seal number 25 tomorrow.
Release tomorrow.
Seal number 26 adjourned. Seal number 27, Rennie Sebastian. I will repeat.
Released. These are the older matters or are more older?
Seal number 28, M. Shashidhara.
Tomorrow. Tomorrow. In notice.
Seal number 29, M. Shashidhara.
ನೀವು ಯಾವ್ದ್ರಲ್ಲೂ ಇಲ್ವಾ? ಹಾಗಾದ್ರೆ in your matters also Kannada paper books are in Kannada?
Yes, madam.
Then
Evidence is deposition is in Kannada.
ಎಲ್ಲದರಲ್ಲೂ ಹಾಗೆ ಇದೆ ಈಗ 15 ಯಾರ್ದು you have 3 matters. ಏನು ಇಲ್ಲ ಅಂದ್ರೆ we'll do one thing, we'll see for 1 week if there are again any changes. Now we'll order to list them.
Judgment ಕೂಡ ಕನ್ನಡದಲ್ಲಿ.
ಒಂದು ನಿಮಿಷ ಕೊಟ್ಬಿಡಿ.
25.
We'll take one after another. 25.
ಅದರಲ್ಲಿ accused number 1.
Number 25.
She is languishing in jail for the last 12 years. What I noticed.
Direction ಇದೆ ಅಂತಲ್ಲ
No,
ಇದ್ರಲ್ಲಿ.
though I appear for.
No, accused number 4's appeal.
ಒಂದು ನಿಮಿಷ.
Placed below.
ಇರ್ಲಿ ತಡ್ರಿ ಹೇಳೋಣ.
11 years 9 months.
Clarify ಮಾಡ್ತೀನಿ.
ಹೇಳು.
Super direction ಅಲ್ಲ ಅದು.
Oh, the same judge. That one which we have now.
Same period appeals.
ಏನಿದೆ ಡೈರೆಕ್ಷನ್? ಏನಿಲ್ಲ.
220 we have for. It is a small matter. Can you furnish the translation? No, you are saying she is in jail for
12 years. No evidence is let in against her, but still she is convicted and she is languishing. Nobody has spoken about her.
Correct, Mr. Doctor. ಈಗ ಅವರು ಓದಬೇಕಲ್ಲ.
Next week.
Can you furnish the
Translation of the judgment.
Everything is in Kannada.
The deposition.
Most of these criminal appeals are like
Kannada
that.
only.
Few judgments are in Kannada, but depositions invariably in Kannada and mahazars, everything will be in Kannada. We'll do one thing. We'll list it in the next week instead of directing to furnish the translation copies. Then if there are any changes now after 1 week, because incoming judges.
Next week could be. No problem.
Relist on, we'll say like that. And due to paucity of time, there is in this matter more particular the Supreme Court direction.
What has transpired is, what is my lords? Here is a case wherein accused number 4, who stands on the same footing, my lords, as that of accused number 1 to 3, his appeal came to dismissed by this honorable court. That appeal is pending before this.
445 and the no 445.
Yes, ma'am.
What happened in that case?
That matter is pending before the honorable apex court, my lords, wherein bail has been sought for. Bail has been sought for in that application, in that appeal. For that, my lords, there is an observation with the apex court. Then adjourned by my lords.
See, what is the observation?
Observation
Bail applications of co-accused are pending consideration before the High Court. Hence, this matter may be adjourned. A similar request was made on 12/2. In the circumstance, this matter stands adjourned. Registry to dispatch the copy of this order.
That is the only observation.
Now, in this case, there is no bail application pending.
There is no
pending.
ಎಲ್ಲಿದೆ?
Pending there. My application pending.
Oh, suspension. Right.
Yes.
The accused number 2 has been granted.
Appellant number 3 million.
This is what we were telling morning that madam was arguing. They say this shall be heard along with the main matter. Sometimes court may say, but ultimately applications are pending for years together. That does not reflect well on us. So we can dispose of the application and take up the matter for this thing.
This matter, my lords, why there was delay in hearing the matter?
Judgment in 449. Can you give us the judgment in that?
It is there, my lords. It is on record, my lords.
It is on record.
445. It has been furnished.
Produced Supreme Court judgment is.
ಇಲ್ಲ ಇಲ್ಲ ಇದರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಲಾಸ್ಟ್ ಟೈಮ್.
ಕೊಟ್ಟಿದ್ದೀರಾ?
And here is case wherein appeal number 2, appellant number 2, who has been
Finding any judgment here?
ಕೊಟ್ಟಿದ್ದಾರೆ.
No.
ಇಲ್ಲಿದೆ ನಾ
ನಿಮ್ಮ ಹತ್ರ ಇದ್ರೆ
ನೋಡ್ಲಿಕ್ಕೆ. It should have been heard along with all these appeals. Unfortunately, it was heard and disposed of.
It was linked with my lord's appeal 445 of 2015.
They ought not to have decided.
appeal of case 4 is dismissed. Okay. Will those records are pending in the Supreme Court?
No.
We can.
Why it has
Directed the registry to list, place the papers of this criminal appeal number 445.
This is in fact connected with this matter on my lords which has been separated.
Why it was delinked?
Delinked is for the reason that my lords appeal number 2, that is appellant number 2 in the present appeal, who has been granted parole, my lords, by the jail authorities, he is still absconding, my lords, because.
That we had read. But why? Then if he was absconding, how the judgment was passed?
Lords.
He is absent.
Not this accused, my lord. Accused number 2 is absconding.
Not this
number
accused.
4.
He is accused number 4.
He is
Accused
accused
number
4.
A4. Correct, madam.
Now these appeals are by whom?
Accused number 1 to 3.
1 to 3.
1 to 3. Now accused number 2 is secured.
No, my lord, still he is not secured. Because of that, my lord, it is kept pending, my lords. Parole.
2019, it is.
That's why we are asking, if accused number 2 is not secured, why only against one person it was delinked?
Lords, after 1 year, though I have made submission,
Maybe that
lords.
is a separate appeal, that way one thing, but here also at least some
This is-
steps,
My lords, in fact, my lords,
getting his appeal against him or appointing some amicus curiae unless he is secured.
Amicus curiae madak barala anta ಹೇಳಿ, because of that, my lords.
No,
In fact, there was
now I
direct.
am appointed as amicus curiae for A2.
You were appointed, then we could have heard him, no? It is for the state to secure and see that he serves the sentence.
We are making best efforts, my lords, since parole proceedings, my lords, there were several directions in this, my lords, in this appeal.
Go missing, he is from Andhra Pradesh.
All are from, all
Can
four.
I- what
All
I'm-
4 are, 5 are from Andhra Pradesh.
But now,
There were directions to the DG and HPP, my lords.
what about splitting the case from him, for him in this, and hearing the other parties? Madak paralva. When you can split up the case in the trial court, can't you do it in the appellate court?
Appeal ಅಲ್ಲಿ ಬರಲ್ಲ. That in fact, that was discussed, my lords, on the previous occasion, my lords, by coordinate bench with regard to that aspect also. Even that aspect has been, my lords, discussed.
Inherent powers of 482? Just to check
Yeah.
that, otherwise why these people should be in jail? Or he is right, otherwise we have to grant bail. But one person who has gone on parole has not come back. How to grant bail to the other two?
The matter could be disposed of.
Correct, now how to dispose of? He is saying accused number 2 is not here, appellant number 2.
In fact, there were several directions, my lords, to secure the presence of appeal number 2.
Just you clarify that legal position. Whether even in his absence, with assistance of the amicus curiae, we can dispose of. If he is released, that goes. I mean, if judgment is reversed. Otherwise, it was for the state to secure his presence and see that he serves the sentence. ನೋಡಿ ಅದನ್ನ position ಏನಿದೆ ಅಂತ.
ಇದರಲ್ಲಿ ಅದು if the records pertain.
Why it is listed for final hearing? Go ahead.
Amicus curiae has been appointed only to, for that particular purpose, my lords, to assist the court with regard to that particular point.
Sir, if that is
No,
the case,
to ascertain, my lords, whether it can be bifurcated or not, my lords, whether to proceed with the matter or not.
while appointing amicus curiae, these things were not discussed.
Lords,
Now amicus curiae is appointed. Then we'll not worry about these things. We'll dispose of the main matter itself.
Correct.
amicus curiae appointment ಮಾಡಬೇಕಾದ್ರೂ ಕೂಡ ಇವೆಲ್ಲ ಪಾಯಿಂಟ್ ಡಿಸ್ಕಸ್ ಮಾಡಿಬಿಟ್ಟು,
When, what was the date of that order?
lords,
Last but one.
Last
19/2/2025, my lords.
20?
19/2/2025 is the date of order, my lords, appointing amicus curiae.
19/2/2025, no? Just wait.
For A2.
For A2 minutes.
19-2.
ಇವತ್ತಿನ appearing A2 ಮೊದಲು.
19. For accused number 1 is absent today. Shivamani Nathan. It is brought to our notice that appeal filed by A4. Ended in confirmation of the trial court judgment and accused number 4 has lost special education. CH-4 Learned Counsel for R3. Learned Counsel for A to submit that they were not aware of decision of criminal appeal. No, you were representing accused number 2.
No, previously I was not appearing.
Previously, before his.
My lords, earlier,
I was appearing.
Earlier, my learned friend was appearing for accused number 2.
So you don't have any intimation?
No.
He gave NOC
You gave NOC?
because he was absconding, my lords. In fact, I oppose my lord's retirement memo also because he has not served notice on the accused number 2, my lords, as provided under the law. But my lords, in spite of that, my lords, this honorable court permitted him to retire from the case. From there onwards, my lords, the situation arose because he was not able to be secured because he is absconding, my lords, since 4 years. The state is trying, making its best efforts.
But thereafter, when Mr. Halshetty was
Halshetty came on record, my lords, on
as amicus curiae?
19/2/2025.
No, 19-2, he was not appointed on that day.
Next date a little bit.
He was there before that only. Therefore, we appoint, that is on 12-2. See,
No,
the
it's,
order says
on 12/2/2025.
A2 is appellant number 2 in this appeal. All efforts have been made to secure him. Now I have one of these filed on behalf of A3 for suspension of sentence being caused because of abscondence of accused number 2. Since the appeal is of the year 2015, we can decide the appeal on merits by providing assistance of amicus curiae to accused number 2. So he is a privileged person. He absconds and he gets an amicus curiae also.
And on the previous date of occasion, my lords, all these things with regard to.
Then we'll hear and dispose of the matter. But the thing is, this judgment and other things are in Kannada. ನೀವೇ ಕೊಟ್ಬಿಡಿ ಇವ್ರೆ ಅದನ್ನ ಒಂದು ಸುಮ್ಮನೆ ಸ್ಟೇಟ್ನವರು ಅಟ್ಲೀಸ್ಟ್ ಗಿವ್ ದ ಜಡ್ಜ್ಮೆಂಟ್ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಕಾಪಿ.
Lords, it takes time, my lords, because I know the state condition of my lords translators in the state. I should not say about my lords that how it is working, translation department.
We have ನಮ್ದೊಂದಿತ್ತಲ್ಲ translation wing, we have one translation wing here. Mr. So we can give the translation copy of the judgment.
Judgment copy I will.
By next hearing date, at least you give the translated copy of the judgment.
ಕೊಡ್ತೀನಮ್ಮ. Only judgment copy.
You at least furnish that, we'll see. Paper book ಇದೆಯಾ?
Paper book is there.
ಮಾಡಿದ್ದಾರೆ.
Paper books are there, my lords.
Now all other documents are everything is in Kannada.
ಹಳೇದು ಕೊಟ್ಟಿರೋದು 445 ಇದರಲ್ಲಿ ಇರೋದು ಕೊಟ್ಟಿರೋದು.
ಒಂದೇ paper.
Everything is in Kannada. Only few thing is in their ID proofs are in Telugu. Sister has to translate it for her.
Let the records of 445 may please be taken in this file also.
But they will also be in Kannada.
Yes, but records ಅಲ್ಲಿನೂ ಇದು ಮಾಡಿದೆ ಇದ್ರೊಳಗೆ ಸೇರ್ಕೊಂಡು.
No, that's why we asked whether those records have gone to the Supreme Court in appeal.
No, ಹೋಗಿಲ್ಲ.
ಹೋಗಿಲ್ಲ.
ರೆಕಾರ್ಡ್ಸ್ ಹೇಗೆ ಬೇರೆ ಇರುತ್ತೆ ಎಲ್ಲ ಒಂದೇ ಅಲ್ಲ ಇವ್ರೆ ಸೆಷನ್ಸ್ ಕೇಸ್ ಒಂದೇ ಸೆಷನ್ಸ್ ಕೇಸ್ ಒಂದೇ ರೆಕಾರ್ಡ್ಸ್ ಬೇರೆ ಇರಲ್ಲ.
ಕನ್ನಡ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಸರ್ ಇಂಗ್ಲಿಷ್ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಆಫ್ ಕನ್ನಡ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅವ್ರು ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. ವಿಲ್ ಸೇ ಓನ್ಲಿ ದಟ್ ಮಚ್ ದೆನ್ ವಿಲ್ ಸಿ ಇಫ್ ಯು put up the records of criminal appeal number
445
and that you gave us the copy, no, just now you took it back. Criminal appeal, it's here.
Yes.
Criminal appeal number 445 of 2015. Okay, list on 24/6. If you have an extra copy, please give it to us. ನೀವು ಕೊಟ್ಟಿದ್ದಿಲ್ಲ ಎಲ್ಲೂ ಕಾಣ್ತಾ ಇಲ್ಲ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ.
Keep it with you.
Let it be with us.
Yes.
ಇದನ್ನ ನೋಟ್ಸ್ ಅಲ್ಲಿ ಹಾಕ್ತೀನಿ.
Cell number 27, Reni Sebastian, SPP.
Affair for appellate pilot. Pray for time. Next week comes.
Serial number 27. ಇಲ್ಲ 26 is
urgent morning.
26 ಅದನ್ನು sentence inadequacy of sentence. 27
27 ಮೇಲೆ
you have to furnish the copies translations.
Cancellation.
Appellant's counsel shall
Furnish ಮಾಡ್ತೀವಿ ಸರ್.
the English translation of Kannada documents list on 2 weeks. 2 weeks. ನೋಡೋಣ ಬೆಳೆ ಏನಾದ್ರು ಚೇಂಜ್ ಆದ್ರೆ ಅಷ್ಟೆಲ್ಲ 10 days ಬಿಟ್ಟು
25/6.
ಆಯ್ತು ಮೇಡಮ್.
ಓಲ್ಡ್ ಅಪೀಲ್ಸ್
ಎನಿ ಡೇಟ್ ಮೇಲೆ
25/6.
25/6
Seal number 28 M Shashidhara.
ಶಶಿಧರ್ ನಿಮ್ದು ಏನ್ ಕನ್ನಡ ಏನ್ ಮಾಡೋದು? Appellant's counsel shall submit the same English translation of Kannada documents list on
26/6.
26/6.
Seal number 29 M Shashidhara.
ಅದು ಅವ್ರ ಸೇಮ್
26/6. Seal number 30 urgent. Seal number 31 SPP Chandrasekhar L.
ಯಾರು?
Connected appeal then.
One is your appeal. Javed. He is HCLC ilva? No, for the respondent list on
27.
You can set ಯಾರು ಹಾಕ್ಬೇಕು ನೀವು ಹಾಕ್ಬೇಕು. ಜಾವೇದ್ he has to.
ಅಲ್ಲ ಅದು 30.
Arjun is.
31.
31 SPP
31 and 31.1 is filed by accused my lords.
2018. Yeah, same thing. ಏನ್ ನೀವು ಕೊಡ್ಬೇಕಾಗುತ್ತೆ SPP.
ಅಲ್ಲ 31.1 is also there my lords filed by accused.
ಜಡ್ಜ್ಮೆಂಟ್ ಕನ್ನಡದಲ್ಲಿದೆ ಅದು ನೋಡಿ ತುಮಕೂರದೇನಾ ಅಂತ. ತುಮಕೂರು is a place. The same judge there. This is another judge Davangere. Appellant's counsel ಅದರಲ್ಲಿ connected. Appellant's counsel shall furnish the copy English translation of Kannada documents list on
27/6.
27.
Seal number 32 M Shashidhara SPP.
Same ಅದರಲ್ಲೇನು. We'll see one week if any bench knowing Kannada is constituted then we'll
27/6.
Date
27/6.
26. ಹಾಗಲ್ಲ, see let there be a date because these are the older matters. In case the bench changes by that time you need not furnish. ನೋಡೋಣ 1 week ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ.
Seal number 33 Ravisha MG SPP.
No representation for the appellant agent. We'll do like this.
Seal number 34
I appear for
Dr.
the
JS Harashiki.
appellant 26/6
ಅಲ್ಲ ಇಂಗ್ಲಿಷ್
ಕನ್ನಡ ಜಜ್ಮೆಂಟ್ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಇದೆ.
ಜಜ್ಮೆಂಟ್ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಇದೆ.
ಇಲ್ಲಿ ಇದರಲ್ಲಿ ನಾನು ಐ ವಿಲ್ ಸೀಕ್ ಫಾರ್ ಲೆಸರ್ ಸೆಂಟೆನ್ಸ್.
Lesser sentence. That's all. List on as requested list on. Don't say now copies.
36.
36. Any other some other date. Before that 26/6.
26/6.
26. Great.
Seal number 35 Anil Kumar S BB Patil.
My lord, I appear for the accused number 1 and 2.
Compliance.
It's complaint, my lord.
Complainant. You appear for?
Accused number 1 and 2, my lord.
This number 1 and 2. Where is the complainant?
My lord, complaints affidavit is filed on 14/3/2019. And additional.
19 you have filed. None appears for the complaint. Last time also they have
Last
not
time,
appeared.
many times they have not appeared.
They have not appeared before that also. Due to paucity of time. Anil Kumar for complaint is on, but there is no representation. All along they are not appearing.
Please, my lord.
We'll see what is the non-compliance they are reached.
My lord, the alleged non-compliance is
Writ petition. Oh, this we have seen. This is unwanted here. Taking suitable action, punish willful. Writ appeal number 26. Oh, this chair. It was confirmed by the in the writ appeal. What was the direction? We are
My lord,
accordingly
is-
allowed petitioners are
direction is at
entitled
page
to
number
cost of rupees
34.
50,000 in addition to 50,000 as cost directed to be paid to the writ petitioners in Nagarajappa's case,
Please.
along with interest at 15%.
Please,
And from the date of taking possession of the land,
till the date of payment.
Land versus no. What is your compliance affidavit?
My lord, instead of consent complaints affidavit, your lordship may have additional complaints affidavit. I have explained everything. Filed on 11th April 2023.
11th April 23.
23 months.
Somebody was dead, LR application was filed. 1/3/2023.
11/3/23, my lord. 11th of April 2023.
21/3 is there. 10/4 it was filed on 11/4.
Please, Lord, your lordship may have page number 3 of the complaints affidavit.
Special land acquisition. CI-ADB matter. This is
Please, ma'am.
para 3.
Para 5, page number 3, my lord. I state that the possession of the land was taken on 1/12/2010 and the compensation was paid on 9/3/2011. The copies of the measure is produced as R4, my lord. My lord, the box is payable compensation. Para 6, I have given the details of the survey number, extent and the actual amount of compensation.
Correct. You paid this cost also.
Please, my lord, everything is paid, my lord.
Where is that mentioned?
My lord, I have explained in para number 7.
Para 7.
My lord, the possession taken date,
With the interest at
compensation
15%
paid, total dates of delay,
to the complainant.
amount 15% of interest and below cost is 1 lakh. Totally it comes to 49 lakhs 10,542.
No, you have not specifically mentioned cost.
My lord, cost is mentioned 1 lakh, my lord,
Cost 1
in the
lakh,
bottom.
We can do one thing because now successively they have not come. We'll close it, reserving liberty to them, revive it if there is no compliance.
Please.
You have said no violation. You say there is no violation.
There is no
But
violation.
court has held that. When did you pay this? After filing of this complaint? No, you claim to have paid it in 2010 itself. Complaint is filed in 2018.
18.
No representation for the appellant. I'm sorry, complainant. There is only one complainant, no? You are the KIDB counsel.
Please, my lord, the accused are KDB officers.
Counsel for accused number 1 and 2 submits that the order is complied and the compliance report is filed on additional. Is it additional or 11/4/2023? They have not filed any counter to this.
No, my lord, they have not filed in.
The records show that since then they are not appearing because 2-3 adjournments we saw. This 25. Respondent number 2 is Anil Kumar Ellasapura is present before the court physically. That was on 17/12/2024. After 11/4, what was held about this compliance? Oh, even 30/10/2024, no representation, short accommodation. The records show that consistently the counsel for the complainant is not appearing before the court. Okay. Not even counter is filed to the compliance affidavit. Under circumstances, it appears no purpose will be served by further adjourning this matter. Therefore, reserving liberty to the appellant. There is no compliance. These proceedings are closed.
Please. Obliged.
For arguments, you know who is that advocate? Whether he appears here regularly.
I know him, my lord. I will inform him. Obliged.
For arguments, seal number 24, PB Appaya, N. Vasant Kumar.
They are pending 1999. ಅವ್ರು ಕೇಳಿದ್ರ ನೀವು 1999 ಕಂಪ್ಲೇಂಟ್ ಬಂದು ಭೇಟಿಯಾಗಂತ? Yes.
Finished 710/2017, 8/26/21.
Now this order is being implemented.
Now this order is being.
Then why don't you bury these things?
May it please your lordship.
Why don't you bury these things? They are parents of the.
Let them just
child.
give an undertaking, they will faithfully continue to abide.
What is the age of the child now?
Child is about 16 and a half.
15, 16.
15 and a half.
So just another 3 years for the child to
Let them
attend.
just file an affidavit, they faithfully abide by the order passed by the family court.
What was your defense?
Without the
Is
necessity.
there any allegations of?
Contempt.
No, no. Any allegations of? 1 second. Is there any allegation of any misconduct on his part?
I would not press on those, my lords, because I'm on NOC on this file, my lords. But the accused person, even before I could come on record, my lords, has tendered unconditional apology on all the contempt petitions, my lords. And therefore, when she's ready to tender apology, my understanding is that even in the last occasion with her also, we had a conversation that we are ready to continue to abide by the orders of the Honorable Family Court, my lords. And in fact, in the previous occasion, there was a joint memo was also filed to say that, you know, we're ready. And in fact, if that's this court is directing us, we're ready to file.
Where is that joint memo? When did you file it?
No, it was not filed before the court. It was circulated amongst ourselves.
Ready.
It was only amongst ourselves.
We did not permit you.
No, it's not. My lords, we could not come at a conclusion.
See, even this Contempt of Courts Act says that if apology is tendered, court shall anta ide word adralli. Only thing is it should be bona fide anta ಹೇಳ್ತಾರೆ. So, and they are
not saying do this, do that, give but and hand.
right. See,
My lords, to submit further.
Mother goes to the jail. What would be the trauma of the child? Even assuming that you succeed
We don't
ultimately.
want that to happen. But during the course of the proceedings before the family.
The marriage is dissolved.
55.
Marriage is
55 execution petitions were filed. 55
Why
miscellaneous
she is
petitions for
giving
contempt.
scope? That's why we ask. Sometimes mothers may have some apprehension, like if they are not having good conduct about the safety of the child. He is living with his parents or he is alone?
He lives by himself. He lives with his, he has an extended family that is parents, but there is no issue about that because the child has been going with them to Chennai to their family house.
He is in
for
Chennai.
vacations with them.
He is in Chennai.
No, he lives in Bangalore, but his family lives in Chennai. She goes to the father's
Their marriage
house,
is
they go
dissolved.
together to Chennai
Yes,
for
ma'am.
10-15 days.
When was the marriage dissolved?
Marriage was dissolved by way of decree.
Was it long back?
Marriage is dissolved.
When? About how many years back?
I think 2017.
2016, 9 to 2016.
Whether he has remarried?
No, both of them are not married.
Both. Then see, at least if they are remarried, some apprehension may be there that if the child goes to their stepfather, stepmother, such a person.
In fact, the present situation, my lords, that the child is meeting whenever father wants, and there is no, we are not technically following the orders of the court. Whenever father wants, and in fact, they are regularly in touch with a mobile phone which he is given to the daughter. And most importantly, my lords, very recently, the place where he lives in Electronic City, the complainant, and the complainant has also made a house just next to his house.
Complainant and accused are living.
Right now, they're not. Just last month, she did a housewarming ceremony. It'll be like next door.
Housewarming ceremony. She has purchased a house here.
She has made a house just next to his house.
Where she is?
Right now, she resides somewhere near Marathalli because of her.
Both of them are in Bangalore.
Both of them are Bangalore, settled in Bangalore, but originally from Tamil Nadu.
What is the occupation of both of them?
Software.
He's a self-employed businessman. He has a software industry.
What is his qualification?
BTech.
Software engineer or any mechanical or?
We are made more into hardware is what I understand.
Mechanical. What she is doing?
She's also a software engineer, my lords.
We are seeing hardware only in the software persons. Malwares, hardwares, etc. Why can't both of you advise them? Whether they listen to you? Whether they listen to you? Both of
She will listen to me, my lords. I've explained.
you. Then Mr. Appaya, whether your client will listen to you?
I try to listen to him, certainly.
So we can do one thing.
I will show
If
you.
at all there is any, breach in future, with liberty to you to revive this, we can close this with some of the understanding that they will abide
Yes,
by.
my lords. The only
this
condition
area
from
which has
the
standard apology of-
accused side is that there is one property which was jointly held prior to the conclusion of divorce at the family court, my lords. In the mediation center, he agrees to release that property and in her favor, in the favor of the accused. While that has been held, although she cleared the bank loan, the property papers are with the HDFC Bank and it is attracting charges since it is pending from 2016, my lords. That's one thing. And apart from that, the school
Property
fees,
stands in whose name? In her name?
that has been released, but the property papers are with the HDFC Bank, for which the HDFC Bank is
And he
clearly.
has to go and sign.
Yes, my lords.
These are small things.
This is what I mentioned.
Do you keep the
Every
parties
time an
present?
apology
Do
is
you,
tendered,
do you
it is
keep,
subject to conditions.
No, my lords, it is not subject to conditions, sir.
do you keep
Only
the
see
par-
that once it is closed here, we don't come back to here again.
One thing. We are asking both of you, advise both your parties. If they are self-sufficient, even if one party takes little more, to forego that, because life is not
Yes, my lords.
certain. So at least they can live peacefully by that. And if really property stands in her name and the records are with the bank, only for the release your client's signature is required, then any other litigations are pending between the parties?
Apart from this, my lords, there are three other petitions before the magistrate court for under section 499 of IPC, and one civil suit in the
For property.
property for which she was constructing. He filed a civil suit, and another MFA before this honorable court.
MFA?
MFA is against the family court, my lord, with great respect. Interim order for visitation given to me was every Saturday between.
In
11 o'clock
execution
and
that
4
is
o'clock.
modified, that's what your contention. In execution it is modified, it is.
No, not an execution. Interim order of visitation given to me Saturday 11 o'clock to 4 o'clock. Full scale trial is conducted of the main petition. She comes and gives evidence, does not come for cross-examination, which means her evidence should have been discarded. The learned family court judge truncates that 11 Saturday 11 to 4.
So you have challenged this G&W order.
Yes.
The one which.
The GWC, the final judgment is Sunday 1 o'clock to 3 o'clock. Interim order is Saturday 11 to 4.
Child is studying in which
Final
class?
judgment
Child is studying in which class now?
must be the 10th.
10th standard. 10th standard.
10th standard. See, now these 3 years are crucial for the children,
Yes,
10th to 12th. Then why, at least a little of it goes in the mind of the child.
In fact, when my MFA came up for admission with great respect, I made a submission. After trial, if you're going to give me less than what you gave me for interim order on affidavit, why make me wait for 7 years? I filed a petition, the wife could appear.
No, whether matter was referred at any time. Matter was referred at any time. Mediation, whether matter was referred to mediation?
It was earlier referred by this honorable court.
Pending this case?
Yes, my lord.
May I request the subject, let them just simply file a simple affidavit in these 3 matters, undertake to abide by the final order of the family court, close these 3 matters at least.
Yes, my lord. I'll file. I'll file.
Let them finish whatever those other matters are, let it be whatever.
Even other matters
So let us
also.
close these 3 matters, otherwise we keep on coming. And your lordship on one occasion said, your lordship's predecessor said, I'm trying to avoid the bench because the matter was not reaching or not being heard. Why all that? Let us finish these 3 matters and close it.
Right, that's why we are seeing many old matters in contempt also. So,
My lord,
and in this case, it is not any commercial transaction or anything. So, only, even assuming that you succeed and mother is sent to the jail, that is a trauma for the child also.
Let us simply file 3 affidavits, abide by the orders passed by the family court, close the chapter. Let them be left to their own devices for everything else.
On interaction with both the council, you are for 615, 710, serial number is 24. 24. Because the government is not there, no? An interaction with both council about any possible settlement Law counsel for the complaint submits that if an affidavit is filed by the respondent undertaking to abide by the trial court's order
Yes.
regarding the custody matters, the complaints can be closed. Law counsel for the accused submits that the accused is ready to file such affidavit. She has already filed, it seems.
Apology she's filed, unconditional apology she's filed on all the three matters, my lords.
She is permitted to file such affidavit. Huh?
Regarding visitation matters, custodians have to be decided.
No, custody. Trial court's order, we said. That trial court judgment is, so we'll say orders in question. They're all interim orders, no?
No. 826, 827 is against the final judgment.
826, 827.
710 was against.
But again, that is in appeal, you said? Final order is in appeal?
Final order is in appeal, but there's no modifications.
Only you have preferred appeal or she also has preferred appeal?
No.
About visitation, you have not preferred?
No, we have not preferred any appeal, my lords. In fact, he is visiting the child more than.
My client had a physical disability. The learned family court judge has said, father has this physical disability, how can he look after the child? What observation by the family court?
What is that physical disability?
He has a slight limp because of some childhood polio or something. Family court judge making an observation. He has a limp, how can
That
he
is
look after
correct.
the child?
Learned counsel for the complaint submits that if the respondent accused files an affidavit undertaking to abide by the orders in question and the orders in question, complaint is prepared to is agreeable for dropping the proceedings. Learned counsel for accused submits that respondent is ready to file the. You are submitting on instructions, no?
Yes, my lords.
Respondent is ready to submit such an affidavit. Okay. Therefore, list on. Wait 2 weeks. Wait 2 weeks. If they are going to close,
2
why
weeks,
2 weeks?
2 weeks.
2
I'll
weeks
file.
you want?
No, she constantly works and I have to find out if she can apply leave. I'll keep her present and file it in the open court, my lords.
10 days on
26/6.
Published.
Close, bury them as much as
Yes, ma'am.
early
We
as
will, we will.
possible.
We don't want your lordship to spend too much time.
No, not because there is no issue for we spending, but these are not the commercial disputes. These are a minor child is involved. Why these things should go on happening? And ask your client also, because if there is no allegations of misconduct or any moral turpitude, then they have to abide by this
Yes.
order until because she has not challenged that order.
Yes, she is not challenged.
Nothing.